All right, we're back. I appreciate how important this issue is to many, many people, and that people are quite passionate about it. And for some people, it is very easily distilled into black or white. It's the right to life. It's a woman's right to choose. But as many of you in this room know, it's more complicated than that. There are a lot of complicated legal issues, and we have very, very good lawyers on both sides who are going to present those issues and some facts connected to them. If while you're in here, you find that it is hard to be a dispassionate observer of the proceedings, I'd ask that you step outside until you can be dispassionate again. If there is any disruption, Deputy Gordon has been instructed, not by me, but by the sheriff, to make sure that the disruptor stays outside for the rest of the proceedings. I trust that's not going to be an issue, but we had virtual issues last time, and I would hate for those to infect any of the in-person proceedings. It is not a problem if anyone here, to include the many lawyers, as long as there is at least one lawyer from each side, for people to take breaks. We are going to have 2 long days, and we will move quickly and break infrequently and briefly when we break. But it is not a forced march. So if anyone needs to step outside, I can keep going as long as there is one lawyer at the bench, at the table for each side. We will break for lunch, I promise, but it'll probably be a truncated lunch. I also want to thank both sides for their Herculean efforts. I set an aggressive schedule because this is an issue that needs attention now and not in 3 months. It probably needed attention 3 months ago, but here we are. And I appreciate that both sides are very busy, that there is a whole lot in particular on the Solicitor General's plate. I'm not unmindful of that, but this is one of the most important things on his plate. And I appreciate that he has brought in additional resources so that we can move forward today and tomorrow. So thank you, both sides, for working hard on this and being ready to go. What we had discussed in a pretrial conference is that we would spend some time first to give both sides a little bit to address arguments on the state's motion to dismiss, as well as plaintiff's partial motion for judgment on the pleadings. And I'm happy to continue to do that. That's time away from the trial, but it's still time well spent. I do feel like the issues raised in particular on the motion for judgment on the pleadings have been discussed before, and not all of them, but discussed before and very, very thoroughly briefed. And I flag that only to say it may be that the two sides want to spend a little less time with oral argument on that and rely more on their pleadings. But I'm not going back on my commitment to give you all about an hour across those two motions before we pivot to the trial itself. So what I'm going to do first is have both sides introduce their lawyers who are going to have speaking roles today. And then I will hear from one lawyer on each side as to what the plan is for those two motions before we get on into the trial. And I'll have my little countdown timer ready when it's time. So let's start first with counsel for plaintiff.
Good morning, Your Honor.
Good morning.
Julia from Kaplan Cobb. I'm here with a lot of people who might be speaking today. So I've got Julia Kay from the ACLU. She'll be handling the argument portion of it. Tiana Middlevet from Bondurant. And then in the next row, we've got Joanna Zacharias from the ACLU, Rebecca Chan from the ACLU, and Alice Wayne from the Centers for Reproductive Rights. And
at different times, different of these many lawyers may be involved with what's going on.
Yes,
okay.
Depending on the order of witnesses and how that all plays out.
Got it. Okay. Write all that down. Great. And Mr. Petrani, good morning, sir.
Good morning, Your Honor. Stephen Petrani from the state, of course. I'm going to be handling the motions argument at the beginning. Then I'm going to let my co-counsel introduce themselves for who's going to be talking throughout the day. I think there's some question as to who might be, depending on the witnesses, of course, but I'll let them address that.
Sure.
I'm Gene Scher, and with me here is Chris Bartolomucci and Brian Field and Ed Trent.
Ed Trent is defendants exhibits.
No,
Oh, no, back, further back. Okay. All right. I thought I might link a name to the, okay.
You can just call him Mr.
Mr. All right, DE, defensive end. All right, great. And I want to be clear, it is not an issue for people to be handing rolls off. I just wanted to have some names to associate with faces, but if Mr. Bartolomucci is handling one witness and then Mr. Field is that's all good. I just wanted to know who all was here and who might be doing things. And it will help stenographer April know who is doing what. So Ms. Stone, has anything changed from plaintiff's perspective as to how we're going to start out today?
I don't believe so.
Okay. Same, Mr. Petrani? Okay. And I can't remember if we said, let's do motion to dismiss first, or the MJOP. I'm fine with either. And were we going to try to spend about a half hour on each, or had you discussed how we're allocating that? And I want to be clear, I'm not going to say sit down, time is up. I'm trying to give you some framework so that you maximize the remaining time through end of today and all of tomorrow for the trial piece.
I think we're open to whatever your honor's preference is. I do think the state filed their motion to dismiss before our motion for judgment on the pleading, so I kind of expected that one to come up first, but
Okay.
we're happy to do it, whatever your preference is.
Got it. We'll do first in, first up. Last thing before we begin with the state's argument on its motion to dismiss. As we discussed in our pretrial conference, because of the complexity of the issues and the volume of material that we will all be consuming from a very, very powerful fire hose, this is not the kind of trial where at the end of business tomorrow, I'll be announcing the verdict, guilty, not guilty. Of course, it's not a criminal trial, but the two sides have asked to brief things, and the briefing schedule extends beyond November 8th. So I will not be in a position to rule on any of the many issues that have been presented and will be presented until after both sides have had a chance to brief. And we've agreed that some of the briefing will substitute to a certain extent for some of the examination that might have occurred during the course of a longer trial. So with that, Mr. Petrani, why don't you, and podium is all yours. Also, if folks for whatever reason are more comfortable being at the council table, if you're talking into a microphone with a green light on it, then the court reporter can hear you.
Thank you, Your Honor. I'm of course happy to talk about the void ab initio argument. Our motion to dismiss on that issue is essentially the mirror of the motion for judgment on pleadings. One of us is right, one of us is wrong. Of course, we believe that we're right. I don't want to spend too much time on it, given that, as Your Honor mentioned, we already discussed it a couple months ago. There's been a lot of briefing on it. The only thing I think it's worth adding at this point is, I think that in plaintiff's reply brief, they really made stark the distinction between our positions. On page 11 of their brief, they admit that under their theory, if Georgia were to enact prior to Brown versus Board of Education some, segregation sort of rule, it would not be void ab initio because the court had not ruled on Brown. That is just not the way constitutional law works. It was unconstitutional when it would have been enacted because the Constitution says that it's unconstitutional, not because you have to wait for the Supreme Court to give its opinion. There is the law, and then there are courts' opinions as to the law. And of course, the parties are bound to follow the court's judgments. But when it comes to its opinions, legislatures and everybody else can disagree, and they can fulfill their constitutional laws differently. And they are not bound to avoid legislating in that area until the court undoes its rule. In fact, it's not clear how they could ever undo that rule if legislatures like the General Assembly are precluded from even passing a statute that would conflict with it. But I want to turn to essentially the substantive issue here. And while I agree with Your Honor, this is an important case, I have to disagree that it's complicated. There is no right to abortion under Georgia's Constitution. There's nothing that even hints at a right to abortion under Georgia's Constitution.
So I agree. If you were to have a text of the Georgia Constitution and did a text search for the word abortion, it's not in there. there are a lot of words that aren't in there that are pretty firmly protected by the way due process, right to privacy, et cetera, have been defined by Georgia courts. So tell me why I know you didn't mean simply because the word's not in there, the protection's not there. But of course, the analysis isn't that easy to simply look in the Constitution, and it doesn't say gun in there. So how do we work through firearm rights? It doesn't say abortion, but there is a right to privacy. And maybe you were going there, but
Yeah, Your Honor.
it's
So the right to privacy under Georgia law started in Passage in 1905, and that was very clearly a right to actual privacy, as that term is more colloquially understood, which is to say, my private affairs should not be exposed to the public. What plaintiffs are asking for is a much stronger and different version of privacy, which is not, I don't want my private affairs exposed to the public. It's what I do in private cannot be criminalized or cannot be prohibited. And the Georgia Supreme Court has only once in history issued a decision to that effect, saying that some conduct done in private cannot even be prohibited. And that was the absolute high watermark of privacy rights, and it doesn't even come close to reaching the conduct that we're talking about here.
this is
So
Powell.
Powell, where the Supreme Court said that adult, consensual, non-commercial, intimate sexual behavior done in private is protected by Georgia's right to privacy. But there are a number of things here to point out. The first is how many caveats the court put on that, and in fact made very clear if any single one of those things is missing, it's not protected by the right to privacy. So if it's commercial, if it's non-consensual, if it's not between adults, people who can't legally consent, I mean, then we're all of a sudden out of the right to privacy. And one of the reasons that this was so easy for them to put all these caveats in there is that from the time of Passage, it's been exceedingly clear that the right to privacy, such as it is, only extends so far as you are not affecting anyone else. And so what the court in Powell said was, this is private because no one whose intellect is in a normal functioning condition would think that this is affecting someone else. It's just two adults in the privacy of their own home.
It's affecting someone else, but not adversely. I mean, it's two people, so it
Yeah,
is other affecting, but in a way because it's consensual, non-commercial, et cetera.
Exactly. If it's not consensual, it is affecting someone else, and then all of a sudden privacy does not apply. Same thing with commerciality and so forth. And so here we think that that's just the ballgame. There is a third party involved. And the legislature found that there is another person involved and wants to protect that other person. And I think the key point at the motion to dismiss stage is, first of all, plaintiffs don't even really challenge that. If you look at their briefs and their complaints, they actually very carefully avoid really disagreeing with that. What they say is, well, you know, this new developing human is not fully developed, is still dependent on the mother. And that's true, we don't disagree with that. But we disagree that merely being developing or being dependent on others has anything to do with this. Another point would be that even if there were even if the plaintiffs did for some reason think that a 6-week-old or an 8-week-old or a 10-week-old embryo or fetus was not a individual human being worth protecting, the legislature just gets to make that choice. There's nothing, plaintiffs have pointed to nothing to say that the General Assembly cannot find this is in fact a unique individual unborn child worth protecting. I understand plaintiffs disagree with this to some extent. They disagree as to the moral value and so forth. These are all judgments that the legislature gets to make. And the argument from privacy assumes in all of their briefing, plaintiffs skip past whether this is private at all. They immediately go to, well, you have to establish some kind of interest or whatever. And I want to talk about that too. But the first step, and this was very clear in Powell, is that you have to decide whether there's some sort of privacy right implicated here in the first place. And the one thing, there are a lot of reasons why a privacy right might not be implicated, but the one that is absolutely clear is if it's affecting some third party. And that's what the General Assembly decided was this is affecting a third party, and we want to protect that third party. And to us, that's really just the end of the case.
So you don't think it's balancing. You think that there's nothing to balance because the decision to terminate a pregnancy, whatever phrase we want to use during these proceedings, because it clearly adversely affects what the legislature has defined as another life, then there is no privacy right, or it's just that the privacy right, that the balancing would come out, your argument, in favor of saving a life versus whatever, and we're going to hear a lot about it, the burdens or implications or concerns are for what would be pretty private about what's going on inside someone in their personal life and literally within their body. Are you saying it's just not a privacy right issue because it's other affecting, or?
Yes, you're right. Yes, so both. I mean, we have arguments on the alternative that even if some sort of privacy right attached, this law would still be valid. And as I said, I do want to address that. But no, the first step is there a privacy right at all? And what the Supreme Court of Georgia has been clear, and essentially, I mean, there are essentially 4 cases, right? It's Pavicic, Zant, McAfee, and Power. In all of those cases, the court was absolutely clear that no one else is being affected by this. There's no third party being affected. And once that happens, we're no longer in privacy. And that's the first question to answer. You don't immediately jump to, well, what if there was a right to privacy here? Because first you have to decide, do I need to do this analysis at all? Now I do want to address the second point, which is, okay, let's assume for the sake of argument, and we disagree, of course, that there is a right to privacy that somehow affects this. Even there, I think that the law is clearly valid. I think there are two key points here. But the first is, plaintiffs assume that some sort of compelling interest standard applies, but actually, if you read Powell, it just says it needs to be have a public purpose that's not unduly aggressive of the individual. That really isn't a compelling interest standard. It's kind of, if you look at the cases, it's kind of a rational basis plus standard, a little more than a rational basis, but not an immense amount more. But even going a step beyond that, we do think that even if we had to show some sort of compelling interest that was narrowly tailored, that we would, because these are unborn children that the state wants to protect, and there is no way of protecting them except to keep people from aborting them, essentially. And the arguments from the other side are basically that, well, you could do it in a less restrictive means by not prohibiting it at heartbeat. You can prohibit it at 15 weeks or 20 weeks or whatever, but that just misses the point of narrow tailoring. You're not vindicating the state's interest if you allow a lot of abortions the state does not want to allow, but just stop some at the back end. You have to actually stop the abortions that the state is trying to stop. And so we think that even if you get into it with some sort of a balancing test, the state clearly is still clear it has a valid law. But I also think that even trying to do that sort of a thing in this circumstance, I think shows why it's just not really, with all due respect, the judiciary's job to be making that determination, and why there is no privacy right here to begin with. I mean, these are essentially incommensurable values. The value of an unborn child versus, the concerns of the mother or the family or whatever else might be involved.
It's a little more than that. It's bodily autonomy. It's what I say. The mother who would be required to carry this child to term if the mother had been raped but chose not to tell the police about it because the person who raped the mother was her stepfather, who said, "I will beat your mother senseless if you talk to the police about it." So now, under the current law, this young lady can't abort, even though it was a rape, because she chooses not to go to she doesn't choose, she is coerced not to go to the police. And so it's not just, well, what are the family concerns? It's how does it change this person physically and emotionally and the rest of her life, because she's 14.
Well, so Your Honor, when I say interest, I meant that broadly. I wasn't trying to minimize anyone's concerns, but I think.
But oughtn't that be weighed? I'm not accusing you of minimizing. You are a deep thinker about this. And so when I'm probing, it's to help me better understand it, because I know you don't want courts weighing things. That's not what they should be. It's the legislature. Let the legislature weigh. We're asked to weigh things all the time. I'm not so sure that the right to privacy doesn't exist once something is other affecting, but it clearly is not all controlling. That's the law in probably all 50 states, but certainly in Georgia. It is no longer all controlling. It's what these cases say. But I don't know that the scale, if we're weighing things, goes to zero on the other side, because the act that the then mother would want to take would be other affecting.
So Your Honor, of course, that is our first argument, and I disagree. I think that if you look at these 4 cases, the Supreme Court is very clear that once it's other affecting, there is no right to privacy at that point. But even if we take a step past that, there's no doubt that the scenario that Your Honor lays out is a heart-wrenching one. And what the best way of going about resolving that is, I think is certainly something that the legislature took into account. So I think that that's why they came up with the rule that they did. I think that even if the court thought that in these extreme scenarios, there was some sort of constitutional problem, and again, we don't think there is, but even if, that's not talking about the 98% of cases. And plaintiffs are filing a facial challenge. So if they have an issue with some very narrow circumstance, that might be something to deal with on a case-by-case basis, but that's not what we're talking about when we're talking about a facial challenge. I also, point out that in most of these scenarios, there's this assumption that, well, an abortion would just solve everything. That sounds like a pretty horrific scenario to me, where an abortion does not solve it. And so I think that it's very plausible that the legislature would look at it and say, look, we just don't think abortion is the way to solve the problems in this area. I mean, if you have that kind of abusive, terrible situation, there are ways to go about legislating, providing support, police, investigations, et cetera, that will actually help with these things. But we, the legislature, don't think that abortion is really the way to solve these particular points. But again, whether or not the legislature is correct on any given circumstance, the legal point is that because this affects another, privacy right doesn't apply in the first place. But even if we get past that and say, okay, we're going to apply it anyway, we're in a scenario where the vast, vast majority of these cases are elective abortions that don't involve these kind of horrific facts that do, of course, make everyone sympathetic to basically every non-culpable party involved. And if you're going to challenge something facially, as opposed to as applied, you really can't focus, as I think the plaintiffs really have done in the briefing, on all of the edge scenarios. And so I think that's one point. Another thing about some of these edge scenarios, by the way, is again, we don't think they really matter here because this is a facial challenge, but we also think that plaintiffs are just wrong about some of them. So the most obvious one is plaintiffs try to assert that under the law would be difficult for women to get miscarriage care or something like this. And we think that's just a plain misreading of the law.
Okay, I thought that folks had sort of on the sidelines sorted that out. I'll let plaintiffs respond to that, but as I was reviewing the many pleadings, that seems to have been a position that plaintiffs have stepped back from a bit from the language. I'm not committing them to that. I may have misread it. I want to be very clear, and they may want to come back full force on that, but that's not how I read the statute. And that might not be the edge scenario they're going to focus on quite as much.
If that's the case, Your Honor, I don't need to belabor the point. I just wanted to make clear to everyone involved, anyone who happens to be watching this, if you are experiencing miscarriage, go get care. There's going to be nothing stopping you from getting care in this act. But just to get more back to the kind of the more general point, even if there was some problematic scenario, in a facial challenge, you have to show that in all, or at least essentially all applications, it's invalid. And so looking at these edge cases really doesn't help with that in any way, shape, or form. And so I think that would be our kind of final point. And on top of there is no right to begin with here. Even if there's some sort of right, and at edge cases it might apply, it's not the sort of broad, essentially Roe Casey redux that would invalidate this law. It might have something to say on edge cases, which can be litigated, on a case-by-case basis. And then finally, just very quickly on the record-keeping provisions, Your Honor. A couple of points on this. One is, this has been around for 50 years. This is not a new thing.
So that I'm following you, the record keeping that the medical providers need to provide things to the district attorney's office, or that they may, okay.
Yes, Your Honor. So that portion of the statute has been there for almost 50 years. The only difference in the Life Act is that I believe they changed it from which district attorneys can request records. On that particular point.
So it could be that it's been unconstitutional for 50 years.
Yeah, I mean, this is not an argument. This is not an argument that it must be valid because it's been around a while. The point is just it's been around a long time. No one seems to have pointed to any particular problems with it. And the main point I want to make on this is, as plaintiffs themselves recognize, there's no enforcement mechanism. And so they cite in their briefs, and I think this is correct, that what a DA would have to do is subpoena the records. And of course, once you have a subpoena involved, you can go to court and quash that subpoena. You can make all the arguments that they're trying to make here, except make them with actual facts in an actual case, where we can actually, apply the law to something less abstract than, well, might there be certain circumstances where this is unconstitutional? And I think that's particularly important here, where plaintiffs are trying to essentially assert privacy rights of people who are not before the court. And even if we assume for the moment that they have standing to do that, it just seems like a very bad idea to say, I'm going to facially invalidate this law based on the privacy rights of people who might actually not like this. They might want DAs to be able to get these records, and there's no privacy problem at all, and this is totally constitutional as applied in that case. And so, although we do,
how would person X know that person X's medical information, intimate, detailed medical information, is being disclosed to the DA of County Y? Let's say a subpoena was used. So Hospital Z gets the subpoena. They choose not to fight it. That would be a natural, I want to quash this. I'm not HIPAA, all sorts of reasons. The hospital, I'm not disclosing it. But I'm patient X. I don't know that a subpoena has been dropped on the hospital. I didn't know the hospital was going to share the details of a procedure that I don't want anyone to know about with the district attorney, someone I didn't vote for and I don't like, or whatever the situation might be. How does someone get to stand up and say, wait a minute, I want to invoke my privacy rights to my medical information that is being handed over just on it's a subpoena. It's not even particularized. The DA presumably would say, give me every abortion that you did, Hospital Z.
Yeah, so Your Honor, I think in any given case, I'm not necessarily sure. I mean, to be entirely honest, I'm not sure. That's kind of part of the reason I think a facial challenge is a problem. I think most of the time, medical providers are going to say, whoa, hold on, we're not just handing out medical information without at least contesting this or letting someone know and so forth. But I don't think that plaintiffs here are in any better position to kind of speak for those people than the hospital would be or the clinic would be. So I don't doubt there are some kind of weird issues around this. It's a statute that, as far as I can tell, hasn't been used very much. And so there isn't much kind of explication of it. But this is the kind of thing. This is a point. Like facially, validating a statute where there are clearly going to be valid applications, and where there is nothing in front of the court now that would be any different than when a DA actually requests something like this, and the hospital could contest at that point. It just seems to me like even if plaintiffs have standing in the constitutional sense, it would be highly imprudent to try to decide this issue across the board on what is essentially speculative concerns. We don't really know how this is going to operate in practice, and we don't know whether patients are going to want or not want their information to be provided. It could all be anonymized or things like this. I mean, that might be the kind of request that the DA is making.
But it's not required. A DA could say, give me all the gory details.
Yeah, I mean, while I do think it's relatively limited. I think it has to be just about abortion, given its place in the statute and so forth. But again, this is something where I think we actually do acknowledge that there might be certain people in certain circumstances who this could be a problem for. Don't know what those circumstances would necessarily be.
And they're not before us.
But it's certainly not every person in every circumstance in a way that would make sense and go out and decide this way ahead of time for all cases for all time. So that would be my final point there. I'm of course happy to answer any other questions Your Honor has. Otherwise, I can sit down and we can move forward.
All right. If I have more questions, I'll send them your way. Thank you. Ms. Kay.
Good morning, Your Honor.
Good morning. So, Mr. Petrani, 90%, 95% was about motion to dismiss. It was a little bit about void ab initio. I assume you're going to focus just on motion to dismiss, or are we sort of covering both right now?
So my intention, Your Honor, was to begin with the state's motion to dismiss, and then I can either pause and give Mr. Petrani a chance to respond, or I can go directly into void ab initio.
We'll do the latter.
All right, thank you. So Your Honor, first, just as a preliminary matter, the state filed its motion to dismiss 3 days after filing its answer. That's a violation of 9/11-12B and would be an independent basis to deny the motion.
How is it meaning it was too soon or too late?
Without time, it's late.
Okay.
A motion raising defenses, including failure to state a claim, has to be raised before or at the time of the answer. And as Your Honor noted in the order denying the motion to cancel the trial, it was untimely. But let me focus on what we're really
The substance.
about, yes.
All right.
The question is whether forced pregnancy infringes Georgians' fundamental right to privacy under the state constitution. And there are really two pieces.
Is there a difference between right to privacy and fundamental right to privacy?
I'm using the language of the case law, Your Honor.
Okay. But I just want to make sure, I mean, it is a fundamental right, no question. I just wasn't sure if you were distinguishing that from, the plain old right to privacy. It is the right to privacy, which is fundamental. Okay.
So there are really two pieces to this question drawn from the case law. The first half is, would a reasonable person think that forcing someone against their will to go through pregnancy, labor, delivery, and in most cases, a lifetime of parenthood, interferes with Georgians' rights to be let alone and to the uninterrupted enjoyment of their life, body, and health?
I'm not familiar with the reasonable person test.
That language is in Powell, and it's actually, Mr. Petrani alluded to it as well. The court was questioning, is this what most people would view as something that falls within the area protected by the right to privacy?
Okay. So I know I'm interrupting you a lot, but I want to just understand the questions I had, and you'll be able to cover everything else you want to cover. Viewed through the lens of the mother, very reasonable question. And you laid out all of the implications, not consequences, they are consequences, but implications of carrying a child to term and then likely, very, very likely raising that child, whether you're age 13 or 33 or whatever. Viewed through the lens of the person that the legislature has deemed exists once a fetal heartbeat is heard, the answer there is you're killed. How do you balance those two?
So that's actually the second half of the question. And again, I'm tracking the language of the precedent, which starts with, is this within the sphere of the privacy right? And then gets to the question of, is there a neighbor's rights?
Got it.
This is starting to impede upon.
We're in the sphere.
So I'm starting that we're in this sphere. And let me just pause there and say, this is an easy question. First of all, for purposes of the motion, the allegations in plaintiff's complaint must be taken as true, and we detail how profoundly intrusive and medically dangerous it is to force pregnancy and childbirth upon someone. When Pavicic found that even the unauthorized taking of a picture of your body is a violation of the right to privacy, it is inconceivable that an intrusion of this magnitude, that forced pregnancy and childbirth, is not implicating the right, is not within the sphere of privacy, implicating the right to be let alone and uninterrupted enjoyment of your life, body, and health.
So it's interesting. You would call almost another way to look at it is Pavicic is sort of the high watermark of privacy. It's a violation of your privacy just for someone to take a picture of you. And here we're talking about all the other things you've described, which are clearly far more invasive and intrusive and life-altering than someone taking a picture. So if you are protected from someone taking a picture of you you don't authorize, certainly you are protected by the right to privacy from the many, many things that you've detailed.
Yes, exactly, Your Honor. Although I take issue with the state's discussion of the high watermark of Georgia's constitutional right to privacy. Georgia has a rich, a storied history of pioneering the right to privacy, and that is a thread that has been present throughout the case law for over a century.
You say that, but there really are just so few cases. When Mr. Petrani ticked off the 4 cases, like, yep, those are the 4 I'm aware of. And I assume if there were 100 others, you guys are very good with appendices and footnotes. And I didn't get that footnote of the 128 cases from the Georgia Supreme Court creating that rich body of right to privacy law.
Yes, Your Honor, but I'm quoting virtually verbatim from Powell. Since Pavicic, the Georgia courts have developed a rich appellate jurisprudence in the right of privacy, which recognizes the right of privacy as a fundamental constitutional right.
It always sounds good when judges write it. It doesn't always mean it's so, but got it.
But so let me turn to the second question, which is really where the dispute is. The state argues that it doesn't matter how grave of an intrusion this is. Once there is a fertilized egg, in the words of the state, that's the ballgame. You don't do any balancing. That means that the state has a free pass to impose this tremendous intrusion onto Georgians' lives, bodies, and health without having to show that what it is doing, that the particular means of serving its compelling interest is the least restricted means of doing so. Based on the allegations in the complaint and Georgia Supreme Court precedent, that is simply wrong. Now, the state relies on Pavicic's language that my privacy rights end where my neighbor's rights begin. This language about neighbor. And Pavicic and Powell both refer to other individuals as being the outer limits of the privacy right, and Zant uses the phrase third party. So let me just start with the allegations in the complaint, paragraphs 59 to 62, which talk about the process of a pregnancy developing. And what is clear is that for at least the first 5 months of pregnancy, the zygote and then embryo and then fetus is entirely subsumed by, attached to, and dependent on the pregnant person's body and could not survive outside the womb, even with the best medical devices you could imagine. That is very far from a neighbor, just focusing for now on the allegations.
So, okay, so you're working through the allegations, but just back to the law, because I think even some of the defense experts would agree with that science that you've described. I hope most of them would, but that's not what the legislature has said. And so where is it that the legislature is impermissibly overstepping its bounds to say, science is fascinating, but the earth isn't as round as you think. Life begins at fertilization or fetal heartbeat. And once you're there, that's the equivalent of a walking, talking, voting, majority age individual, and you may not impinge on that person's rights. And that 6-week-old fetus that looks more like a little reptile curled up enjoys the full panoply of rights that you and I, you're not a Georgian, but that your colleagues and I enjoy as Georgian citizens.
Your Honor, the legislature does not get to dictate the meaning of the Constitution. That is crystal clear in the in-rate judicial qualifications. So the legislature's determination that a fertilized egg is a person that should have equal status under the law as the pregnant woman carrying that fertilized egg is irrelevant to this stage of the constitutional question. The state's interests in protecting a zygote or an embryo or a fetus, absolutely part of the analysis, but it comes later. Right now, we're just establishing, is the right to privacy of the Georgia Constitution infringed? And is a fertilized egg, does that rise to the level of a neighbor under the Georgia Supreme Court's precedent?
And it's that last piece that I want you to focus on, because I think for purposes of a motion to dismiss, you clear by 100 yards the hurdle of, is there a right to privacy? Is it infringed by requiring a woman to carry to term the pregnancy? Where I think the legal, for me right now, the legal struggle is, well, what about that other person, fetus? And the legislature has said, treat it as a person for purposes of the legislation that was passed. So that's where I'm wrestling right now.
Absolutely, Your Honor. And I just want to underscore again that this, as the state is framing it, the first half of this inquiry is black and white. In the state's telling, as soon as there is a fertilized egg, that nullifies the pregnant person's rights. And in our understanding of the precedent, the first question is whether the right to privacy is implicated, and then you get to the balancing once you're applying strict scrutiny. So let me turn to the case law that guides the court's understanding here. So the language of a third party being the outer limits of the right to privacy comes from Zant, and Zant cites to Jefferson for this point. So Jefferson is central and very instructive, and it indicates that viability is the key milestone when the interests of the fetus may override the constitutional freedoms of the pregnant person. Nothing in precedent suggests that as soon as a woman becomes pregnant, that her rights disappear. So let me focus on Jefferson. Jefferson involved a Jehovah's Witness who was in her 39th week of pregnancy, full-term pregnancy, 39 weeks. And because of her religion, she objected to undergoing a C-section delivery. There was no dispute that if she did not undergo the C-section, there was a virtually 100% chance that this full-term fetus would not survive. And there was a 50% chance that she herself would die. And so the hospital went to court to say, can we force this woman to go through the C-section delivery to save really both her life and the life of the fetus? And the court recited the fact findings of the trial court, the Supreme Court recited the fact findings of the trial court, which emphasized repeatedly that this was a 39th week pregnancy. This was well beyond the point of viability and the point of being able to survive outside the pregnant woman's body. And then critically, in holding that the hospital could require this surgery, the Supreme Court cited to three cases. First, the court cited to Roe v. Wade, which of course held that up to the point of viability, you could not override a pregnant woman's right to privacy, but after that you could do so, although there had to be an exception for her health. It cited to a case out of the New Jersey Supreme Court, which emphasizes in the very first paragraph that it was a similar fact pattern that emphasized in the very first paragraph that the pregnancy was in its 32nd week. And it cited to a case involving a medical dispute between adults. So you look at the cases that the Supreme Court was relying on, and you have to draw from that viability or something closer to the very end of pregnancy, that is the critical point when the balance of interest might shift. So when Zant talks about a third party and cites to Jefferson, there is nothing in Georgia precedent that would suggest that a fertilized egg or an embryo at 6 weeks is that neighbor or is that third party. Now,
So you are relying on Zant's reference to Jefferson, Jefferson's emphasis on viability as the constitutional interpretation and application that would be the higher court saying, here is where the other affecting nature of a private action starts to be weighed and not earlier. And because that is constitutional interpretation and application, it's fascinating that the legislature said what it says, but the legislature doesn't define what the Constitution means.
exactly.
Okay.
Exactly, and I would also point the court to the fact that Powell relies on Campbell v. Sundquist, which is a decision out of Tennessee that reaffirmed a fundamental privacy right under Tennessee's constitution not to procreate, and permitted someone to destroy frozen embryos so that he would not be forced to become a father against his will. There is nothing in Georgia's rich history of the right to privacy that would suggest that Georgia's constitution is any less protected. Now, I'd like to turn to the application of strict scrutiny. And first, I just want to make clear that once the right to privacy is implicated, it is the state's burden to show that its intrusion furthers a compelling interest through the least restrictive means. And if the state cannot do so, the law is facially unconstitutional.
So two things on that. One, what are your thoughts about the rational basis plus rather than strict scrutiny? In the language of Powell that Mr. Petrani was talking about, do you think that he was mischaracterizing, and I don't mean that in a pejorative way, but his interpretation of Powell and the level of scrutiny that is to be applied was that it's not strict scrutiny, that it is something less. It's more than rational basis. It's one of those like clear and convincing evidence, whatever the heck that means. It's not by preponderance. It's not beyond a reasonable doubt. It's in between.
The state is wrong. At page 333 of Powell, the court says, this court has concluded that the right of privacy is a fundamental right and that a government-imposed limitation on the right to privacy will pass constitutional muster if the limitation is shown to serve a compelling state interest and to be narrowly tailored to effectuate only that compelling interest. The state cannot meet that heavy burden. The Georgia Supreme Court has been clear that the state can't just assert an interest in human life in the abstract and that ends the matter. We saw that in Zant, we saw that in McAfee. Instead, the interest must be sufficiently compelling under the circumstances of the case to override competing rights. And this is where Jefferson again is instructive. Jefferson indicates that the earliest point at which that balance might shift over is the point of viability. I would note that pre-existing Georgia law is effectively the viability line. Pre-existing law banned abortion at 22 weeks as they did from a patient's last menstrual period, and that is the earliest point when viability is possible under optimal medical conditions. We have that in.
When you say pre-existing, pre-Life Act, not because there's a lot of pre-existing Roe, Dobbs, but you were referring, okay, pre-Life Act.
Before HB 481.
Okay.
Exactly. And this was the state of the law until July 20th, 2022. Now, even if the court were to find that the state did have a compelling interest in protecting an embryo beginning just 2 weeks after a patient's last menstrual period, the grossly inadequate exceptions make clear that this sweeping ban is far from the least restrictive means. And to the contrary, the legislature seemed to have taken the maximally restrictive course at every turn. So I'm not going to go through each of these because we've had a lot of briefing on it, but I just want to highlight two examples, which is the exclusion of life-threatening psychiatric emergencies, that the state is saying, even if you are going to commit suicide, unless you can end this pregnancy, tough luck. And I would also point to what Your Honor mentioned earlier, which is the police report requirement for a rape victim.
So let me ask, Mr. Petrani referred to those as edge scenarios. And I'm sure the witnesses will help us better calibrate how infrequent or seldom those two scenarios. I will kill myself because I'm right now not emotionally stable or mentally stable if I have to move forward with this pregnancy or the child rape situation. So we don't need to go back and forth about that, whether that's 1% or 5% of all cases where a woman seeks an abortion. Assume for a moment those are edge scenarios, not to suggest they aren't crises and merit attention, but Mr. Petrani's argument was it's a facial challenge, and so you can't handpick the scenario I brought up of a 13-year-old raped by her stepfather, not quite incest, it's rape. And for all sorts of reasons, she says, I'm not going within 1,000 yards of the police on this one because he'll just beat my mom again. Then she's stuck. No relief under the current law. And that seems like the wrong outcome to lots of people. But if that's one out of every 10,000 situations, and the heartland of cases is for very personal and important reasons, I'm electing to end this pregnancy, but there's no coercion, duress, or whatnot. And now I can't because it's week 10 or week 15. Isn't that sort of the heartland? And so if it's a facial challenge, that's what you should be addressing, and not the woman who is at risk of self-harm, suicide, or the 13-year-old whose stepfather raped her.
Because we're applying strict scrutiny, it's the state's burden to show that they used the least restrictive means possible of furthering their compelling interest. And if the state cannot meet that standard, the law is facially unconstitutional. A law that is going to force a 13-year-old raped by her stepfather to carry that pregnancy against her will, a law that's going to sentence mentally ill Georgians to death because they're not permitted to end their pregnancy, that is not possibly the least restrictive means. So the percentage, the frequency doesn't matter, because what matters is that the Georgia legislature did not tailor this properly.
Okay, your point is that because these very real edge scenarios, lower percentage occurrence rate than something other, because they are captured by the reach of the current law, that shows that if it could be sufficiently narrowly tailored, don't know that it could be, but if it could be, it hasn't been, and that's fatal. That's your argument.
Yes,
okay.
Exactly. Now, I just want to pause for a second on miscarriage. So,
and I want to be clear, I was not binding your clients to any position already. I had thought that there had been some back and forth about if you are in the midst of a miscarriage, you can go to any doctor who, and that doctor can help you work through that. And it does not implicate HB 481, but.
There have not been side conversations on that, Your Honor, and I appreciate you raising it, because it gives me an opportunity to point out. You will hear later on today from witnesses about the terrifying ambiguity as to what is permitted with respect to miscarriage care and how that is actually playing out right now for Georgians in those traumatic circumstances. What we need is either a stipulation or a partial settlement from the state or a binding interpretation from this court as to what is permissible in the context of an inevitable miscarriage. Because the language of the law says it's not an abortion if you're removing a dead fetus. And so the state has said, well, the medical futility exception would apply there. We are all for an interpretation that would make this law less devastating and dangerous, but what the state says in its papers is not binding. And there are criminal penalties, as you know well. So we need greater clarity on that. Very briefly on the records access provision, I will just note that as we put in page 26 of our opposition to the motion to dismiss, there is a threat that failure to comply with a district attorney's request for the patient's medical records would mean that someone is held in contempt and potentially imprisoned. The state said, oh, well, it's clearly just the abortion information that will be made accessible. But what HB 481 says, and also the pre-existing law says, is it's the patient's health records that are made available. Once you have your abortion, your health records are available. And we have allegations in the complaint that your health records, and as we all know, your health records contain what medications you're taking, your sexual history, your mental health status, and a tremendous number of deeply intrusive and personal matters. That is exactly why in King v. State, which is directly on point, the Georgia Supreme Court held that prosecutors can't access those deeply private medical records without due process protections like a subpoena. You just don't get to do dragnet fishing of abortion patients' medical records. That's all I have on the motion to dismiss. Unless Your Honor's further questions, I'll turn to Board.
Let's turn to that. I'm mindful of the time and also mindful of the extensive briefing that has happened. And I also know that if while I'm working through this, I've got a question, I can always reach out to both sides and guarantee myself more briefing. So
Absolutely. If you want more paper, we are sure happy to provide.
yeah, Georgia Pacific appreciates you guys.
So the Georgia Supreme Court has emphasized time and again that void ab initio is assessed based on the law's constitutionality at the moment of enactment. In Adams, the court held that to answer this question, you look to the court interpretations that were governing when the law was adopted. The state does not contest our explanation of the legislative history of Adams, which makes clear that what the court was looking at in Adams, what it referred to as the original year support statute, is the 1958 statute that before it was amended in 1979 in an attempt to comply with the new decision in Oregon Order. I want to make clear that we know that the original year support statute is referring to that 1958 statute and not to some earlier pre-14th Amendment version, because the court then goes on to refer to the earlier year support laws. If original meant first in time, you wouldn't distinguish it from something that in fact came earlier. So what's critical is that the court is saying in 1958, the 14th Amendment existed, but it hadn't yet been interpreted to prohibit sex discrimination. So we're not going to say that the legislature did anything wrong. We're stepping into the minds of what did the legislators know about the state of the law when they adopted this, and they did nothing wrong because at that time, the law did not prohibit these kinds of gendered spouses.
More importantly, what the court in Adams didn't say was, well, the law is always the law and it's never changed. And we've had the vision now to tell you what it means. And so retroactively, it means what we say now it means.
Exactly.
How does it work if some of HB 481 is deemed void ab initio? Is all of it? And is that why I understand why you don't necessarily embrace Life Act as the name? It's kind of confusing for the references in all your pleadings to be to HB 481 and its sections, because of course you can't search for that. And that's actually not the law. The law is 1612, 141 and the other provisions. So twofold question. One is just procedural. I'm curious why, other than you may not like the nomenclature, why your pleadings focus on the sections of HB 481. Of course, that's the act. And if something's void ab initio, that's what would have been void, the thing that was passed. So explain that, but more fundamentally, I'm curious to know your view as to what happens if a court finds that, and I'm making the section numbers up, section 4 of HB 481 is void ab initio, but the other things aren't, because at the time passing that didn't violate any understanding that we had at the time of the federal or the state constitution.
So I would point the court to the citation at the top of page 15 in plaintiff's motion for judgment on the pleadings, which cites to in the interests of RAS, where the Georgia Supreme Court explained where a statute is held to be unconstitutional and void in part, a subsequent constitutional amendment cannot provide the void portion. So the court can simply hold that the provisions within HB 41, the 3 sections that we point to, which are all related to the 6-week ban, that those were void ab initio, but the rest of the statute is fine.
Okay. So there can be sort of that blue pencil surgical, here's the part that at the time this law was passed was plainly unconstitutional under everyone's understanding at the time, meaning the Supreme Court of Georgia and the United States, if that's how this plays out, but other provisions would persist.
Exactly.
Okay.
The state is raising in its briefing and in earlier argument 5 alarm bells about applying void ab initio here.
Meaning 5 different bells or a really, really, really loud alarm?
A really, really, really loud.
Okay.
The state's parade of horribles is unfounded, and let me articulate briefly why. The Georgia Supreme Court has not hesitated to require reenactment, even when it might seem harsh or perfunctory. So in Jones and in Wilkins, the legislature passed a law that was void at that time, realized their mistake, one day later, went through the whole rigmarole to cure the constitutional defect. And the Georgia Supreme Court said, sorry, you can't revive it because it was void from the start. You have to reenact it. So the state, you saw in the state's briefing, this reference to plaintiff's contrived rule. This comes from the Georgia Constitution and the Georgia Supreme Court's application of the voidness provision in the Georgia Constitution. The second reason why the state's concerns are overbroad is that this is a very unique fact pattern. It's not like the General Assembly frequently passes laws that are an effort to test the US Supreme Court's clearly established precedent in a given area, and it is even much less frequent that the Supreme Court would then go on to overrule that very precedent. So requiring reenactment under these circumstances is no great burden on the legislature, and as noted, it is required by binding precedent. Now, I'd just like to close by highlighting language in Sherman v. Atlanta Independent School System, which is 293 Georgia 268. And this is just from 2013, which I think well illustrates the democratic accountability principle that's animating this doctrine. In Sherman, the facts are that the legislature had enacted a law that was unconstitutional under court interpretations of the time. The people of Georgia then ratified an amendment to the Constitution to not only permit those kinds of laws moving forward, but also to specifically give that once unconstitutional law retroactive effect. In explaining why the void ab initio doctrine does not apply to prevent such retroactive effect, the Georgia Supreme Court emphasized that there is a key distinction between, on the one hand, the legislature's power to pass laws which are limited by the Georgia Constitution, and on the other hand, the power of the people of Georgia to ratify changes to the Constitution, including a specific exception to the void ab initio constitutional provision applied to a particular set of facts. And what's really key is Sherman explained that it is, and I'm quoting, an essential aspect of our system of government that the people, not the judges, have ultimate control over the law under which they live. That is perfectly aligned with the Georgia Supreme Court's reenactment requirement. So if a law is void ab initio, the people of Georgia can revive it by ratifying a constitutional amendment that says we're going to give this retroactive effect. Or if there is some other change in the constitutional landscape, as in our case here, the legislature can reenact a law that was void if that is the people's will. But a change of heart by 5 justices on the US Supreme Court is not enough to revive a law that was void under the Georgia Constitution, because it is the people, not the judges, who have ultimate control over the law under which they live. The General Assembly is free to take a vote and reenact a 6-week abortion ban now that Dobbs is the law, but Georgia's Constitution requires that the people have an opportunity to weigh.
Got it.
Thank you, Your Honor.
Thank you. Mr. Petrani, you've got a little bit of time. You can respond to the arguments on the motion to dismiss. You can talk more about void ab initio. You can say, you know what, you've heard it all, however you want. You get about 15 minutes.
Very quickly, Your Honor. First, on the 9/11/12B point, we filed both things at the same time, served them on plaintiffs at the same time, made sure Ms. Niles had them at the same time. The clerk's office apparently kicked one of them out. So we filed on Friday, they kicked one, so we refiled as soon as we could. Apparently there was an F in the caption where it should have said in instead of fin. So we did in fact try to file them at the same time, but just setting that aside, Just a few points. First of all, I just want to make clear that the legislature did not say anything that is contrary to either science or even what plaintiffs have argued here. Plaintiffs aren't even challenging the personhood provision. They elected not to. So this notion that somehow that what the legislature found is different from what we believe or experts are going to say, I think is just wrong. I mean, they basically said, look, this is a unique, separate individual. Granted, pregnancy is a unique human condition, and it's dependent on the mother, of course, as it's going to be throughout pregnancy, and it's only, advances in modern science that allow some babies to survive, 22 and a half-ish weeks on in certain circumstances with very, intensive care. So I don't think that there's any differentiation between what the legislature found and what we're arguing, or what is essentially, as far as I can tell, undisputed. The argument seems to be that because embryos and fetuses are small and dependent, that somehow this changes their moral status. And we disagree on that, but the key point is that the legislature gets to make that determination. And by and large, it's just a tautological argument from the other side, which says, well, there is this right to abortion, therefore the legislature doesn't get to make that determination. But I don't think that really gets you anywhere. On Pavicic being somehow just about taking a picture, the point in Pavicic is not something that someone took a picture, it's that they then used that picture and that likeness without this person's consent. And the difference between, of course, Pavicic and here is that no one else was implicated in Pavicic. There was no third party, no neighbor, no one else that was being affected by this. On miscarriage, I think the statute is very clear. Our primary point on this is that you are not intending to end the pregnancy if you're dealing with a miscarriage, and that is our view of the statute. I don't really know what other view could have of the statute, but so I don't actually think we disagree with the plaintiffs on this point, so I won't spend too much time on that. I also want to push back on this notion of least restrictive means or narrow tailoring. It is true that in one portion of PAL, it uses that language, but it doesn't say that's the only test that applies. In fact, it cites the cases with both tests, and earlier in the opinion, it uses the very language that I said, and I'm newly impressive.
I figured your language is in there as well. It just leaves a poor little Superior Court judge wondering, well, what test am I supposed to use?
I don't think it ultimately matters, because I think that either way, the interest of the state in protecting unborn children is a compelling interest. And I think that the fundamental disconnect between us and the plaintiffs on what's the least restrictive means is it is not narrowly tailored, or the least restrictive means to just not prohibit the thing that you're trying to prohibit. It's no more narrowly tailored to say we're going to let you do this in certain circumstances up to 20 weeks than to just stop it at 6 or 8 weeks. You're just talking about, well, how, at which point are we protecting the interest? It's not like you're still protecting it if you're letting this happen for months on end. And then on the psychiatric point, again, this is really a question for the legislature, but again, the plaintiffs never even responded to our basic point that the legislature, of course, can determine that certain things you cannot do in order to deal with psychiatric emergencies. It's not to denigrate the seriousness of them or to say that they're somehow not relevant. It's just that in the same way that we wouldn't let someone commit a crime of some other sort in order to deal with their psychiatric issues, we're not going to let them commit this particular crime, because we think that there are much better and other ways of solving that problem. And again, that's what legislatures do. They regulate in this area all the time. Finally, I think one of the things that on the motion to dismiss, one of the things the plaintiffs raise is this sort of, it's not clear what doctors can do and what they can't. We of course disagree with that, but also they didn't bring a vagueness challenge. This isn't a vagueness case, so I don't really see how that's relevant. And then I'm a little confused on the notion that if in one circumstance this law were invalid as applied, somehow the entire law is invalid. I confess I don't entirely understand this argument. Normally, what the judiciary tries to do is keep as much of a statute around as it can, not look for reasons to sort of like, got you, you didn't quite get that one point, so we're going to get rid of the rest of the statute. And then finally, on void ab initio, I don't think we disagree with the plaintiffs on the technical point of what the legislative history of the law and acts was, but we do disagree very strongly on what the court was referring to when it said court interpretations of that period. I think if you look at that paragraph in context, it's talking about before the equal protection clause was even added. But I also, even that dispute is getting very far away from the core point here, which is plaintiffs say precedent somehow compels this conclusion, and yet can't find a single precedent ever, of a court ever doing this. And the best they have is this one line in Adams where the court didn't even do it. It said we don't have to look at that analysis. And the court certainly didn't say that overruled judicial opinions would somehow matter. So I don't want to belabor those points because we have briefed them many times, but I do want to just, of course, remind the court they cannot come up with a single instance of any court in 250 years in any state or federal court doing this, and it's because it's just fundamentally at odds with the way that legal proceedings work. I'm of course happy to answer any other questions that the court has. Otherwise, I just wanted to make those few points.
I have one question, and it can be fleshed out more during the trial and argument afterwards. Folks have stayed pretty far away from equal protection. It's alleged. It's not as fleshed out as I thought maybe it would be. What is your response to an argument that one constitutional flaw with that medical exception provision is that it doesn't provide equal protection? If I am suffering from a mental health condition that might cause me to, I want to make sure I get the right language. Where did that other piece of paper go? I might harm one of my major bodily functions through self-harm because of the mental or emotional impact of moving forward with a pregnancy. And that's too bad for me. But if for physical health reasons, a major bodily function of mine would be irreversibly, permanently impaired, whatever the magic language is, that is an exception. How is that not an equal protection violation of that particular provision? So we don't need to get to privacy, right? There are some exceptions built into it, but they don't seem to apply equally.
Yeah, so Your Honor, on equal protection more generally, the reason I think that neither side has really gotten into it is their only argument seems to be, well, this is a fundamental right, therefore it violates equal protection. But if it's a fundamental right, we don't really need to get to equal protection. But on your specific question, so the way equal protection analysis works is that there are several steps. First, you have to prove you're similarly situated. Then, to get anything beyond rational basis review, you have to establish that there's a fundamental right at issue or that you're part of a suspect class. I don't think either of those could apply here. And so we're at rational basis review at most, but we're not even there because they're not similarly situated. There are numerous circumstances where we allow someone, in fact, it's the prescribed treatment for a particular physical ailment is, medical intervention, surgery, or something like that. But we wouldn't let you do the same thing just because you have psychiatric issues. So if you have some sort of problem with one of your organs that needs surgery, you can get surgery. If you just think you have a problem with one of your organs, but you don't, it's entirely appropriate for the legislature to say, you doctor cannot do that. That's not the appropriate way of responding to that. So I think, again, not diminishing the real seriousness of mental health problems, they're just not the same as physical problems. They're not worse or better, they're just different. And so you're not similarly situated in those circumstances.
Okay, we'll explore it more. Thank you. All right. My thought was that I guess I need to know from counsel for plaintiff how you wanted to start. I don't need to take a break yet. We can because we're transitioning to doing the trial. If you want to do a short break, otherwise, I figured we'd go closer to 11 before we break. I've got timers here I can use. I wasn't sure if we should do 6 hours or 7. I don't know that there are 14 hours of business time between now and when I kick everyone out tomorrow. I'm happy to do 7 so that we don't run out of timer time, but we still have clock time. So I don't know how you all discussed that. I know I had sent through Ms. Niles a little bit of pushback when I did the math. We will take some breaks during both days. So I didn't quite get to 14 business hours.
Your Honor, we are fine to not take a break now and just dive into it. And I think we had planned, given your instructions, to be aiming for 6 hours.
Okay.
Inside.
Well, if we have extra time, that'll just be a bonus for everyone.
Yeah. And one preliminary thing that we have conferred with the state beforehand in an attempt and a lot of things to try to streamline the next 2 days. And one of the things that we agreed was that each side was not going to have any objections to the other's exhibits. So if it's okay with you, we would go ahead and move to admit all of plaintiff's exhibits. And I believe the state's going to do the same on their side.
So no objections to disclosed exhibits. If something comes up, oh, now that this witness has said this, we have bonus exhibit. I mean, we were at like 500 on the state side. So bonus exhibit 501, that may be subject to an objection because neither side has had a chance, the opposing side hasn't had a chance to vet it.
Correct. This applies to everything on our disclosed exhibit list.
Okay, so I have a handy dandy binder you provided that has for plaintiffs a very short witness list, a very long exhibit list, although not as long. 148 plaintiffs exhibits.
Yes.
Okay, let me. And the defendant's exhibit list has 524 exhibits. They win. It's more exhibits. Let's go home. There's way more exhibits. So there are no objections from plaintiffs to the 524 exhibits on the defendant's list.
Correct.
You've actually looked at all of them.
You know.
Close enough. All right. And Mr. Scher, any objection? And I'm not ignoring you, Mr. Petrani, but you mentioned Mr. Scher and crew.
From this point on, it's not that I'll never speak, I might never speak, but I think the default is going to be either Mr. Scher or one of my colleagues.
Okay, I'll start with Mr. Scher and he can redirect me. Mr. Scher, no objection from defendant to the admission of and consideration of the 148, assuming they didn't leave any out, plaintiff's exhibits.
That's correct.
Okay, great. Well, that will certainly streamline things. So when you're ready,
All right, I'm going to turn it over to Miss Rebecca Chan.
Ms. Chan, and I'm assuming everyone, there's some new names I didn't remember signing pro hoc orders on. I don't have an issue with people coming in and arguing from either side. There are no objections from plaintiff to any of the lawyer names you heard on defendant side.
No, Your Honor. And I believe everybody on our side has had their pro hac submitted.
Okay, and Mr. Scher, you have no concerns about that either.
No, we don't.
Great, okay.
They'll accept our defendant's exhibit attorney, then we'll. we're happy.
Excellent. All right, Ms. Chan,
Morning.
good morning.
Can I just call Dr. Carrie Swiak?
All right. And before we get started, your clock hasn't begun running yet. Will you be sharing exhibits digitally? So we need Dr. How do you say your last name?
Swiak.
Swiak's screen to be working? Great. So before you get sworn in, will you tap the got it button? Does it say got it? The blue? Excellent. Okay. And let me do one other thing. There we go. Okay. Boy, when it's surgery time, you know where right and left is. No, it was my left hand, doctor.
Yes. Carrie, Carrie, last name Swiak, Cwiak.
Good morning.
Very good.
Again, good morning, Dr. Swiak.
Morning.
the court has previously admitted into evidence your two affidavits that were submitted in this case on July 26th and October 14th, 2022 respectively, as well as a current copy of your CV. So I'd like to just briefly go through some of your credentials now. What's your current profession?
So I am a professor of obstetrics and gynecology, as well as a professor of epidemiology.
The second one was epidemiology.
Yes.
Could you briefly describe your educational history for the court?
I received my medical degree from St. Louis University School of Medicine. I completed a residency in obstetrics and gynecology at the University of Connecticut Health Center. I completed my fellowship in complex family planning at Emory University and also completed my master's in public health in epidemiology at Emory University.
Board certified in any particular field of medicine?
Yes, I'm board certified in obstetrics and gynecology and board eligible in complex family planning.
How long have you been certified in obstetrics and gynecology?
Well, I've been practicing obstetrics and gynecology for over 21 years now. In terms of when I was actually certified, it was probably 20 years since then.
Are you currently licensed to practice medicine?
Yes,
Which state?
in the state of Georgia
And where are you currently employed?
at Emory University.
How long have you
Miss
worked?
Jan, I need you to speak up or get closer to the microphone. You're like behind it.
Is this better?
Can you speak again?
Hold on one sec. What color?
Now it's on. Is this better?
Okay. Yes, much better. Thank you so much. Sorry for the interruption, Your Honor.
Not at all.
No, that's exactly what you're supposed to do, stenographer April. Why don't you bend there you go. Excellent.
Okay. Is this still okay?
It should be better.
Much better. Thank you.
Great. And how long have you worked at Emory?
So again, 21 years.
And you briefly mentioned a little bit, but could you state the positions that you hold at Emory?
So I am the chief of obstetrics and gynecology at Emory University Hospital Midtown. I am the chief for our obstetrics and gynecology inpatient service line for Emory Healthcare for our 3 obstetric hospitals. I am the director of the Division of Complex Family Planning and the Fellowship of Complex Family Planning.
And when you mentioned earlier that you're a professor of obstetrics and gynecology and of epidemiology, is that also at Emory?
Yes.
What does your work as a professor of obstetrics and gynecology entail?
So for me, that does include seeing patients. I also teach a variety of learners, students, residents, fellows. I do research, clinical research, as well as public health research, and teach, so provide lectures, as well as administrative tasks like in clinical operations in my duties as chief of service.
And what topics do you teach?
So my focus, my expertise is contraception and abortion care, and especially those areas of care for complex patients.
And do you train students, residents, and fellows in the provision of abortion care and miscarriage care?
Yes, certainly. They are, we teach them in a didactic situation where, we may be providing a lecture, perhaps a simulated situation where we're doing hands-on training where they get to practice the skills, whether that be counseling or providing a surgery. They get to shadow us when we are taking care of patients. And then as their competency progresses, they get to engage in that care of taking care of patients.
What is a complex patient? You mentioned your specialty and it involves complex patients.
Yeah, so for contraception and abortion, it's really something that any obstetrician gynecologist can provide. Complex family planning is a unique subspecialty in which we're more apt to be dealing with and more experienced in dealing with patients with chronic medical conditions, complexities of their anatomy, certainly more likely to be providing care in second trimester. So for patients who are more complex instead of straightforward in their care. Similarly with contraception, luckily many people are healthy and have no contraindications to using contraception, but there are patients with complex medical conditions. And when they have those, we need to make sure that we provide them safe contraceptive care. And so those patients get referred to us.
Just turning back to training a little bit, approximately how many residents and fellows and medical students have you trained in miscarriage and abortion care throughout your career?
I gotta think about that. So if we think about, one fellow a year, so roughly 20 fellows so far, 9 OBGYN residents per year, and at least, depending on the year, at least 100 medical students that rotate through obstetrics and gynecology with us per year.
So safe to say in the thousands then.
Mhm.
And what does your work as the director of the Division of Family Planning entail?
So clinical operations might include directing the division to agree on a clinical protocol that is evidence-based and that allows for high quality, safe care for our patients and eliminating as many barriers as possible. Assuring that the learners that we do work with have a particular schedule for their lectures or their readings or the time that they're working with us in clinic. Assuring that my division directors have the mentoring that they need to provide clinical care and education and research themselves, and then assure that our research program is robust, that we are collaborating with other groups within Emory University or outside the university, and that we are engaging in a number of different types of studies.
And do you also provide clinical care?
Yes, I do.
Do you provide care to patients who wish to continue their pregnancies?
Yes.
How many babies would you estimate that you've delivered in the course of your career?
It's too many to count. But I do continue to provide obstetrics, including deliveries, and that in addition to general obstetrics and gynecology, as well as in my subspecialty.
And do you provide medical care directly to patients outside of your work at Emory?
Yes, we contract with some independent abortion providers in order to provide care and to train our learners.
So I see that you also work at Feminist Women's Health Center, is that correct?
Yes.
What is your role there?
I am the medical director there, as well as a clinician and a trainer.
And what services do you provide there?
So we provide abortion care, contraception, gynecologic care, some minor procedures for GYN, as well as trans care, including hormone therapy for trans men.
And what is your role at Atlanta Women's Center?
I'm a clinician trainer there.
And what services do you provide there?
Abortion care and contraception, and sometimes early pregnancy loss care, that as well for Feminist Women's Health Center.
Are you a member of any professional associations?
Yes, the American College of Obstetricians and Gynecologists, Physicians for Reproductive Health, and Society for Family Planning.
How do you keep abreast of literature and developments in your field relating to obstetrics and gynecology?
Well, like all board certified OBGYNs and likely physicians in all specialties, I have to complete maintenance of certification every year, which means that that's a requisite number of studies that I need to read and assure that I'm comprehending in order to maintain my certification. But also, I had mentioned before, working on clinical protocols with the division in my roles in administration. That just requires me to keep up to date, reading the literature, assuring that whatever protocol I support or develop is evidence-based.
And do you conduct research in obstetrics and gynecology?
Yes.
Have you published that research?
Yes.
Where?
So one journal that we published in is the New England Journal of Medicine that focused on a study in which IUDs were provided to patients, and we looked at the pain management that was appropriate for them. I've also published with my team extensively in contraception. That's the journal for our Society of Family Planning.
And are those peer-reviewed publications?
Yes.
Aside from conducting and publishing research, do you serve as a peer reviewer for any
Yes.
peer-reviewed public medical journals? Okay.
Yes. Contraception, American Journal of Obstetrics and Gynecology, Fertility and Sterility, American Family Physician.
Based on your experiences, are you familiar with the norms and standards for the provision of obstetrical and gynecological care, including care for high-risk pregnancies and including the provision of abortion care?
Yes, I'm aware of that.
Your Honor, at this time, plaintiffs move to qualify Dr. Swiak as an expert in obstetrics and gynecology, including abortion care.
No objection on the part of the state, Your Honor.
Great. So Dr. Swiak, you are qualified for the purposes of this trial as an expert in the field of obstetrics and gynecology, as well as abortion care. Did I cover it?
Including abortion.
All right.
Dr. Swiak, you're here today to offer expert opinions about the impact of Georgia House Bill 481 relating to the provision of abortion care. Is that correct?
Yes.
Are you familiar with HB 481?
Yes.
And what do you understand that law to require?
So HB 481 states that when fetal cardiac activity, that once fetal cardiac activity is present, that abortion is not permissible unless 3 legal exceptions apply. And that is the case of a medical emergency, medical futility, or rape or incest where the police report is filed.
And when during pregnancy is fetal cardiac activity generally detectable?
Typically by 6 weeks.
And when you say 6 weeks, how are you measuring that?
So the way that pregnancies are typically measured is from LMP, or last menstrual period. And so when we say 6 weeks LMP, that is 6 weeks from your last menstrual period that you were aware of. And it's really 2 weeks from when you would have expected your next period, if it was a regular period.
So it's not 6 from your first missed MP. It would be 6 from a non-missed one.
Exactly.
Okay.
So is it correct to say that it's roughly 2 weeks from your first missed period?
Yes. So again, if you have a typical monthly menstrual period, then by the time you have missed your menstrual period and recognize that, then you're already 4 weeks from LMP.
And so if I refer to HB 481 as the ban or the 6 week ban, will you know what I mean?
Yes.
How typical is it that a woman has a fairly regular menstrual period, i.e. every 4 weeks, as opposed to, sometimes it's 4, sometimes it's 6, so that 6 weeks could actually be before you even were worried you had missed something?
Well, there is a range of normalcy. So it is more than 28 days. It really could be considered up to every 35 days and still be considered regular. And so that is the norm, but there are a number of people who have irregular menstrual periods, either because of a chronic medical condition, obesity, current use of contraception, previous use of contraception, or they have bleeding that occurs with implantation and they think it's the last menstrual period.
So given that variation, is it common that people know they're pregnant before 6 weeks?
It is not that common.
What is the basis for your opinions in this case as to the necessity for and impact of the ban?
Can you clarify?
Sure. I'm curious what you're basing your opinions on in this case about the impact of the ban.
Oh, okay. Well, it's really based on my over 2 decades of experience, clinical experience, as well as study in this area in the medical of the medical literature, and not only in obstetrics and gynecology, and specifically for abortion care, but also in public health.
And do you offer your opinions today to a reasonable degree of medical certainty?
Yes, as much as I can.
You'll help me understand when your opinions are particularly anchored in medical certainty versus, look, I've been doing this for a long time. I've got strong feelings about it.
Yes, certainly. I really try to make that a point, especially when I'm working with learners or other faculty, that if it's clear cut from the evidence, then I'll say so. If it's not, if it's a data-free zone, I'll say so.
Data-free zone. Okay, thank you.
Did you review any materials for this litigation?
Well, certainly. I looked at my prior affidavit. I looked at the most recent morbidity and mortality statistics to see what had changed since we last really looked at the issue.
Did you review any of the affidavits from the state's experts?
Oh, yes, I did.
And based on your review of the literature, research, analysis, and your firsthand experience and expertise, do you believe that the ban improves health outcomes for Georgians?
Unfortunately, no. I think a restrictive ban such as this only harms the health of Georgians and their families.
I'm going to pause you for 1 second. I'll pause your clock. If folks could slide to my right, your left. We do have a few people trickling in, and if you've got extra real estate to your left, put your bottom on it. Thank you. I don't mean no one needs to sit in laps or anything like that, but I'm seeing people come in and like, there's no room, and then I see person-sized gaps between some people. So let's try to accommodate. All right, restarting the clock.
Okay. I'd like to ask you some questions about pregnancy. If a patient carries a pregnancy to term, what is the duration of that pregnancy?
So again, thinking about the standard that we use from LMP, we say that 40 weeks from LMP is the estimated delivery date. And that's because that, again, is the norm on average. So that means that could be a couple weeks earlier, that could be a couple weeks later. And then certainly there could be complications with any pregnancy that require delivery sooner than that.
And how does pregnancy affect a person's body?
Well, it depends.
That could be like a 4-day answer.
Briefly.
So really it's a continuum, because as you progress in pregnancy, the level of estrogen in your body increases, the level of progesterone increases, the placental action increases, and its hormone that it secretes increases, the size of the uterus increases, and the placenta and the fetus, and therefore more blood flow needs to go to the uterus. And so all of the physiologic changes of pregnancy will therefore just increase as you move further along. And one of the effects is increased cardiac output. So your plasma volume increases. Again, you have to get all the blood flow to the uterus and the placenta and the fetus. And so your cardiac output has to increase to compensate. So that could be why people feel, flushed or their heart rate goes up even after like climbing one flight of stairs when they're pregnant. As you move further along in pregnancy, you have more oxygen requirements because again, you are delivering oxygen to the uterus and the placenta and the fetus again. And so your lungs need to work harder. Plus, as the uterus gets bigger, it's going to impinge on the ability of the lungs, for you to take in a full breath. And so again, thinking about the person climbing the set of stairs is why you might be a little short breath, or just like walking across your room, you might feel short of breath. The increase in progesterone impacts the GI tract, the gastrointestinal tract. So everything kind of relaxes. And that's when you tend to have more gastric reflux and nausea and vomiting and constipation and things like that. So it increases again over time with the development of the pregnancy.
And what impact, if any, can pregnancy have on any underlying health conditions?
So if you have already pre-existing conditions, hypertension, diabetes, pregnancy can adversely impact those conditions because it really changes how your vascularity works, how your blood vessels constrict, and how active they are, how reactive they are, and how likely they are to constrict. The placenta also makes you more insulin resistant. And so it can make diabetes worse. Again, hypertension can develop to severe hypertension, stroke, heart attack, but also preeclampsia and eclampsia, which is even more so than just hypertension. It is where your vessels kind of get leaky and then you end up spilling protein, you have swelling, you have protein in your urine, you can have seizures. And to back it up, I mentioned the impact on high blood pressure and diabetes. That's talking about people with that pre-existing condition, but certainly even people without a pre-existing medical condition may develop high blood pressure just because of the pregnancy itself, and diabetes just because of the pregnancy itself. And for those people that develop those conditions, they're actually at higher risk after delivery and later on in life of developing those conditions.
So in this era where we read all the time that Americans are getting more and more overweight and obese and diabetes is spreading, do you see more complex patients because they have these pre-existing conditions? The average American is overweight and is out of shape and all that. And you've just described how that can make being pregnant, set aside HB481, just pregnancy in general is getting more complicated because we have fewer fit and healthy people.
That's part of the reason why we are seeing more complex pregnancies, more hypertensive disorders in pregnancy. We have people are waiting until they are older in general to get pregnant. And it is true with the rising increase in obesity that you're more likely to have conditions that go along with that. There are also people that are, increasingly we're seeing luckily more survivors of issues that they had, congenital issues they themselves had. So we see more people with complex congenital heart disease or childhood cancers and cystic fibrosis, sickle cell anemia that weren't surviving to that point where they could be pregnant. And so now, HIV as well, where they weren't surviving to that point where they could be pregnant. So yes, we're seeing more complex pregnancies nowadays.
So you mentioned diabetes and hypertension, and I'm curious if there are any other conditions for which pregnancy is itself the risk factor that could develop in a pregnancy if a patient didn't have that condition before the pregnancy.
So I would say the other biggest example would be venous thromboembolism, which means a blood clot in your veins. And that often starts in one of your deep veins of your leg, but unfortunately can also travel to the lungs where it can be life-threatening. That happens, and pregnancy is a risk factor. So if you already have risk factors for blood clot, then you have a higher risk of blood clot in pregnancy. But just by virtue of being a reproductive age female, if you get pregnant, you therefore then carry a higher risk of blood clot. And that steadily increases in pregnancy as the level of estrogen increases. And in fact, it increases exponentially in the first 24 to 48 hours postpartum.
How common is abortion?
Well, almost half of all pregnancies in the United States are unintended. About half of those people are using contraception, so they're trying actively not to get pregnant. Of those unintended pregnancies, about half lead to abortion. And then there are the cases where the pregnancy was intended, but then there's a complication that leads them to make that decision. And so if you look at the incidence among US women, it's about 1 in 4 women of reproductive age have had an abortion.
And when during pregnancy do most people have abortions?
Over 90% occur in the first trimester.
And in Georgia, do you know roughly what portion of abortions occur during the first 6 weeks?
It's less than half.
And does that percentage of abortions that occur before 6 weeks, can we safely say that those abortions, those fetuses would not have had fetal cardiac activity?
So the majority of pregnancies before 6 weeks won't have fetal cardiac activity detectable on ultrasound. Again, there's a little bit of variability, and so you might have a pregnancy measuring 5 and 6 that shows fetal cardiac activity. You might have a pregnancy measuring 6 and 1 that shows no fetal cardiac activity. But in general, by 6 weeks, most of them show fetal cardiac activity. And so the majority of them before 6 weeks would not be showing that.
5 and 6 means 5 weeks, 6 days.
Yes, 5 weeks, 6 days.
And so when you say that roughly half of abortions in Georgia occur during the first 6 weeks, does that include that 6th week, or does that run up until 6.0 and stop?
Well, it's important to look at the statistics and know, that is the important point, to know where the cutoff is, because if you are looking at the ITOPS data that is collected in the state of Georgia, they collect the gestational weeks by just a solid integer, no decimal points. And so when the abortion is reported as 6 weeks, it's actually 6 and 0 to 6.6. And so anything less than 6 weeks has to really be reported as 5 and less. So you need to make sure whatever report that you look at is truly looking at less than 6 weeks instead of 6 and less, in order to reflect the number of abortions that could occur under this ban.
And so the roughly half that occur that you referred to, that's 6 and less weeks. Is that correct?
Yes.
And when you said ITOPS earlier, did you mean induced termination of pregnancy reports?
Yes, that's the system that Georgia uses to report abortions.
In your experience, why do people have abortions?
It's a complex question. It's not a decision that they take lightly. It typically involves more than one reason. Could be for their own health, could be for the children that they already have. They're concerned about their economic stability or other ability to care for them and the needs that they have. It could be a number of familial, financial, social situations that lead someone to determine that it's best for them to pursue abortion. And in fact, that's why we increasingly are not using the term elective, because elective is a bit of a pejorative term that suggests that I could do whatever. I could go either way. And really there are compelling reasons why typically a person chooses to have an abortion.
You mentioned in your rebuttal affidavit that you counsel patients before you provide abortion or before you do the procedure. What types of factors do you counsel patients about as they're deciding or before the procedure?
So I really strive to make sure that I'm providing patient-centered counseling, and that is to engage in shared decision-making with them, where I provide the scaffolding of medical information about the benefits and the risks, and then they can use that to insert their own preferences, values, beliefs, all of those myriad factors that I talked about before that impact how they need to live their lives in the setting that they're in. And so with that information together, the information I provide them and trying to understand where they're coming from, trying to meet them where they're at, even what point are they in the process of deciding, then I can help guide them in making the decision that's best for them.
What different methods of abortion are commonly used in the United States?
So there's medication and there's surgery.
And are these abortion methods, medication and surgery, comparable to other types of clinical care you provide?
So we do use the same medications and surgical techniques for care of early pregnancy loss or miscarriage.
How often do patients experience serious complications from any kind of abortion care?
So a serious complication would be very rare, less than 1%. And the risk of death is, it's like half of 1%.
What do you mean by serious complication? There are a bunch of phrases that get bandied about, and it helps to try to define. I'm going to ask you about a couple that appear in the statute to see if that's a medical term or if that was a lawyer legislator term. But you, as a medical person, said actually, I think the lawyer said serious complications, but you answered it. What does serious complication mean to you?
Yeah, so if you look at the literature, they often talk about complications overall and then talk about serious complications. And that tends to be, whether you're looking at abortion literature or other literature, it tends to be complications that require surgery or some invasive intervention like blood transfusion or hospitalization. So
excessive bleeding such that there need to be a transfusion, that would be a serious complication.
Yes.
Complication could be, I'm still in a lot of pain 2 days later, but you examine the patient and it's pain, and that's unfortunate. And here's a pill to help with the pain, but it's nothing more serious than it still hurts.
Yes.
Okay.
On what data is your,
Were you going to ask Dr. Swiak how serious complication rates and death rates in abortion compare to carrying a child to term? Is that, I don't want to, if that's on your chart and you're going to get there, then I'll stay away.
Yeah, I'm going to get there, but we're here now. So happy to have her speak about that now.
So if you look at the fatality rate for abortions, it is less than 1 per 100,000 abortions. If you look at the maternal mortality rate, it is, well, in Georgia, it is 25 per 100,000 live births. And in Georgia, our state is the second to the worst in the country.
So 25 times higher risk of fatality during, we'll call it the process.
If you compare specifically to Georgia, yes.
Yep, that's what we're here for, is Georgia.
And on what data are these opinions based?
So the CDC, the Centers for Disease Control and Prevention, publishes the abortion surveillance report annually, and they look at the best estimate of the total number of abortions provided, and then look at use a number of means to determine how many fatalities occurred and whether they were related to the abortion or not. And it's very similar with maternal mortality. There are a number of vital records systems in each state that report the number of live births in the United States. And looking at maternal mortality may involve working with similar to the abortion fatality, working with a maternal mortality committee, looking at, again, vital records, death certificates, reviewing specific cases to determine the true incidence of pregnancy related deaths that would be included in the maternal mortality ratio or rate.
And is the CDC considered reliable in your field?
Yes.
Did you look at any other sources of data in drawing your conclusions about safety?
So the National Academies was asked to compile a report as well on the safety of abortion, and they did even more of an extensive review than the abortion surveillance report for the CDC, because that's looking specifically at the statistics, again, like I said, involved in mortality and the total number. But the National Academies review did a expansive systemic review of the literature to look at all the cases that were really relevant to the United States and measured them on the quality of the evidence, as well as if they could show that the typical tenets of care were being provided in abortion care, like quality and safety, things like that.
And when you say the National Academies, are you referring to the National Academies of Science, Engineering, and Medicine?
Yes.
And is that considered a reliable source in your field?
Well, not only in obstetrics and gynecology, but I mean, the Institute of Medicine. Maybe people aren't as familiar in my field with the engineering and sciences, but the Institute of Medicine is well regarded among the entire medical profession.
You mentioned that you reviewed defendants' expert reports, and I believe Dr. Skopp said that the numbers that you rely on for the safety of abortion are not reliable. Do you have a response to that?
Well, I understand that you are talking about two different events. One is the number of abortions and one is the number of live births, but truly that is what we are talking about, is what is the mortality related to each. And I think it's the closest you can get to estimating what has the impact of pregnancy been to that point. And in fact, that's what abortion mortality includes, those statistics. What has the impact been so far of the pregnancy? Has the abortion itself caused the mortality? Has it led to a chain of events that caused mortality? And it's almost mirrored in the way maternal mortality is determined. Did the pregnancy lead to a course of events that led to the mortality? Was it the delivery of itself? Did the delivery bring upon a chain of events that occurred at that time or later? And so it's, in that sense, it is as comparable as you can get when you're talking about two different medical events.
Did you comment on the frequency of serious complications flowing from pregnancy, as opposed to, you told us it's about 1% of the abortion cases results in serious complications. What about?
I guess it depends on the complications. It is
the
true
serious
that
ones.
So certainly your risk of blood transfusion, surgery, hospitalization increases as the risk of, or as pregnancy progresses. Even if you think about something that is an intended surgery. So for about 30% of people in this country who are pregnant, they more or less, they end up with a cesarean delivery instead of a vaginal delivery. And that may be a necessity in order to provide the most benefit to the patient, the pregnant patient and the fetus, but it's an abdominal surgery. I mean, you're cutting through the abdomen and you're around the bowel and bladder and cutting into the uterus. And there's, incredible risk of bleeding, especially for some patients. So, so certainly, yes, higher rates of serious complications.
But that's not something, it just seems like a statistic that would be quantified in this debate, that of pregnancies that go to term, for every 100,000, there are X where there are serious complications. Whereas for abortion procedures, there are Y that result in serious complications. That's not something that's measured.
No, I'm sure it is. Off the
Okay.
top of my head, I don't know.
Okay.
But I know that my colleague, Dr. Bedell, will also be testifying. And
Okay,
she
we'll save it
may
up.
be able to answer that more clearly than I can.
Dr. Swiak, have you had to tell patients that you can't provide their abortion because fetal cardiac activity has been detected?
Yes.
Generally speaking, when patients receive this news, how do they react?
It's upsetting. It's emotional. They get mad. It's hard for them to understand why I can't provide medical care to them when they're coming to me for medical care. And if it was any other situation, I'd be able to. They often wonder aloud to me in that instance what they're going to do, how they're going to assure that they can get the care that they need, whether that's even thinking through logistics, like transportation, arranging for childcare, arranging for time off from their job. Yeah, so it can be pretty significant.
I'd like to talk next about miscarriage. Based on your experience, how common is miscarriage?
About 1 in 20 pregnancies end in early pregnancy loss or miscarriage.
You said 1 in 20, is that?
Oh, I'm sorry. 20% of pregnancies. I'm sorry. Yes.
No problem.
Thank you.
Just clarifying.
Yeah.
Completely
That's a
different
different number.
Yes, that's completely different than what I put in my affidavit.
Right.
Yes, thank you.
Of course. Is miscarriage sometimes called by other names?
So yes, so early pregnancy loss, spontaneous abortion, and there are different types of spontaneous abortion.
When during pregnancy is miscarriage most likely to occur?
In the first trimester.
And is it common after 6 weeks?
Yes, it still is common after 6 weeks.
Broadly speaking, what is the process of a miscarriage?
So it depends on, obviously, the underlying etiology could be a number of things.
And that word means
The
etiology.
the cause of the pregnancy loss. So whether it's chromosomal or an infection or a hormonal imbalance that the patient already has. But sometimes what happens is the embryo or the fetus doesn't even develop to a point where it develops fetal cardiac activity. Sometimes and so it stops in its development. Sometimes the development proceeds to the point where fetal cardiac activity is starting and then is lost thereafter. And so you may see fetal cardiac activity at one point and then you don't after that. It could be from an abnormality that occurs within the uterus. Again, is this from infection? Is it from a weakening of the cervix? It's not entirely clear all the time. But sometimes what happens is patients, even early in their pregnancy, have a dilation of their cervix that occurs where the dilation is too much to be able to sustain the pregnancy throughout the rest to term. Sometimes they have premature rupture of membranes, which means the amniotic sac breaks. And so you no longer have the amniotic fluid surrounding the fetus. And that could happen too early where even at that point, there's no lung development that's possible. In those last two situations, those are called an inevitable spontaneous abortion because it's nearly always likely that the pregnancy miscarries.
And does fetal cardiac activity always stop during a miscarriage?
No, not if sometimes when the tissue is in the midst of passing, and again, that could be fetus and placenta. But again, in these statements or situations that I mentioned where you could have advanced cervical dilation early on or premature rupture of membranes, fetal cardiac activity might not have stopped yet at that point. And that's what we're most concerned about. We do understand the bill stating that if there was a fetus without cardiac activity, that we could remove it and provide care. But it's these situations, because it's not black and white, it doesn't always happen at once. It's these complex situations where you still have cardiac activity, and yet something is occurring where it appears that miscarriage is likely, or that the fetal prognosis is very poor. And it's unclear whether we can proceed in that point, because fetal cardiac activity is there. And if the bill is talking about not being able to proceed after fetal cardiac activity is present, it makes it a confusing picture.
What is the standard of care to provide when a patient is miscarrying?
So depending on the clinical circumstances, you can offer expectant management, which means that the patient just allows the process to naturally happen. If they don't want to wait for that, or if you feel like there's a greater risk in waiting medically, then you can also offer active management with medication or surgery.
And what do you base that standard of care on?
So our national organization, the American College of Obstetrics and Gynecologists, that again provide practice bulletins about abortion care or about miscarriage, early pregnancy loss care, and PPROM, the premature rupture of membranes that I mentioned before.
What's the standard of care for counseling a pregnant patient for whom continuing the pregnancy poses a risk to their health, but which is not currently an emergency?
So it's important to explain all of their medical conditions that would pose a risk to them during pregnancy, and especially if it's significantly increased by the pregnancy itself, and make sure that you talk about all of the conditions. So for instance, if someone has high blood pressure and diabetes, that you talk about both, and provide them the likely risk that they would have serious complications and the risk of death, and give them their choices, with which to make a decision either to continue the pregnancy or not.
I'd like to pull up Plaintiff's Exhibit 1 and turn to page 4.
Before we do that, I think this is a natural, you paused just long enough. I forgot, we all may be fine, but stenographer April needs to stay alive during this process. We don't want her to develop a serious medical condition. So we're going to take a brief break. I've already paused your timer just to allow everyone to refresh. I'll be back out according to that clock on the wall, which may not be standard Eastern time, but it's what we go by, 11:21-ish. So about 5-6 minutes. And we'll see if our stenographer can go until lunch break after that. So be at ease. You're at 5:11:52. Thank you.
Unless you need to go back.
No, I did before.
Unless you need to go back.
Oh, okay.
Yeah.
Okay, just think, yeah.
I know. Yeah, I'm fine. Thanks. Thank you for checking.
Oh, really?
I will avoid
Yeah, that should be fine as long as. Yeah, and we'll let you know. It's not fun.
Marshall here in the last hour.
Yeah, I think that's, is this okay?
Thank you.
I am, thank you. I'm good, thanks. What? Hi, nice to see you. You're doing great too. Okay.
Welcome, nice to see you. Nice to see you.
Wait, you said it's called? One second, we're not on the record yet, and I want to check in with stenographer April anyway. But Deputy Gordon let me know that there are others who want to fit in here. There's no room. So two things. One, there is a live feed of everything that's happening. So if you have colleagues who want to come in and don't fit, if you go to the Superior Court of Fulton County main webpage, there's across the top, it says live video feeds. Click on that, go to Judge McBurney, and I can wave to the people right now. This will be streaming throughout, but we're also going to try to activate the screen that is right outside the courtroom. It will at least show what's going on. That'll be pretty boring. But I think there's audio. We're going to try to make that happen. And then we'll keep pressing on. So just give me a second. Can you check Deputy Gordon to see if it's on and if any noise comes out of it? Hello, Deputy Gordon. Excellent. All right. There's that too. We are here to please. Stenographer April, are you doing okay?
I am, Your Honor. Thank you.
Did we break in enough time or was it getting kind of dangerous?
I took my Motrin. I'm good.
All right. If you were in the same room, you'd be safe because I think we've got about 20 doctors in the room, but you're wherever you are, they cannot render aid other than that weird teleconsulting thing. We're like, yeah, just push really hard on the cut and you'll be all right. I found that to be real helpful. All right. We are going to pick up where we left off, which was somewhere in the direct examination of Dr. Swiak, and I will resume the timer once you ask your next question.
Great. I'd like to pull up Plaintiff's Exhibit 1 and scroll to page 4, please. One more, I think. Just to look at the medical emergency. Great. So let's pull up the medical emergency exception. Dr. Swiak, do you understand this exception to allow OBGYNs to offer an abortion to a patient for whom pregnancy poses a risk to their health, but has not yet become a medical emergency?
Well, it's not, the language isn't clear, especially because we might see a patient in her first or second trimester before something has developed, before a condition has worsened, before a complication has developed, certainly before a medical emergency may have developed, because as I mentioned, these things, the risk just increases as you go in pregnancy and even immediately after pregnancy. And so it's not clear, again, by the language that I can act just based on increased risk alone because they use the term medical emergency.
There is a phrase in that first sentence of, it's actually A3 of 1612-141. For some reason, we're still using the act rather than actual law. But that first sentence, it refers to the substantial and irreversible physical impairment of a major bodily function. And it's those last three words that I want to ask you about. You told me that serious complication, that actually has some currency, general understanding of meaning in the medical profession. Major bodily function, is that a term of art? And you know right away, that's the digestive system or something at that rank? Or is that a legislative term and you are left wondering, I don't know, is vision a major bodily function? You only lose one eye, that's not major. How do you process that
Well,
as a doctor?
it's not that it's entirely a legal term and not a medical term, but it's vague. And so the intention of what is included in major bodily function is just not clear.
It's not, they don't teach in medical school. There are 5 major bodily functions. Everything else is minor.
No,
Okay.
it's not that cut and dry.
All right. I mean, I know you have lots of lists, but that's not one of them.
No.
Okay.
And I'd actually like to focus on some of this language as well. Are you aware, Dr. Swiak, of any clinical guidelines as to what conditions would make an abortion necessary to prevent substantial and irreversible impairment of a major bodily function?
Can you ask the question again?
Sure. Are you aware of any clinical guidelines that would sort of elucidate what this means or how doctors are supposed to act in accordance with it?
Well, the clinical guidelines that I follow and the people in my profession follow from the Society for Family Planning, the Society for Maternal Fetal Medicine, from ACOG, they again don't put lists, and so it's never presented as so black and white, especially when we understand that this is happening on a continuum where a person is impacted as the pregnancy progresses and after delivery and for the next year after pregnancy and potentially longer than that. And so it's the problem with interpreting this is that it's hard to understand, like, does this mean prevent the death immediately or within the next year, and same thing with like physical impairment, like, and the fact that the bill has as the consequence criminal prosecution, if you have a different interpretation than the legal interpretation, that's very distressing to physicians, because we want to be able to understandably base our counseling and our decision-making on medical risks and what our medical judgment is, but not how legally that might be interpreted. And then, like I said, unfortunately, in this case, lead to our prosecution criminally.
You mentioned some national guidelines around providing abortion care, and I'm curious if you're aware of any Georgia-based guidelines or guidance around the scope of this exception.
Well, again, not guidelines per se, nothing written that we can refer to. The Georgia OBGYN Society that represents and is a membership organization of Georgia OBGYNs provided a webinar for its members, because there was such widespread confusion among the providers in the state as to what to do in order to be compliant with this ban. And so in an effort to provide guidance, GOGS held a webinar, and I was on it was a Zoom webinar. I was on there, and at least 80 people were attending.
And did they discuss just clinical situations in that webinar?
Reviewed the bill, what the bill states, and then, yes, some clinical situations and how one might be able to proceed and still be compliant with the bill.
And what were some of those scenarios that were discussed?
So talked about the premature rupture of membranes, as I mentioned, fetal anomaly, and the medical emergency circumstance.
And did that webinar clear everything up? Did you come away with instructions?
No, it didn't. Again, they're trying to provide guidance to their members, but even in that situation, there was not clarity.
And so now, if you are faced with a situation where you are unsure if you can provide care, how do you approach deciding what to do?
So if there's another primary provider that's been involved primarily in the prenatal care for the patient, then I certainly work with them to make sure that I have all the information. We work with maternal fetal medicine, again, the specialists, those that specialize in high-risk pregnancy. We might work with the neonatologist if there's a question about the survival of the fetus or the prognosis for the fetus. If needed, then we consult our Office of General Counsel to determine, again, are we legally compliant and going to avoid the risk of criminal prosecution? And then if there are ethical questions involved, then we involve the ethics committee.
And you mentioned that you talk through the prognosis for the fetus. Do you talk through the status of the pregnant person?
Certainly.
Do you consult any literature?
Yes. So again, trying to parse out what constitutes a medical emergency, what is more likely to be interpreted that way rather than not, medical futility, which again, not a medical term. So like trying to figure out like what is more likely to be considered a medically futile condition or not. Then we consult the literature to see what the risk of mortality with that particular condition is. So whether it's maternal condition, and we're looking specifically at maternal mortality and morbidity being the serious complications we talked about before, or whether it has to do with the chance for fetal neonatal survival.
And while you're having these conversations, talking to the GC, talking to other providers, what's happening with the patient?
So certainly if it's a medical emergency, the way that we in the medical profession typically see that, like a patient is in distress in front of us and it's an urgent or emergent situation, we're going to act. So a patient is, again, I'm going to go back to the rupture membranes. A patient has that rupture membranes and then develops sepsis, significant, infection. A patient has pre-existing hypertension. Now they have a hypertensive emergency where they're at great risk of stroke. Then we proceed in those situations if the termination of the pregnancy is going to alleviate the emergency. But if there's not an obvious medical emergency as we typically define it in medicine, then we're taking time to determine all this information and the patient is waiting without an answer.
Does their condition change over the course of your deliberations?
It could, certainly. I mean, that's what we're always worried about. Are we acting in enough time? And again, it's a little more clear cut when you have like an urgent situation or emergent situation in front of you. When it's not so immediate, I can't predict exactly when a condition will worsen, when a complication will occur. I have some statistics that gives me an idea about when, but particularly for that patient, I wouldn't know. And my job is to prevent complications. The guidelines that I look at, that I follow, as I mentioned before, from ACOG, from SMFM, SFP, they're really guided to use the medical literature to provide the safest care, to prevent complications, to prevent emergencies. And virtually nowhere does it say, sit back and wait for an emergency to occur. So it's hard to, it's really hard to tell a patient that you would like to provide them medical care, but unfortunately they're not sick enough.
And just to clarify for the record, when you say SMFM, do you mean the Society for Maternal Fetal Medicine?
Yes.
I'd like to turn to the next topic. You said that you reviewed the state's experts' affidavits in this case. And Dr. Coleman suggests that survivors of rape are unlikely to become pregnant. Is there any reason to believe that pregnancy is less likely to occur from rape than it is from consensual sex?
Well, naturally occurring pregnancy without assistance requires penile vaginal intercourse and the sperm and the egg coming together and a number of physiologic steps in order for those to fertilize, fertilization to occur, and for implantation to occur. All of those physiologic steps do not change based on the intention of one of the participants in the act itself. It does not change whether it's consensual or non-consensual. It doesn't change whether based on somebody's emotional state at the time. So there's no reason physiologically to expect that pregnancy would be less likely from an act of non-consensual sex versus one of consensual sex.
Have you cared for patients who have been survivors of rape?
Yes.
How do you counsel those patients?
So it's important to assess what their condition is at the time. How much distress are they in? Are they actively feeling like they're in an unsafe situation? Are they actively experiencing trauma and any medical or mental impacts from that? If they want to pursue involvement of law enforcement, if there's anything else that we need to take care of in respect to their healthcare, like did they receive testing for sexually transmitted infections after the assault, things like that. And then if they are pregnant, we provide them options counseling, what they think they'd like to do about the pregnancy.
Have you encountered patients who have wanted to report to the police?
Yes.
And what do you do in those situations?
So if they have, typically they have started the process already, but if they haven't, then we can connect them with resources directly to law enforcement.
And have you encountered patients who didn't have a police report or who said that they did not want to report their rape to the police?
Yes.
And what are some of the reasons that those patients give?
It could be because they themselves feel threatened by the idea of involving law enforcement, either because of the perpetrator or perhaps because of the judgment they may feel from family or friends around them. Some of them are in a state of trauma so that they really feel like it's important for them to accomplish one thing at a time. And others just have personal reasons for not pursuing it.
I'd like to talk a little bit about medical training now. Are graduate programs required to meet certain standards to be accredited?
Yes, per the ACGME, which accredits all training programs in medicine.
And does ACGME stand for Accreditation Council for Graduate Medical Education?
Yes.
And does the ACGME set particular standards for obstetrics and gynecology residency programs?
Yes.
Does it have standards relating to training in abortion care?
Yes, there are a minimum number of cases that residents must train in.
And is Emory accredited by ACGME?
Yes.
I'd like to pull up Plaintiff's Exhibit 32, please. If we can turn to page 1, please. So at the very bottom, Dr. Swiak, as of what date are these guidelines effective? It's kind of similar.
This was September 17th, 2022.
Okay. And if we could please turn to page 30. Thank you. So in that top box, the very last paragraph there beginning obstetrics and gynecology residency programs, could you please just read that aloud, Dr. Swiak?
Obstetrics and gynecology residency programs may be located in jurisdictions where induced abortions are unlawful. Residents who do not opt out of clinical training in induced abortion must receive support to obtain clinical experience in induced abortion in another jurisdiction. Depending on the circumstances, support may require financial, logistical, educational, and/or other resources. If a program in partnership with its sponsoring institution fails to provide support for this clinical experience or penalizes residents who receive such support, the program will be considered non-compliant with the requirement.
What does this mean for the OBGYN residency program at Emory or such programs in Georgia if abortion is unlawful after approximately 6 weeks?
So restricting abortion to occur only under certain circumstances will decrease the educational experience of the residents. And if they cannot, for any program in Georgia, if they cannot meet the minimum requirements, then that means you need to provide the out-of-state training for that resident.
And on a practical level, what does that look like for the residency program? We'll start there.
So if you're a resident, and like I mentioned, there are 9 residents a year in our program, you have a job. And so your job is with your 9 colleagues in your year to cover the schedule and to assure that you get the training that you need over your 4 years of obstetrics and gynecology training. And the hospital or the several hospitals that you work at pay your salary for you to be able to provide clinical care under those circumstances. So if you then need to leave the state for a rotation, typically 4 to 5 weeks, depending on the program. If you then need to leave the state, that means that you need to leave your job, your home for a month, depending on what's happening with your family. Do you take your family with you? Do they have to stay, in the state? We have to arrange housing for them while they're out of state. And then they're leaving that schedule. And so their colleagues need to cover the job without them. And then our program needs to cover the salary without them, because obviously they're not working in the hospital within Georgia. So we need to cover their salary and then need to cover, as I mentioned, the costs of them going out of state.
Are you involved in recruiting OBGYNs to Emory?
Yes,
Has the ban affected your ability to recruit OBGYNs?
I believe so.
How so?
So every year for our fellowship, as I said, we have 1 fellow per year. We work with a national program to get applications, and then we review those applications, invite people for interviews. They come interview, and we do a computerized match to determine who our next fellow is. And it's our number of applications has been fairly consistent over at least the last 10 years, I would say, for our fellowship, and this year it was half. I can't say that that's the cause, but it was the one thing that was drastically different this year as opposed to other years. We also had people that canceled their interviews once the bill took effect. And I've had anecdotal conversations with students and residents and fellows, as well as faculty that are interviewing for positions within the state about the implications of the bill.
And in your opinion, if Emory and other Georgia schools are not able to recruit OBGYNs, how will that affect, if at all, healthcare in Georgia?
Well, the majority of practicing physicians in Georgia do train within Georgia. And for OBGYN, right now, about 50% of counties in Georgia don't have an OBGYN at all. And so anything that impacts our ability to recruit competitive applicants to Georgia is likely to impact the number of physicians we have practicing in Georgia. Anything that impacts the ability of current physicians to practice according to medically sound and ethical standards of care within Georgia will impact their decision to stay or not. In fact, that's why the Medical Association of Georgia also, along with GOGS, did not support this bill because they believed it would further decrease the number of OBGYNs practicing in Georgia.
And one last question for you. Dr. Swiak, why do you provide abortion care?
You know, pregnancy is a significant life event in someone's life, and the decision whether to be a parent, give birth to a child, or not, is a deeply personal decision, and it really is best made by a person that can incorporate their own beliefs and their values into that decision, into that life decision. Because it is also a medical decision, it's best to be guided by a physician or a healthcare provider. And so I want to be able to guide people in that decision so that I can assure that they're able to make a fully autonomous decision, and one that, whether it's for medical indications as we talked about, or for social indications as I talked about, you know, one that will significantly impact their lives. And what continues to sustain me in providing abortion care is just the tremendous gratitude that people have when they tell you how much you've changed their life and saved their life. And so that's why I continue to do that.
Thank you. I could just have a moment with co-counsel.
Sure. While Ms. Chan is huddling with counsel, I have a quick question for you after
Yes.
you freshen up.
Me too.
So in preparing for today and reading all the many things that have been submitted, I understand the viability line that is drawn, after which medical science has evolved such that the fetus could survive as a baby outside the womb. That's at whatever number of weeks it is, well past 6. Is it ever studied, is this crazy science about whether before the viability date, the fetus could survive in a different womb? Sort of like, you could take my kidney if you needed a kidney, and my kidney would survive in you. In fact, you might need it if your 2 kidneys stopped working. So we do kidney transplants. Is there any ever research about whether the line for viability could actually be lower because there is a fetal transplant?
So there's been research about uterine transplants. So if you lost your uterus for some reason and wanted to carry a pregnancy, that they could provide a uterine transplant. I don't really know the data on that, like where they are in that science. It's certainly not to the level where we can offer it to our patients.
So the sole measure of viability would be, could, through incubators and breathing tubes and all the other things, could doctors keep the child alive after removed from the mother? There's not a, we could put it somewhere else in, the mother dies in a car accident, but we can save the fetus, but only if we could put it in the mother's best friend's womb.
Yeah, not at this time. And when you think about that line of viability, I think it is hard to put a specific number of weeks on there because, again, you are talking about the totality of the pregnant person and their fetus. So not only what the gestational age is, what's the underlying medical condition, what is the underlying fetal condition if there is one, what's their growth been like what's the prognosis, and then you have to think about, is survival possible and at what cost?
Right. What survives and in what condition?
Yes.
Understood. But I'm not missing some advancement in science in thinking about viability as the line that scientists, medical professionals have drawn of, we think we could keep this child alive after it is removed from the mother for whatever reason, emergency, the mother passes, whatnot, at a certain point. And you're helping me understand it's a variable. It's not 21 weeks and every kid is the same. Every fetus is the same at that point. I appreciate that there's always going to be gradations, but there isn't some line of inquiry where people think actually it's many weeks lower. It really is up to tubes and doctors keeping the child alive after it's removed from the womb. That's what we've got.
So currently, no, but let's just think about what if it were? I mean, what if we were in a situation years from now, right? Hypothetical situation that were the case. We're still going to talk about what are the benefits, what are your options? What are the benefits of each option available to you? What are the risks of each option available to you? Can I provide the information to my patient so that she can make her own decision based on what is most important for herself and her family? That doesn't change regardless of whether you have this new technology that's available.
Okay, thank you.
Thank you.
Did you have anything else? No, okay. I'm trying to recall how we were going to work this. Certainly the state can cross-examine now. There was some discussion about maybe it was, we're not doing rebuttal. There was something that you all were going to handle in written submissions later. Let me stop your timer while we do that.
Your Honor, I think the understanding was that our witnesses would only be called once so
Got
that
it.
they could address, and I heard Dr. Swiak address part of Dr. Coleman's report
Great.
as well. So that she'll only be on the stand this morning.
This one time.
Yes.
Then let's hear from
Session
the
of this afternoon.
Okay. Let's hear from the state.
Counsel, will you please identify yourself for me before you start?
I sure will, I promise.
He's just getting situated, brought up a lot of pieces of paper.
Georgia Pacific needs to have a good fiscal year. Good afternoon, Dr. Swiak. I think we've crossed into afternoon now. My name is Chris Bartolomucci. I'm one of the lawyers for the state of Georgia, the defendant in this case.
Good afternoon.
When you were speaking with Ms. Chan, I believe you testified that over your career, you have the number of babies that you've delivered is too many to count. Was that your testimony?
Yes.
Well, let me ask you a similar question. Over your career, how many abortions have you performed?
Well, for me, that's a different question because that is my area of subspecialty is abortion care and contraception care. I would say that that would be at least in the thousands.
Okay, so then you've performed more abortions than delivered babies. Is that fair to say?
It's likely.
Likely. Okay. Now, in the year 2021, so last year, approximately how many abortions would you estimate you performed?
Probably like 500.
Now, has the Life Act, since it took effect, has that increased, decreased, kept the same, the number of abortions you perform in a typical month?
So it initially significantly decreased the volume. And right now it's probably about, for all of the locations that we work at, it's probably about 50% what it was before, 50% or less.
And how about you personally? Are you performing 50% fewer abortions than before the Life Act?
I'm including myself in that because I'm working in those same locations as my other colleagues.
Okay,
I'm sorry. The way you answered the question was initially, and there was a great drop off, but now you're saying you're at 50%. Was it greater than 50% drop off initially, or we're still in the initial period?
Initially, it was significant.
More than 50%,
More than 50%.
which also sounds significant.
Sorry.
That's okay. I just want to make sure I'm following.
So a significant decrease where, you potentially had a handful of patients presenting per day, or that were able to receive their abortion per day and the rest having to leave.
But
And I would say it's leveled off a little bit, but it's still, maybe it's back to 50%, but I don't think so, even that.
so steep cliff drop off, but it's begun to climb back up, and you're sensing that it's sort of stabilizing. I understand it's still early at basically a 50% reduction from what volume you saw before.
Well, but also understand that I'm not looking at the total volumes of all the providers in Atlanta.
Just
So
yours.
I'm just thinking about my own personal.
I think that's what the question was.
Okay.
Thank you.
now the Life Act went into effect in late July, is that right?
Yes.
So when you say initially, are you talking about a period of weeks or a month? What did you mean by initially?
So we were told immediately that all abortions needed to cease.
And who told you that?
We were informed by,
Objection, I'd like to just make sure, remind Dr. Swiak not to disclose anything, that our conversations are privileged. So just a reminder there before we delve too deeply into this conversation about who said what to who on that day.
Okay. Mindful of that, you want to refer, the question's fine as long as we aren't breaching any privilege.
Without piercing any protected attorney-client privilege, can you tell me who told you that you had to stop performing abortions?
so we were already working with our Office of General Counsel to assure that we are compliant with this bill. And so I believe it was primarily from their office, as well as my boss.
Now, is that instruction the reason or part of the reason why there was a sharp drop off in the initial period in the number of abortions?
I don't know the reason for that. That's part of it, yes.
I mean, you were told not to perform abortions, correct? You have to give a verbal answer.
Oh, yes,
And so you didn't perform abortions, correct?
yes.
But at some point you resumed the performance of abortions.
So on that day, we were told that the bill went into effect. And therefore, even patients that already were on the schedule to be seen could not be seen if fetal cardiac activity was detectable. So there were a significant number of people that were told that either their procedure was canceled, or that once they got to the clinic that they would not be able to have their procedure.
How long did this initial or temporary period last before you got to where you are now?
I'm not sure I understand what you're asking.
Well, you testified that you received an initial instruction not to perform abortions, right?
We received the instruction. So I apologize. Let me clarify. We received the instruction that the bill was in effect immediately. It was not to stop providing all abortions. It was to stop providing abortions, that the bill was in effect, that we couldn't provide abortions after fetal cardiac activity was detected.
So the instruction was comply with the new law.
Yes,
Okay. And so there was an initial dip, and then the place you are now is a 50% reduction over the abortions being performed before the effectiveness of the Life Act. Is that
again,
fair?
that's an estimate of what I see.
okay? All right. Now, when you as a doctor are caring for a pregnant woman who is seeking to give birth, she is your patient, correct?
Yes,
And because she is your patient, you have certain professional and ethical responsibilities to her. Is that true?
yes,
So in this scenario, the pregnant woman seeking to give birth is your patient. Is the unborn child also your patient?
so in this situation of a person choosing to continue their pregnancy, she is primarily my patient. The pregnant person is primarily my patient. But I also consider any impact of recommended treatment on the health of the fetus and what the fetus needs in terms of testing throughout the pregnancy.
So you give consideration to the needs of the fetus, but do you consider the fetus to be your patient along with the pregnant woman?
Again, I consider the pregnant patient primarily my patient, and I need to consider her fetus as well, but it's not.
Is the fetus your patient secondarily?
I don't know if I've ever thought about it in that way.
Well, you said the woman is primarily your patient. I'm wondering what you mean by primarily. Is the fetus your patient, but less than the pregnant woman?
Again, because of her intention to continue the pregnancy, I recognize that the development in the uterus of her fetus is going to impact that fetus and their health once they're delivered. And so, yes, secondarily, I would consider the needs of the fetus.
So in considering the needs of the fetus, do you view yourself as having professional and ethical responsibilities to the fetus? And again, this is in the scenario where the pregnant woman, wants to give birth.
When I consider my ethical responsibilities, again, that is primarily focused on the pregnant patient. In fact, if I was in a medical emergency, if the patient in front of me, the pregnant patient in front of me had a medical emergency, ethical and evidence-based guidelines state that you focus on the pregnant patient, stabilize the pregnant patient first, and then consider what's happening with the fetus.
I'm just reflecting back though on conversations that your counterpart would have had with me and my wife, and there were all sorts of admonitions: don't drink and don't do this or that. Partly maybe because it's not great for the mother, but mostly because it's not great for the fetus. And that advice seemed to be given because the doctor was focused on the health, well-being, and welfare of the fetus, perhaps secondarily to the patient that the doctor could interact with. But does that come into play with your interactions with a patient who has told you, I'm excited about this, child grown within me, I want to bring it to term?
Certainly. So part of her is the fetus. And so, and her intention is to have a healthy live birth. And so it's therefore partly, that's part of the decision-making that I make in my ethical responsibility to her.
Now, if your patient is a pregnant woman and she wants an abortion, in that scenario, is the fetus your patient at all?
Well, if If it is pre-viability, then the pregnant patient is again primarily my patient. And if it's post, then I will counsel based on the benefits and the risks of each option as it applies to her and the fetus.
So pre-viability, if a pregnant woman wants to abort the fetus, you don't view yourself as having any ethical or professional responsibilities to the fetus. Is that true?
Again, the pregnant patient is primarily my patient, and I focus my counseling on the benefits and the risks of the pregnancy and what it's doing to her.
Okay, so you submitted 2 affidavits in this case, right?
Well, yes.
Okay, and in your first affidavit, which I believe is DX5, you said in paragraph 16 that according to the Centers for Disease Control, there were 20.4 maternal deaths per 100,000 live births in the United States between 2018 and 2020. Is that what you wrote in your affidavit?
Can
You're allowed to object and interrupt if that's not an interruption if you've got a concern.
I just didn't want to interrupt Dr. Speck, Your Honor. I was going to ask that the exhibit be brought up, but I believe she was asking the same thing.
And there it is.
Defense exhibit in action.
So Dr. Swiak, in paragraph 16, you wrote that according to the CDC, there were 20.4 maternal deaths per 100,000 live births in the United States between 2018 and 2020. Is that correct?
Yes.
And I don't think you included the number for Georgia in your affidavit, but I heard you testify on direct that the Georgia number was, did you say 25?
Yes.
Okay. Now help me with the math here, because I went to law school because I don't do math. If for every 100,000 childbirths, there were 20.4 maternal deaths, does that mean that for every 100 births, there are fewer than 0.002 deaths?
Per 100 live births, I'd have to do the math a little bit myself as well.
You should probably stick to not math based on that question.
Yeah, the rate is less.
I'm just trying to change it from 100,000 to 100. If you study 100 childbirths, is the risk of death less than 0.002?
Your Honor, I don't think Dr. Swiak needs to be doing math on the stand.
This is her affidavit.
What's your objection? I don't know that no math objection is a.
She's already stated that there were 20.4 maternal deaths for 100,000 live births, and I'm just questioning the utility of having her do mental math on the stand. What I'm
Question
But
utility.
he has her on cross, he determines utility. I'll observe that his math is off. And so we're not going any place real helpful. You have moved the decimal too far in the direction you're trying to move it. But either way, there would be less than 20 deaths per 100 live births. There might be 0.02, but
Okay, I'll accept 0.02. And again, I said I'm not good at math.
you proved it.
Now, Dr. Swick, you testified that serious complications from abortion were less than 1%, correct?
Yes.
And therefore you characterize that as very rare?
Yes.
Now, would you also characterize the number of maternal deaths from childbirth to be very rare?
Yes.
Now, in September of 2020, you were interviewed by Mina Kim on National Public Radio, right?
I don't recall if that's exactly when it was. Yes.
Do you recall being interviewed on National Public Radio?
Yes.
And the topic was abortion, correct?
Yes.
Now, do you recall saying in that interview that, quote, it is infinitely safer to have an abortion than to have a live birth, end quote. Do you remember saying that?
So right now, without a transcript in front of me, I can't say that that was my exact quote. But it is many times safer to have an abortion than to have a live birth. And we've shown the statistics here.
Well, I think we're going to be able to play a clip from that interview. We're going to try this. This may or may not work, but Mr. Prince, can we try to play that?
Is it an exhibit so that the record shows what exhibit this is impeachment. It doesn't need to have an exhibit number?
It's not an existing
Okay.
exhibit. No, Your Honor.
Infinitely safer to have an abortion than to have a live birth. And when you're talking about an unintended pregnancy.
So Dr. Swiak, is that your voice we were hearing?
Yes.
And so was your quotation infinitely safer to have an abortion than to have a live birth?
Yes.
Okay. Were you exaggerating there, or do you believe that it's infinitely safer to have an abortion?
I was not exaggerating.
Okay. So do you counsel your patients who are pregnant that it's infinitely safer to have an abortion than a live birth?
I explain to my patients that the risk of death from abortion is less than 1 per 100,000, whereas the risk of death from childbirth is much higher than that. And if I said the specific number to them, for Georgia, I would use 25 deaths out of 100,000.
And that fits within your definition of abortion being infinitely safer?
Yes.
Now, are there circumstances in which an abortion is medically necessary to save the life of the mother?
Yes.
Are there circumstances in which abortion is not medically necessary for a pregnant woman?
Yes.
In those circumstances in which abortion is not medically necessary, is carrying the pregnancy to term a high-risk option?
Well, as I mentioned, there are conditions that develop only because of pregnancy, or the risk factor is increased only because the person is pregnant. So the risk of blood clot, gestational hypertension only happens in pregnancy. Gestational diabetes only happens in pregnancy. And so even without a medical necessity related to the abortion, specifically, that person has a higher medical risk with an unintended pregnancy if they carry the pregnancy to term.
Did you just say higher or high risk?
Higher.
Okay. When abortion is not medically necessary, is carrying the pregnancy to term considered a low risk option?
I would not consider it a low risk option. No.
Let's bring up your affidavit at paragraph 22. Now, do you recognize this as being from your affidavit?
Yes.
And you said that embryonic cardiac activity is generally detectable via ultrasound starting at approximately 6.0 weeks LMP. Is that right?
Yes.
All right, let's move down to paragraph 23. Now, here you wrote that in the state of Georgia in the year 2019, 43.6% of abortions occurred at or before 6 weeks of pregnancy. Is that right?
Yes.
And you were talking about induced abortions, right?
Yes.
Now, the 43.6% of women who obtained an induced abortion in Georgia in 2019 at or before 6 weeks of pregnancy, they obviously knew they were pregnant, right?
At that time, yes.
At that time. If we could put up paragraph 37 of your affidavit. Now here you wrote in part that the risks associated with abortion increase as pregnancy advances. Is that a true statement?
Yes.
So abortions are safer the earlier they are performed. Is that true?
Yes.
Do the risks of abortion include infection?
Yes.
Do the risks of abortion include excessive bleeding?
Yes.
Do the risks of abortion include incomplete abortion?
Yes.
What is incomplete abortion?
That is when some of the tissue is removed, but not all of it is removed.
And how is an incomplete abortion treated?
Either with medication or surgery.
Do the risks of abortion include the possible death of the mother?
Yes.
Do you advise your pregnant patients that serious injury or death is a risk of abortion?
Yes.
Have you advised abortion patients to return to see you for a post-abortion follow-up visit?
If necessary, yes.
In cases in which you have provided that advice, do some of your patients fail to return for a follow-up visit?
Yes.
Do you know approximately what percentage or what rate of your patients don't come back?
No.
For the almost 44% in 2019 who had abortion before 6 weeks, would that procedure have been taking Plan B, some kind of medication, or is there actual surgical intervention? I don't know when that cutoff occurs, when it is medication induced versus, you said there are two types, medication induced and surgical intervention. So week 4, week 5, up until week 6, 44%. What would the procedure be that the woman would have undergone?
So that 43% is at or less than 6 weeks.
Okay.
So when we talked about before, we could be up. So at that point, you can provide either medication abortion or surgical abortion safely.
Okay.
And Plan B is not an abortion.
Okay. And I don't mean to muddy the waters. It's the patient's choice. If it's 5 weeks, the patient comes in and look, you can take medication or we can do this procedure, or it's dictated by the patient's condition.
Most of the time, they are able to make that choice. And sometimes there are certain medical conditions that they have that contraindicate. So make it a very risky choice for them to choose one versus the other. And sometimes it's relative. So we may encourage them to choose the safer option, but they perhaps still could choose the other option.
Sure. And in your experience, do most women choose a medication-based procedure or a surgical procedure? Again, we're talking about 6 weeks or earlier. Or is it 50-50?
I'm not sure about 6 weeks or earlier, but in general, if you look nationally at all people who have the optional, they're eligible for one or the other, then it's about 50-50.
Your Honor, I have an impeachment exhibit that may I approach the bench,
Sure.
pass a copy to you and the witness?
Thank you.
So Dr. Swake, I've handed you a book called Managing Contraception. Are you one of the co-authors of this book?
I was for this edition, yes.
Okay, this is the 2010 edition, right?
Yes.
Okay, and actually, if we move into page, I think, III, we'll see your name. There we go. You're the third name down on this page, is that right?
Yes.
Okay, I would request to move this exhibit into evidence.
What number do you want to give it so that in the future it can be referred to?
I believe we're up to 521. 521.
So I've got up to 524 in the list you gave me. So I think you'd be safer to go 525 or even 530 or 600, just so you build the gap.
Let's go with 600, Your Honor.
All right, for 600. Exhibit 600 is now before you, Dr. Swiak. And any objection to its admission, Ms. Chan? It's admitted.
Now, if we could turn to page 27, and Dr. Swiak, I tried to crumple that page to make it easier for you to find it.
Crumple.
And we're going to bring up page 27. There it is. Now, Dr. Swiak, in this chapter, you're talking about home pregnancy testing, right?
That's what this chapter is talking about, yes.
Okay. And under the heading pregnancy tests, I believe it's the fourth bullet. You've indicated that home pregnancy tests can detect pregnancy 7 to 10 days after conception. Is that right?
After implantation.
After implantation, okay. And when does implantation occur relative to conception?
About 3 weeks after.
So we're at four weeks-ish when the tests are positive for 98% of the women.
So you have your last menstrual period. Conception for someone, again, who has regular menstrual periods will happen for the most part roughly 2 weeks after that. And then if 3 weeks later implantation occurs, then you're at 5. But the other way to think about it is that urine pregnancy tests are, like if we think about the active intercourse, that they can be detectable as early as 10 days, but typically 14.
After implantation?
After conception.
After conception.
Yeah, I want to go back to the sentence. You say this level can be detectable 7 to 10 days after conception. Is that what you wrote?
So I did not write this chapter. I am a author of this book. And so I did not write every chapter. And I also was not the editor of every chapter. Each of us co-authors had sections of the book that we wrote.
Is this sentence I just read a true statement?
So again, I would say 10 to 14 days after, but again, about 10 days after conception.
You're not that far apart.
Yes.
Okay.
And the next bullet indicates that home pregnancy tests are 98% accurate 7 days after implantation. Is that right?
Yes.
Now, since this is the 2010, 2012 edition of the book, have home pregnancy tests become better in the last decade?
It's about the same in terms of their accuracy, their sensitivity.
Okay. Okay, we can take down that exhibit. And shifting gears a bit, this case is not the first time that you have been a plaintiff in a lawsuit against the state of Georgia seeking to challenge an abortion statute.
That is correct.
In a case called Lathrop versus Deal, you were one of the plaintiffs in that case. Is that true?
Yes.
Your Honor, may I approach to hand out another impeachment exhibit?
Sure. If you've got a host of them, if you could just bring them all up at once, that way we don't have to have the back and forth. Unless that's going to throw off your.
I can do that if we take a 1 to 2 minute break so I can reorganize the paperwork?
If they're organized in a, let's come up each time, you can do that. You just don't need to ask each time.
Okay.
Approach us as you see fit.
Approaching now, Your Honor.
All right. You don't even need to announce. We'll see it. See it coming.
I wanted the stenographer to know what was happening.
Okay.
Now, do you recognize this document, Dr. Swick?
Yes.
And what is it?
This is the, our statements from our complaint from the 2019 case.
And you're listed as one of the plaintiffs in this case, correct?
Yes.
Okay, I would move this into evidence as 601, I think.
Any objection? 601 is admitted.
Now, the other two plaintiffs in this case were Ava Lathrop and Lisa Hadid, doctors, is that right?
Yes.
And they are also plaintiffs in this case with you today, correct?
Yes.
And in the Lathrop case, you and your co-plaintiffs sought to challenge HB 954, a statute enacted by the Georgia legislature, is that right?
Yes.
Thank you.
Dr. Sweet, do you recognize this exhibit?
Yes.
And what is it?
This looks like the bill that was passed. The
Meaning-
House Bill 954 that was passed.
Thank you. I would move its admission as 602.
Yes, sir. Any objection, Ms. Chan?
No objection.
Admitted.
And Dr. Swick, HB 954 generally prohibited abortion at 22 weeks LMP or 20 weeks post-fertilization. Is that right?
Yes.
Now, the plaintiffs in the Lathrop case took the case all the way to the Georgia Supreme Court. Is that right?
Yes.
And do you remember what the Georgia Supreme Court's decision was?
So I don't remember the specific sequence of events.
Well, let me rephrase it. Did you win or did you lose?
There was an injunction that held the bill up initially from being enforced. And then it eventually was overturned. That's the correct term. So that the bill was then enforced.
So at the end of the day, you and your co-plaintiffs lost.
Yes.
Thank you.
Dr. Swick, do you recognize this document?
I don't.
Okay. If I told you that this is a copy of the Georgia Supreme Court's opinion in the Lathrop case, would you have any reason to doubt me?
I suppose not.
Your Honor, I would request to move this into evidence as Exhibit 603.
Any objection to Lathrop versus Deal, the Supreme Court opinion being made part of the record? Ms. Chan.
No objection. I don't know that it's necessary to admit a case from Georgia, but.
Let's do it.
Thank you, Your Honor.
Exhibit 603. You were one name away from being on a case that gets cited all the time for sovereign immunity. Could have been Swiak versus Deal. Need to renegotiate your.
Everyone would have been mispronouncing.
Yep.
Okay, so let's talk about the Life Act. The Life Act has contains certain definitions, does it not?
Yes.
And why don't we bring this up as DX 001? Am I correct that the Life Act states that the definition of abortion does not include a procedure performed for the purpose of removing an ectopic pregnancy?
I don't recall specifically the language about ectopic pregnancy in here. It's on this page.
I don't think you're going to find it on this page.
But is there a provision dealing with ectopic pregnancies?
I don't recall specifically what this bill said about ectopic pregnancy.
Okay. Is there a provision of the Life Act that says that it's not an abortion to remove an unborn child who has died because of miscarriage or spontaneous abortion?
I see that it includes that.
And the Life Act contains an exception for medical emergencies, right?
Yes.
Are you aware that even before the Life Act, there was an exception in Georgia's abortion statute for medical emergencies?
Yes.
Have you ever performed or approved an abortion because in your judgment, a medical emergency existed?
I'm sorry, say the question again.
Have you ever performed or approved an abortion because in your judgment, a medical emergency existed?
Yes.
Are you aware of other doctors who have made the same judgment?
Yes.
Are you aware of any abortion provider in Georgia who has been criminally prosecuted for performing an abortion where the prosecutors believed there was no medical emergency justifying the abortion?
No.
Now, another exception in the Life Act applies when a physician determines in reasonable medical judgment that the pregnancy is medically futile. Is that right?
Yes.
And that exception is couched in terms of the physician's reasonable medical judgment, is it not?
Yes.
And are you aware that even before the Life Act, there was an exception in Georgia's abortion statute for medically futile pregnancies?
Yes.
Have you ever performed an abortion after you determined that a pregnancy was medically futile?
Yes.
Are you aware of any abortion provider in Georgia who has ever been prosecuted for performing an abortion where the prosecutors believed the pregnancy was not medically futile?
No, because we only act on this in rare circumstances because it's not clear. It's not clear in this bill. It's not clear in the 6-week bill. It wasn't clear beforehand that what medically futile was and what medical emergency.
But however they're defined, you would, I'm assuming from your connections, the network of medical providers who practice in your area of expertise and specialty, if a doctor or nurse working with that doctor had ever been prosecuted because a prosecutor thought, that wasn't medically futile, that wasn't a medical emergency, you would have heard that actually those charges were brought against a healthcare provider in Georgia. Do you agree?
I would think that maybe I would be aware of that, yes.
Okay. I mean, it wouldn't just be news that actually now finally someone had decided to prosecute a doctor because the prosecutor, not being a doctor, had decided for whatever reason, I don't know that that one was so medically necessary, so I'm bringing charges.
It makes sense that I would be aware of that.
And you're not aware of any?
I'm not aware of anything that has happened now.
Council, just a quick request. Would you mind, as you switch back and forth between the two bills, just clarifying in your question which one you're referring to? It's a little bit confusing with the exhibit up on the screen to know which one.
Well, what's on the screen right now is the Life Act.
Okay.
Dr. Swiak, the Life Act has a third exception for pregnancies that are the result of rape or incest. Is that right?
If a police report is available, yes.
Now, would you agree with me that rape and incest are serious crimes?
Yes.
Would you agree with me that prosecuting rape and incest crimes serves the ends of justice?
Yes.
Are law enforcement officers able to investigate a rape or incest if the victim does not cooperate with them?
No.
Let's talk about a couple of your other writings.
Thank you.
So Dr. Swiak, I've just handed you an article titled Abortion Trends in Georgia Following Enactment of the 22-Week Gestational Age Limit, 2007 to 2017. This is published in the American Journal of Public Health in July of 2020. Is that correct?
Yes,
And the principal author is Kelly Stidham Hall, right?
yes,
And you're one of the co-authors?
yes.
You and Lathrop and Haddad, you move in a little trio.
That's right. I should give a shout out to Dr. Lathrop and Dr. Haddad. They are also co-authors of the study, right?
Yes.
Now, if we could flip into page 1036. Under the heading discussion, you wrote, quote, or the study authors wrote, not necessarily you personally, but the study states, quote, we found that Georgia's 22-week gestational age limit appears to have had the intended effect of decreasing abortions at later gestational ages in Georgia after implementation of the policy, end quote. Is that what the article says?
Yes.
And on that same page, the article also states, quote, the number of abortions at less than 21 weeks from LMP remained stable, and there was a marked decrease in abortions in Georgia at more than 21 weeks from LMP, following both the partial and full implementation of HB 954, end quote. Was that one of the findings?
Yes.
Now, based on your study of HB 954, do you believe that the Life Act will decrease the number of abortions in Georgia at more than 6 weeks LMP?
Yes.
If we could go back to the first page of the article. In the middle column, it says, quote, prior to this policy change, abortion was legal in Georgia up to 26 weeks from LMP, representing the highest gestational limit of abortion services in the Southeast and positioning Georgia as a unique point of access to abortion services for people in the region, end quote. Is that what it says?
Yes.
Now, we know that you oppose the line drawn by the Life Act at roughly 6 weeks LMP. And you also oppose the line drawn in HB 954 at 22 weeks, right?
Yes.
Now, you wrote in this article that before HB 954, abortion was legal in Georgia up to 26 weeks LMP. Do you believe that abortion should be legal in Georgia after 26 weeks LMP?
I think that any policy that applies to abortion needs to include all of the factors that we think about when we consider delivering safe healthcare. And there are other things that impact the soundness of that decision rather than just gestational age. So I have a hard time with saying there should be a specific limit because medical practice is complex.
What was there a medical significance to 26 weeks? The 22 or 21, I understood to be loosely the viability line. And that's what 954, if that's the right number, was pulling things back to viability. What was 26 weeks?
That cutoff was based on Georgia's definition of trimesters.
Okay.
And so they said for the first 2 trimesters, and they defined trimester as 13.
Okay, so 13 plus 13, and then 954 pulled it back to viability, give or take, at 21 or 22 weeks.
Yes.
So Dr. Swiak, do you believe that abortion should be legal in Georgia during the 3rd trimester of pregnancy?
For rare circumstances, yes. If it was medically sound, yes.
And what do you mean by medically sound?
So rarely it's needed in the 3rd trimester for situations where, again, there's a grave fetal prognosis and an abortion would be safer for the pregnant patient than to have a vaginal delivery or especially a cesarean delivery if that was the only other option. And the example that I can think of is fetal high drops, where there's so much fluid taken on by the fetus because of heart failure, fetal heart failure during pregnancy, that that especially the head is so large that cesarean delivery is typically required. And so because abortion is safer than a cesarean delivery, in that case, again, if you have virtually no chance of fetal survival, then it would be safer for the pregnant patient to have an abortion.
If a pregnant woman decides at 35 weeks, look, I've changed my mind, I just don't want to have this baby. Do you think the law in Georgia should let her obtain an abortion at 35 weeks?
You know, I've never seen someone say that.
But that wasn't his question.
I don't think that that would reflect the sound medical practice that is practiced throughout healthcare in Georgia, meaning that talk about the risks and the benefits. And in the context of the gestational age, that fetus can survive at 35 weeks, but also there would be no benefit to delivering at that time or ending the pregnancy at that time.
So does that mean that you would draw the line at viability? If a woman just says just prior to or just after viability, the viability line, I've decided I don't want to have a baby. Do you think the Georgia law should allow abortion in that circumstance?
Again, I have a hard time setting a law with a particular limit that doesn't take into account all of the factors that could be impacting that person's medical care. And so it would depend on the circumstances. It's a relative weighing of benefits and risks.
Okay, I'm going to give you one last chance, Dr. Swick, and then I'm going to move on. Where, if anywhere, would you draw the line at a certain number of weeks for abortion to be illegal in Georgia?
Illegal, but with the typical exceptions we see: medical emergency, life of the mother,
Correct.
Emergency, rape, incest.
Let's assume the same exceptions in the Life Act.
I have stated that I don't believe gestational age limits are a legislative matter.
So before you pivot, Mr. Bartolomucci, I want to make sure that no one passes out due to low blood sugar levels. It's 12:50, and you should take as much time as you want for the rest of your cross-examination. If you tell me you've got 10, 15 minutes, we'll probably let this witness finish. If you've got 30 minutes or more, which you're totally entitled to, then we'll probably break for lunch now.
I think it's 15 minutes.
Okay. Then the pressure's on. Thank you.
Your Honor, I can't recall if I moved the admission of the prior article, the abortion trends article.
I don't think you did. I just thought of that when I looked at it. That would have been Defense 604. This is the following the enactment of 654.
I now so move.
All right. Any objection to Defense 604, Ms. Chan? And now we're at 605.
And Dr. Swick, this appears to be an article in the International Journal of Obstetric Anesthesia. Principal author J.A. Reeves, you one of the co-authors, title Anesthesia Providers' Perspectives on Abortion Provision, Deductive Findings from a Qualitative Study, published in 2022. Did I get that all right?
2021 or 2022?
I see accepted in 2021. The date at the top says 2022. So,
Yes.
okay. And I now move its admission, Your Honor.
Any objection to 605? Admitted.
Now, this was a qualitative study that you were involved in, right?
Yes.
Can you describe the study methodology?
So in a qualitative study, instead of looking at a large sample and getting very specific yes, no answers or statistics, or very concrete answers, this is instead a different method where you use structured interviews with a smaller sample size. And so it's not intended to be representative of a larger, of everyone. It's exploratory. And so what we do is especially in a relatively unknown area, such as this topic, we talk to individuals and ask them certain questions, but let them really tell their own story without much prompting from us, so that we can, again, explore what the possible important themes are.
Now, if we could go to page 2 in the second column, you're reporting what the study participants told you, and this is in the third full paragraph in the second column of page 2. And it says, quote, almost all were accepting of abortion in cases of maternal life endangerment, rape, or incest. Most accepted abortion for severe fetal anomalies, especially cases characterized as incompatible with sustained life after birth. Fewer participants accepted abortion for non-lethal fatal anomalies, social or financial indications, or perceived elective reasons. One participant expressed opposition to all abortions. Is that the quotation?
Yes.
Now, would it be fair to say that, as you've described them, your study participants probably would be pretty comfortable with the Life Act?
We didn't ask them about the Life Act.
I understand that, but reading what was written in this study, it sounds like your participants' views line up pretty well with the Life Act, don't they?
I feel like this is still calling for speculation, and Dr. Swain has already said that they were not asked about this.
Your response? You are free to argue from this, and it may be that Dr. Swiak has more personal knowledge because of her assessment of the survey, but she can't climb inside their minds, other than that they've spoken their opinions.
I'll move on, Your Honor, since
Okay.
time is short. Now, you included, I think, exactly 2 exact direct quotations from study participants. Is that right?
I'm not sure how many.
And if the number's 2, did you include quotations because these were views representative of study participants?
So again, it's qualitative research, and so we can't say that this is representative of either the entire sample we talked to or representative of the entire sample of, in this case, anesthesia providers. We typically provide in a manuscript like this quotes specifically if we thought that the quotes themselves were illustrative.
So one of the quotes, which is attributed to a female anesthesia provider, is, quote, I do believe in a woman's right to choose, On the other hand, I believe that life begins at conception, and I think it's a conflicting issue for a lot of people. And I'd say that I'm somewhere in the middle, end quote. Is that what one of the study participants said?
Yes.
And 2 paragraphs down, there's another quotation from a different anesthesia provider, an anesthesiologist, and he said, quote, if you're pregnant and want an abortion, you got to decide early. I'm not saying you have to decide in 2 weeks before you know you're pregnant, but I think you got to decide early, end quote. Is that what that study participant told you?
That's what that person said, yes.
And just one last paragraph that I think is relevant, right above that. This is not a quotation from a study participant, but it's part of your study. It says, quote, gestational age at the time of abortion also resonated with participants. Many participants thought abortion at an earlier EGA was more acceptable than at a later EGA. Is that the quotation?
Yes, among these anesthesia providers, yes,
And what does EGA stand for?
estimated gestational age.
Now, shifting gears a bit, let's talk about the Life Act and medical education and training. You testified on direct examination that the programs at Emory Medical School are accredited by the ACGME. Is that correct?
Yes,
Now, after the Life Act went into effect, did the medical school or any of its programs lose accreditation?
no,
As of today, is the medical school and all of its programs still accredited by ACGME?
as of today, no. I mean, they still are, yes.
Okay, so it is, the school and the programs are accredited, right?
Yes.
Okay.
Thank you.
Dr. Swick, you were you interviewed by the author of this article I've just handed you? Do you recall?
Yes,
Okay. If we,
Do you have an agent or something? You pop up in all these things.
And this article is called Abortion Ruling Pits State Bans Against OB/GYN Training Rules. Author Christopher Brown, June 27, 2022, published in bloomberglaw.com. Is that right?
yes.
Now, if we could go to the last page of the article. Josh, I don't think we're on the page I want. Can you go down one more? No, well, actually, why don't you go up one page? Okay, so we're under routine training. And Josh, go over one more page. Well, Dr. Swick, here it is. We've blown it up. The quotation attributed to you, and I want to know if you said this, is the procedures and techniques I teach related to abortion care are the same procedures and techniques used for patients who have early pregnancy loss or are dealing with obstetric complications.
Yes,
So you said that to the author,
yes,
and it's a true statement.
yes.
Okay, Your Honor, I'd like to move the admission of this article.
As Defense Exhibit 606.
Yes, sir.
All right, Ms. Chan, any objection?
No.
Admitted.
And 3 paragraphs down from where you gave a quotation, there's a different doctor who said, quote, OBGYNs are trained to empty a uterus at any gestational age as part of their normal training. Do you see that?
Yes,
Is that a true statement?
I don't know if it's true in all cases.
Is it generally true that OBGYNs are trained to empty a uterus at any gestational age as part of their normal training?
Some programs only train in first trimester techniques rather than first and second trimester.
Do you have a Twitter account, Dr. Swack?
Yes.
Dr. Swiak, is your Twitter handle or name, Dr. Carrie Swiak provides abortion as healthcare?
At one point, yes.
Did you change it?
Sometimes I change it.
So, okay. What is it today?
I don't recall. It has something to do with COVID and masks.
But at some point, that was your Twitter handle.
Yes.
Okay. Now, you retweeted a May 3rd post by Julie Lalonde. Is that right?
Yes.
And Miss Lalonde's tweet said, quote, "It's okay to want an abortion just because you don't want to be pregnant," end quote. Did you retweet that?
Yes.
Did you retweet it because you agree with her comment about it being okay to want an abortion just because you don't want to be pregnant?
Because I believe you don't need a tragic story for access to reproductive justice.
Now, you also retweeted a June 27 post by one of your co-plaintiffs, Dr. Haddad. And her post said, pregnancy is not a benign condition. Did you retweet that?
Yes.
Did you do that because you agreed with her comment?
Yes.
Now, I believe the antonym for benign is malignant. Do you believe pregnancy is a malignant condition?
That is not a direct corollary where it's either benign or malignant.
But do you believe that pregnancy is not a benign condition?
Yes, because there are risks inherent in being pregnant.
Now, on September 11th, you sent out a tweet that said in part, quote, "Pregnancy can often be life-threatening and that abortion is a safer option." Did you tweet that out?
Yes.
You also retweeted a September 19 post by the Orlando Women's Center. Do you remember doing that?
Yes.
And the Women's Center's quote was, "The signs that you are pregnant may appear before you miss your period. If you aren't sure what these signs are, there are commonplace symptoms that may suggest one is pregnant." Is that what you retweeted?
Yes.
And is the Orlando Women's Center right about what it said?
Yes.
Now, on August 30th, you tweeted out some advice for justices on the U.S. Supreme Court. Do you remember that?
Yes.
And could you, Josh, can we put that up? Now, Dr. Swiak, could you please read for the record your advice for the Supreme Court justices?
Yes, the conservative Supreme Court justices should go F themselves.
Now, were you talking about the justices in the majority in Dobbs?
Yes.
So Justice Thomas, Justice Alito, Justice Gorsuch, Justice Kavanaugh?
A state case. This is a tweet, and we're going through a long series of questions about the federal Supreme Court, which is really not of any issue in this case. So objection as to relevance.
Goes to bias and credibility, Your Honor.
Overruled, it's his clock running.
So were those the justices that you were advising to go F themselves?
Yes.
Oh, no, actually, I missed one. Amy Coney Barrett. Were you advising her to go F herself as well?
Yes, those in the majority opinion, yes.
Now, you also tweeted on July 9 in regard to Justice Kavanaugh that, quote, "Karma is a bitch." Is that what you tweeted?
Yes.
And was that in relation to an incident in which Justice Kavanaugh and his family were harassed at a restaurant?
Yes.
Okay, just a few more questions, Dr. Swiak. Are you an attorney?
No.
Are you offering any opinion in this case on the proper legal interpretation of the Georgia Constitution?
No.
Did you set forth all of the opinions that you're offering in this case in your two affidavits?
as much as I could possibly put forward in affidavits, yes.
Okay, no further questions, Your Honor.
Did you want to make the tweets an exhibit?
Yes, I do. Thank you, Your Honor. I hereby move the admission of the tweets.
That would be 607.
And Your Honor, this is when you say any objection?
I'm about to. Any objection? I don't know if you tendered 606, which is Christopher Brown's deep dive article that Dr. Swiak was also quoted in.
I think I did, but if I didn't,
Let's
I
just
move
be
it now.
extra clear. Any objection to 606 or 607, Ms. Chan?
No objection to either, thank you.
Okay, they're in the record. Do you have any redirect? Okay. More tweets?
No redirect, Your Honor.
All right, Dr. Swiak, thank you for your time and for the important work you do. You are free to step down. All right, last little bit to get on the record. So everyone knows, Ms. Chan, your side is at 4:41:30. Still a lot of time left. And Mr. Bartolomucci, your side is at 4:52:38. It's about the same, about 10 minutes more on direct and cross. Who will be testifying next after lunch?
Your Honor, that would be Dr. Rice.
Great, Dr. Rice. Stenographer April, how much time do you want for lunch? Or need?
20 minutes would be the least amount I would like if possible, Your Honor.
Okay, you can easily have that much. I think we had talked about a half hour. Is there anyone representing either side for whom 30 minutes will leave you unable to continue if we come back in 30 minutes? Seeing no hands, let's be back on the clock in the courtroom at 1:40, and we will pick up with Dr. Rice. Thank you so much, and I'll mute the microphone in here so you don't have to worry. I can't speak to the media, but the live feed microphone will be muted in about 2 seconds.
Your Honor, we are off the record, but I didn't want to see if I put my email in chat. If somebody could give me a listing of everyone present. I know they stated their names, but the law firms.
Yes, if you put your email in chat, I'll have both sides send you all their information.
Perfect.
There it is.
There it is. I appreciate that. Thank you, Your Honor.
You bet.
It's clear.
Yep.
Have a good lunch.
We're gonna keep going. Stenographer April, can you hear us?
I sure can.
Great. Did you get enough lunch?
Yep, I'm perfect. Thank you.
Okay. Plaintiffs and defendant, if you would look in the chat, there is an email address for our stenographer. She would like to have the names of all the lawyers who have been or will be talking so she can make an accurate record. So please designate to someone who's got access to the Zoom room to send her in chat, or I can give you her email. She put that in there as well. What do you prefer?
I think we got it.
Okay, the exhibit people can do that. Excellent. Okay. Then where we left off was we were going to hear from Dr. Rice next, if that's still the plan. Let's do it.
Yes, Your Honor, thank you. Alice Wong from the Center for Reproductive Rights for Plaintiffs, and at this time, we'd like to call Dr. Rice.
Great. Please come up, Dr. Rice. And Ms. Wong, are you going to be at the lectern or you? Okay.
Whitney Rice, Whitney, Rice, RICE.
Good afternoon, Dr. Rice.
Good afternoon.
As you're aware, your affidavits and CV have been admitted to this court as exhibits 8 to 10. So I'd like to just briefly go through your credentials. What is your current profession?
I am an academic researcher, a scientist and faculty.
And Dr. Rice, could you just briefly describe your educational history for the court?
Sure. So I received my undergraduate degree here in Georgia. I went on to receive a Master of Public Health at Emory University in Health Policy and Management, and also received a Doctor of Public Health degree at the University of Alabama at Birmingham in Healthcare Organization and Policy. I also completed postdoctoral training in health services outcomes and effectiveness research at the University of Alabama at Birmingham. I should mention, during my doctoral training, received a traineeship in maternal and child health policy.
Thank you, Dr. Rice. Where are you currently employed?
I'm currently employed at Emory University in the School of Public Health.
And what positions do you hold at Emory?
I am director of the Center for Reproductive Health Research in the Southeast at Emory. I am assistant professor in our Department of Behavioral, Social, and Health Education Sciences. And I'm also affiliated faculty at a few of our centers, including the Maternal and Child Health Center of Excellence.
Thank you, Dr. Rice. And as a reminder, please just speak slowly and clearly for the court reporter. What does your role as director of Emory's Center for Reproductive Health Research in the Southeast involve?
So my role involves scientific leadership, including roles as an investigator or co-investigator on research studies involving access to sexual and reproductive health care. I also provide mentorship and advise students who are at the master's level, doctoral level, also postdoctoral fellows, and oftentimes am serving in roles on committees related to sexual and reproductive health research.
And what courses do you teach as faculty?
Currently, I teach research methods and health promotion to master's level students in my department.
Have you published any research in peer-reviewed journals?
I have published research in a number of peer-reviewed journals focusing on access to sexual and reproductive health care, as well as reproductive stigma and other topics.
What's reproductive stigma?
So stigma is referring to just a social process by which people are excluded, devaluated, an experience of attitudes towards topics like abortion or other stigmatized topics or conditions.
Meaning someone who might seek an abortion could be stigmatized because of that topic.
Absolutely.
Okay.
Dr. Rice, do you have training in research methods?
Yes.
Can you share some examples of research methods that you use in your work?
Sure. So I've used a variety of mixed methods in my work, either quantitative or qualitative or some combination. And a few examples include of quasi-experimental research methods, which basically simulate the condition of having a sort of randomized study where people are in groups, an experimental group and a control group, as opposed to that in quasi-experimental studies, which we often use in public health. We might evaluate the impact of a policy by comparing states that have a policy in effect to states that do not have a policy in effect on certain health outcomes, is one example. I've also been involved in studies that analyze large data sets, including birth records, or administrative data from medical records from healthcare providing institutions, I guess I would say.
And do you also use qualitative methods in your research?
Yes, I have used qualitative methods as well, collected focus group interview data, and analyzed that data in some studies.
And in addition to publishing your own research, do you also supervise research at Emory?
Yes, I supervise postdoctoral fellow training as well as doctoral progress through the PhD program. I've been an advisor on doctoral dissertations and master's theses as well.
And do you serve as a peer reviewer for any nationally recognized journals?
I have peer reviewed for high impact journals in sexual and reproductive health, including Perspectives on Sexual and Reproductive Health, including contraception, but also general healthcare journals like Health Affairs, American Journal of Public Health, to name a few.
Thank you, Dr. Rice. Your Honor, at this time, plaintiffs move to qualify Dr. Rice as an expert in public health, including in maternal health and the impact of reproductive health policies on health outcomes.
So that's a lot of words. Mr. Field, are you handling this witness?
Yes, Your Honor.
Any objection?
Yes, sir.
Okay. Dr. Rice, you are qualified for the purposes of this trial in the general area of public health and then as more refined as Ms. Wong just described.
Dr. Rice, let's just start by discussing maternal health. How is maternal mortality measured?
So maternal mortality refers to death that occurs during pregnancy or within a specified period following the end of a pregnancy that are pregnancy related.
And what are pregnancy related deaths?
So those are deaths that may be attributable to pregnancy. Specifically, some examples might include hemorrhage that occurs once again, during up to a year following pregnancy. Other examples might include just experiences of injury during birth due to medical intervention.
And Dr. Rice, how does Georgia's maternal mortality rate compare with that of the nation overall?
So Georgia is among, Georgia's maternal mortality rate is among the top 10 worst in the nation. Its maternal mortality rate is higher than the national average.
Are any pregnancy-related deaths in Georgia considered to be preventable?
Yes, a substantial portion. So the Georgia Department of Public Health indicates that over 80% of maternal deaths are preventable.
And are there racial—
You say 80?
Over 80.
Are there racial disparities in Georgia's maternal mortality rate?
Yes, where there are disparities whereby specifically Black birthing people experience over twice the maternal mortality rate than non-Hispanic white people in Georgia.
And the adjective you used was urban. You said Black urban people?
Oh, birthing. So
Birthing.
people who are giving
Okay, got it. So a Black female giving birth is much more likely to experience maternal mortality than a non-Hispanic white.
Correct.
Got it. Birthing.
Dr. Rice, why are Black Georgians over twice as likely to die from pregnancy-related causes than non-Hispanic white Georgians?
So there are a variety of reasons at play in those disparities. They may include, or they do include, experiences of systemic bias, systemic discrimination in the healthcare system and outside. They include just some of the disproportionate experiences of experiences that Black people in Georgia have that contribute to difficulty with accessing care. So we know that Black people, pregnant people, and otherwise have experiences, disproportionate experiences of poverty, for example, living in rural areas in which access to care is more limited, to name a few.
And Dr. Rice, in your expert opinion, why is Georgia's maternal mortality rate among the top 10 worst in the nation?
In my professional opinion, Georgia's maternal mortality rate reflects general lack of access to healthcare in Georgia, and sexual and reproductive healthcare is a specific area in which there are issues with access to care. And there are a number of reasons for that, including shortages of physicians and shortages of physicians in specialties really relevant to sexual and reproductive health care, to name a few. Also policies that are not as supportive as they could be for people preconception, during pregnancy, and postpartum. And in addition to that, we certainly see that specific communities in Georgia are disproportionately less likely to access care or disproportionately more likely to have difficulty with accessing care. And that includes lower income people in Georgia, as reflected in your last question, Black, pregnant people, as well as people in general, and then Black people in general in Georgia, and then certainly folks who live in rural areas.
Thank you, Dr. Rice. Let's just break that down a little bit further. How does poverty in Georgia compare to poverty elsewhere in the nation?
Well, we know that the rate of poverty in Georgia is higher than for many other states, so higher than the national average, and that there are specific groups of people for whom the experience of poverty may be disproportionately high. So as we just discussed, Black communities in Georgia, but also women relative to men.
And what does that mean for women of reproductive age in Georgia?
So that means that women of reproductive age may experience difficulty with affording care, healthcare. And in fact, there are some data to support that a substantial proportion of women in Georgia forego healthcare due to cost.
So you mentioned barriers to accessing reproductive health care. Is one of the barriers a shortage of physicians in Georgia?
Absolutely. So we do see that in Georgia, there is a shortage of physicians, period. And then, as I mentioned, in specific specialties, so there are, limited access to primary care physicians, shortage of OBGYNs, and even disparities in access to pediatricians.
Are there, we read about food deserts where there are no good grocery stores in certain communities? Are there OBGYN deserts where you could live in a city or even a county or several counties and you can't get access because there's just not an OBGYN?
Absolutely. So as reflected in some of the data that I reviewed and included in the report, nearly half of Georgia's many counties lack access to an OBGYN.
You use the phrase lack of access, and that may be an important term of art for the work you do, but it's not that there's a wall around the county, it's that there is no OBGYN in that county. And if you can't afford transportation, or for whatever reason, you'd still have to go to an adjoining or even further county to even meet a doc. It's not that there's an OBGYN in County X who says, I refuse to see you. It's that there's just not one at all.
Absolutely. That's an important clarification that in terms of that specific, data regarding lack of access, quote unquote, to OBGYNs, specifically, there's not access within that county. And a lot of these counties are concentrated in, similarly, the counties without access to an OBGYN are concentrated around other counties for which that is also true.
Sure.
Dr. Rice, you mentioned that one factor that contributes to Georgia's high maternal mortality rate is the lack of policies that support the well-being of pregnant people and families with young children. Can you just provide the court with some examples of policies that Georgia is missing?
Sure. So one example is lack of support for sick leave is a primary example. Another is a regressive family cap, whereby folks who are receiving TANF assistance are not able to receive additional cash assistance at the point at which they have, 4 additional children that they may have.
I didn't follow that last one, meaning your TANF could be capped at 2 kids. So if you have a 3rd or a 4th, you're not getting additional money. A family is a 4-unit household. And if you add a 5th or a 6th unit, you have to make by.
Exactly. That is how I think of that policy, that specifically we are, limiting conditional upon the number of children that people have.
Dr. Rice, what is maternal morbidity?
So maternal morbidity refers to health conditions. They might be short or longer term health conditions that arise during pregnancy or that are worsened by pregnancy.
And are there racial disparities in maternal morbidity?
Once again, there are racial disparities. Just as with maternal mortality, there are racial disparities in maternal morbidity, whereby non-Hispanic Black, pregnant or postpartum people experience a higher rate of maternal morbidity relative to non-Hispanic Black people in the state of Georgia.
Do you mean relative to non-Hispanic white people?
Non-Hispanic white people, absolutely, sorry. Non-Hispanic Black people relative to non-Hispanic white people is correct.
Understood. Let's now turn to the law that's at issue in this case. Have you reviewed Georgia's HB 481?
I have.
And what is your understanding of what Section 4 of HB 481 does?
My understanding is that that section of HB 481 limits access to abortion, whereby after detection of fetal cardiac activity, which occurs at around 6 weeks, people can no longer access abortion within state.
If I refer to Section 4 of HB 481 as the ban, will you know what I mean?
Yes.
Are you familiar with the demographics of people who seek abortion in Georgia?
Yes.
Can you briefly describe the socioeconomic demographics of Georgians who seek abortion?
Sure. So Georgians who seek abortion are certainly disproportionately more likely to be Black, to be lower income, as well as to have had a prior birth, many of which, essentially most people have had or do have existing children.
Do you know what proportion of abortions in Georgia occurred at or after 6 weeks prior to the ban taking effect?
Yes, prior to the ban taking effect, the majority of people who had abortions in Georgia obtained their care beyond that 6 weeks.
Do you disagree with what we heard from Dr. Seawack, which was it's about 44% who get abortions 6 weeks or earlier? So it's still a majority that would be after 6 weeks, but does that sound like about the right break for you? So it's 56% would be thereabouts later than 6 weeks after fetal cardiac activity, and then 44% before? Or do you have different numbers?
I think it probably has depended on the year. However, I think I would, trust that opinion.
I'm not trusting it, but you said majority, and I'm just wondering if you're thinking, yeah, it's 80% of all the abortions are after 6 weeks. That's fundamentally different from what another expert had to say. And I just want to be able to evaluate all that. I'm not critiquing anything.
So I think it could vary in that in some years that proportion might be higher than, 54%.
Okay.
Dr. Rice, why are some people delayed in obtaining abortion care until after 6 weeks in pregnancy?
So there are a variety of reasons for which people may be delayed in obtaining care. One of those reasons includes physiologic reasons. So people can have experiences with conditions for which detection of pregnancy may be later than for other people due to menstrual irregularity. They may not, in other words, detect a missing period as early as other people. Some of those conditions for which that occurs include certain thyroid conditions, obesity, among others. And several of those types of conditions are also more prevalent in Black people within the US. There are also other reasons, however, for which people may be delayed for which reason people may be delayed in obtaining care. And they certainly include having difficulty with obtaining the funds, putting together funds to pay for care, to pay for abortion care, to pay for transportation, to pay for childcare, and to pay for maybe the cost of lodging while in cases where people are, having to travel. Are primary, I think, among some of the primary reasons. I think in addition to that, logistically, people may not be able to get time off from work to be able to travel longer distances to obtain care.
Thank you, Dr. Rice. So in your expert opinion, how does the ban impact abortion access in Georgia?
In my expert opinion, the ban will drastically decrease the ability for people to access care within the state of Georgia. And for the smaller proportion of people who can access care in the state, they may be more likely to have access to resources with which to do so. For people who are unable to access care outside of or inside the state, they may choose to self-manage their abortion, or they may, if they have the resources. So if they have the resources, they may travel. And then for those who cannot travel, they may choose to self-manage their abortion, or they would be forced to continue a pregnancy.
And what do you mean when you say that some people may self-manage their abortion?
So by that, I'm referring to taking, finding ways or access to medication for abortion, or by other means attempting to proceed with an abortion, whether by ingesting something or other ways, but primarily finding access to medication.
And is the difference that it is without medical supervision?
Yes, specifically without medical supervision.
What is your opinion that some Georgians are unable to travel out of state for abortion care beyond 6 weeks based on?
So my opinion regarding the difficulty of traveling for care is based on, and I should say inability for many to travel, is based on a body of literature indicating that with larger travel distances, people are less likely to be able to obtain abortion care. We also, I think, in a specific, somewhat pretty comparable example, after Texas passed SB 8, so a similar ban in terms of, at around 6-week gestation, there was quite a drop off in the number of abortions accessed in state. And I think that number is maybe even an underestimate for, I think they found that in one study shortly after the ban occurred, they found that drop off was about 50%, which may have been an underestimate given that not all facilities, though over 90% of facilities were sort of surveyed to assess their provision of care. And then folks who accessed care out of state reported a lot of difficulty, like very long wait times, and those wait times for accessing care in surrounding states were much higher than they were prior to the passage of SB 8. I should also note that evaluation occurred at a time in which a number of the states surrounding Texas had access to abortion care, whereas in comparison, in Georgia, we see currently a lot of bans in Georgia surrounding states.
What is the closest state that doesn't have either an outright ban or a 6-week-ish ban?
Closest state to Georgia?
Right. We're here in Atlanta, and you're trying to get the closest state where at week 14, you could have this procedure.
So we certainly see that there is still some access around that time in Florida, I believe. And I didn't
mean to put you on the spot if you don't know that. I just thought that would be part of, as you're weighing the impact of this policy on people in Georgia, where they would go. So Florida is one destination.
One example, and I just say I add that I believe, given that things seem to be changing
daily,
quite frequently.
Okay.
Dr. Rice, do you expect the ban to have an impact on maternal mortality and morbidity in Georgia?
I do expect the ban to increase maternal mortality and morbidity in Georgia and to exacerbate the disparities, racial disparities in maternal mortality and morbidity in the state.
And what is that opinion based on?
So that opinion is based on several studies that have looked at this. So in one case, there is a study that looked at data from the 60s and 70s, late 60s, early 70s, following access to legal abortion in Georgia. So I think before compared to after, and found that there was a decline in maternal mortality when abortion became legal, specifically for non-white Georgians. In one example, there's another study that has done a projection of what change there might be in maternal mortality following bans across the country. And so I should say there are data in both of these studies beyond and including Georgia. So, and in the projected, in the case of the other study that projects the potential impact of bans nationally, they found that the rate of maternal mortality following a decision where that we did end up seeing that was realized in Dobbs v. Jackson Women's Health Organization, they projected that following that decision, there would be an increase in maternal mortality initially, and that that increase would, jump up over a longer term period, and that there are projected disparities in those rates, whereby once again, non-Hispanic Black women had a higher rate of, or would have a higher rate of maternal mortality.
Other than the impacts on maternal health outcomes that we just discussed, do you believe the ban has any other effect on the well-being of Georgians?
Yes, I do believe that the ban will have effects in terms of exacerbating some of the income-related disparities that we see in Georgia. As noted earlier, there are increased costs, even among people who are seeking abortion care and are able to obtain it, say out of state, for example. There are increased costs to them for obtaining that care, given additional barriers and distance that they have to travel. For people who are unable to obtain care and may continue the route of, or are forced to continue a pregnancy, we see studies that indicate that having been denied a wanted abortion relative to being able to obtain one, that in comparison, there are increased risks of experiencing things like eviction and other income-related just disparities. And I think, so those are some of the income-related effects that this policy could have. In addition, there are risks to families. We've seen in one study that for folks who were denied a wanted abortion relative to able to proceed with receiving that care, that folks in those circumstances who had a history of intimate partner violence with the man involved in the pregnancy, in this case, is how at least this study phrased that. They found that people in those circumstances were more likely to stay in a relationship with that, partner, or in the study's words, man involved in the pregnancy.
Can you briefly describe this research that you're referring to that compares people who were denied an abortion versus people who were able to obtain one?
Yes, so the research that I cited there is from the Turnaway study. This is a study, a prospective cohort study that followed the experiences of nearly 1,000 people seeking abortion, and specifically followed groups that included people who were denied a wanted abortion and people who were able to receive care near gestational limits in their state. And the people who were included in this study came from facilities across the US. And once again, data were collected at several time points.
Do you consider the Turnaway study to be rigorous in its design?
I do. I think in the public health field and reproductive health field, this has been referred to as somewhat of a gold standard within, that social science public health research. The research out of that study has been published in a number of peer-reviewed high impact journals, and has gone through, has had to go through a process of vetting to be published. In addition to those publications, I should also note, detail a lot of the methodological strengths as well as any limitations of that work.
Dr. Rice, did you review the expert report of Dr. Priscilla Coleman in preparation for your testimony today?
I did.
Do you agree with Dr. Coleman's critiques of the Turnaway study?
I disagree with the characterization of the Turnaway study in that report. And specifically, I think some of the primary issues that were highlighted were around the study's attrition rate, so the degree to which folks who were initially recruited and enrolled into the study continue to participate over the different data collection time points. And my opinion about that is just that the attrition rate reported in the Turnaway study for its participants is equal or better to similar other research. I think in addition, attrition rate is one of several methodological considerations around studies' strength or relative weaknesses, and I don't think should be considered as a sole indicator of a study's strength. We know that, or as reported by the Turnaway study, a number of statistical modeling approaches were done to test whether or not dropout essentially of participants, or whether their attrition rate, in other words, was reflective of bias. And we know that they took a number of approaches to minimize bias in the study as a whole. So attrition rate was one issue that was spoken to, and another is just the study's recruitment strategy. And I think in my opinion, the recruitment approach that was reflected in this study is one that, again, is comparable to other social science and public health research, and took approaches to minimize bias.
What was the recruitment approach that they used?
Sure. So the approach that they used was to recruit people who were in the group that were denied abortion care due to seeking care beyond gestational limits. The clinics approached anyone who were instructed to approach anyone who entered those facilities and couldn't receive care for those reasons, and invited them to participate in the study. Comparably, in the other study groups, which were people who were able to receive care, we know that, or they reported that, they chose recruitment windows in which to approach those groups because they're more represented in the clinic population. So during recruitment windows, the I guess investigators report that they approached all folks who were instructed to approach all folks who could or received care during those times. And so I think that is more of the individual level recruitment strategy. And they also report that at the facility level, they approached the vast majority of facilities that were eligible according to their recruitment criteria. And something like 2 of the facilities that they approached indicated that they were not willing to participate. So I think sometimes choosing to focus on the recruitment strategy at just the individual level is not necessarily reflective of their multi-level recruitment strategy. And in addition to that, there are reasons why, given the clinic population, they may have encountered a higher percentage of people who received care relative to people who were denied care.
Thank you, Dr. Rice. And were clinics that were recruitment sites across different geographic regions in the US?
Yes, so the facilities that were enrolled represented multiple geographic regions in the US. So were recruited across the country.
You mentioned that the Turnaway study found that being denied an abortion resulted in worse socioeconomic outcomes. Can you just speak a little bit more to that?
Sure. So the study indicated, there are several relevant studies that were published on the topic. And so in one example, they looked at the Experian credit reports of folks who were denied a wanted abortion relative to folks who were able to obtain care. And it was in that study specifically that that finding about having a higher likelihood of being, higher risk of being evicted, for example, came from. And then there were other studies indicating, other socioeconomic risks of, being denied a wanted abortion that include ability to findings related to ability to, the perception, I think, among people who were denied a wanted abortion, ability to, provide to the same degree to their families, but which include existing, for many included existing children.
And do those socioeconomic risks include a higher likelihood of falling below the poverty line?
Yes, so that was one of the other findings reported as a result of a comparison between those groups of being denied a wanted abortion and being able to proceed. And there was a finding related to that risk of falling below the poverty line as well.
And did the Turnaway study find any disparities with regard to maternal health outcomes?
So yes, there were also study findings regarding likelihood of having proceeded with a pregnancy for the groups that were denied a wanted abortion, and that was certainly an experience represented among that group. In addition, having pregnancy-related complications was more likely in that group that was turned away, or in other words, denied a wanted abortion relative to folks who proceeded.
Were there any maternal deaths in either group?
So we did see, or the study did report 2 maternal deaths specifically for the group that were denied a wanted abortion relative to groups that were able to receive care.
And just to clarify, were there any pregnancy-related deaths in the group that was able to obtain abortion care?
No deaths in the group that was able to obtain abortion care, whereas there were, again, 2 deaths in the group that were denied the opportunity to receive abortion care.
Thank you, Dr. Rice. Are there certain populations in Georgia that the impacts that you described of the ban will fall hardest on?
Yes, so as reflected in some of the studies that we discussed, these impacts fall hardest on, Black families, Black women, and people within Georgia.
And in your expert opinion, how will the ban impact the overall public health in Georgia?
So in my opinion, we are likely to once again see disproportionate experiences of morbidity and mortality in connection with the ban in Georgia, whereby not only, so certainly Black families will disproportionately experience that maternal morbidity and mortality, but we also know that this ban will be disproportionately affecting lower income people, as well as people who already live greater distances from care. And a lot of this, the majority of this disproportionate experience is preventable. And so in addition to that, these experiences of worsened economic outcomes are another devastating impact of the ban.
Thank you, Dr. Rice. I have no further questions at this time.
I have a question before Mr. Field goes. Has there been time yet, Dr. Rice, to conduct studies that show which option seems to be, I won't say preferred, just used the most? If a woman cannot get access to reproductive care in her home state, you described options. One is to travel, maybe not financially or logistically feasible. Have the child, in other words, take the pregnancy to term, or you had a fancy term for it, but sort of self-resolving the situation. Have there been studies yet that show which of the three is the predominant outcome? Or it's too soon because obviously it's very soon after Dobbs, but their restrictions have tightened around the country in different ways.
So I think that there is beginning to be, research evidence that folks are, releasing surrounding this. I can't say that I am able to speak to the specific proportion breakdown off the top of my head. It would probably be helpful to reference just to make sure that is.
But it's some people are looking at that to see, well, what is this, as you are looking at health outcomes, you described the three most likely approaches someone would take if she can't access that form of care in her, you start with neighborhood, then county, and now state. So you'd have to do one of those three things. Okay. All right. Thank you.
Your Honor, may I approach the witnesses to hand her?
You may. And Mr. Field, when you're ready.
Good afternoon, Dr. Rice. My name is Brian Field. I'm one of the attorneys for the state. I'd like to begin by discussing with you some of your statements about geographic disparities. And if we look at your report, I think we'll be able to pull it up. I'll look at paragraph 18 if we could. While it's coming up, I'm going to I'll read a portion of it. With respect to geographic disparities, you said, quote, lacking access to care in one's community and having to travel long distances to access critical care results in worse outcomes. Do you recall saying that?
Yes.
And your only citation for that is to an article written by Charlotte Kelly. Does that sound right?
I would have to look to.
Okay. It's paragraph 18. So toward the bottom of this page, on this paragraph, you'll see the sentence that begins with lacking.
Yes.
Okay. So the citation for that sentence is a study by Charlotte Kelly. Is that correct?
Correct.
Okay. Are you familiar with that study?
Yes.
Okay. That study didn't consider, analyze, or even discuss abortion, correct?
That study considered a variety of health outcomes. I do not recall abortion being a specific outcome that they were looking at, or travel-related health condition that they were.
And if I represent to you that it didn't discuss abortion specifically, would that surprise you?
No.
Okay. And this study, it showed that in some instances, there was actually no relationship between distance from a healthcare facility and outcomes. Does that sound right?
So there may have been studies for which that is true, but I should note that the study is a systemic review of a variety of studies, and generally systematic reviews, report as their results, what was the case for a, substantial proportion of studies in, that were reviewed.
Yeah, so let me just, maybe easier if I just give you a copy of the study, because I don't believe, actually, I'm sorry, this is admitted as plaintiff's exhibit 43. So if I understood what you just said correctly, the Kelly study is compiling and discussing the status of other studies.
Correct.
Is that right? Okay. So if the Charlotte Kelly study says that there are other studies that show that in some instances, there was no relationship between healthcare, distance from a healthcare facility and health outcomes, would that sound right to you?
I think that's absolutely possible.
Okay. And would it also sound right to you that the Charlotte Kelly study also determined that other studies showed that greater distance actually led to better health outcomes?
Your Honor, I would just ask that the witness be shown the study so that she can refer to it, since this is not a memory test.
Okay, I think Mr. Field did ask for it to pop up on the screen, but we lost defendant's exhibit and it was replaced by someone else. So the imposter may have.
That Prince guy.
She was there, yeah.
So if we go down to page 4, on the left side, there's discussion. If you could blow up that paragraph, please. And I guess my question really on this is it the case that some studies show that there's no change in health outcomes by distance? Some studies show that there is actually a positive health outcome due to distance, and others show that a distance leads to a negative health outcome.
I think that it is the case that studies have a variety of findings with respect to that.
Okay, and that's presumably why this paragraph begins with the results were mixed, correct?
Right.
Before you take that down, just so I'm following it, because I don't think the numbers are just some and some, is distance decay association, that sounds very academic. Does that mean the further away healthcare is, the worse the outcome is?
Yes.
All right, so 83 said it is bad to have healthcare far away.
Exactly.
19 said, it doesn't really make a difference. And then 6, I don't know what distance bias association would be. I'm assuming it's the opposite. Like actually, it was better that you had to drive a lot for your doctor. Maybe you thought harder about getting the plastic surgery, but somehow distance was not a bad thing. Or does distance bias association mean something else?
I would not need to look further up, but I would suspect that the distance bias association could reflect an issue with the degree to which they are able to really speak to that relationship.
Okay.
But
I just wanted to make sure I understand Mr. Field's point. I want to make sure I understood this language as well, because to say some is not inaccurate, but 83 is a whole lot more than 19 or 6.
Correct.
Okay.
An overwhelming number of studies identified evidence of a distance decay association.
Okay.
So, and the report indicated that the results were mixed, but if we go down to page 6, and if you take a look at the conclusions paragraph on the right, you'll see a sentence in the middle that begins with a distance decay. And it says a distance decay effect cannot be ruled out. And as Judge McBurney was just asking you about, that means we can't rule out that distance leads to negative health outcomes, correct?
So what the judge was referring to was a reference to bias. I think this sentence is referring to something different, just the distance decay, period. And so, so slightly different.
Okay. But the conclusion here is that effect can't be ruled out, right?
It cannot, that there is a distance decay that, at a certain point, the distance, maybe may not as, strongly relate to those outcomes. Yes, it cannot be ruled out.
But what I'm trying to understand is we have a statement that the results were mixed, a statement that distance decay cannot be ruled out. But then in your report, you say that it's going to, this distance will result in worse outcomes. And those not ruling it out seems to be very different than it will result in something.
I think in general, these studies, so just like this, are trying to acknowledge the possibility that there are, as stated, possibilities, but generally the large body of studies that were reviewed here had a similar finding in terms of the effect of travel distance on health outcomes, which is what I referred to in the report.
Okay, but you cited just one study for this sentence, that distance results in worse outcomes, and that's the Kelly study that says it can't be ruled out. Is that
Kelly
correct?
Study reviewed over 80 studies. So I think in citing the Kelly study, I am citing this evidence regarding dozens of studies.
But the Kelly study reviewed those and said, we can't rule out the possibility that that there's some distance decay and a negative effect on healthcare outcomes, correct?
The Kelly study is acknowledging the possibility that there is, some point at which there may be a distance decay, but also finds that the large body of studies are observing this effect.
Okay. Now you're familiar though with the principle that correlation and causation aren't the same thing, correct?
I am familiar with that.
And you agree with that principle, correct?
Generally, yes, I agree with that principle.
Okay. And does it sound right that a correlation is a relationship between variables, but does not imply that one variable caused the other? Is that a fair definition of correlation?
That is a fair definition. I would add that some study methodologies are more likely to demonstrate evidence that is near causal or that is causal. And we see that systematic reviews like the review that we just had as an exhibit on the screen have are considered to be a strong just demonstration of evidence, and that they are reviewing across a large body of studies, and particularly when studies are showing similar findings across as many studies. It certainly points to the fact that association is highly likely, and similar to that, there are other methodologic study designs that are stronger in their ability to point to those relationships.
But do you know, before we move on, do you know one way or the other whether the studies that were cited and reviewed in the Kelly study reached causation statements, or did they also have this hedging language that we can't rule out potential causes?
So I did not review every individual study reported in the Kelly study, given that their systematic review provides pretty strong evidence for what a large body of studies across different study designs, across different populations, across different outcomes found, indicating the strength of that relationship.
Okay, let's turn over to maternal mortality for a bit. And I'd like to look at paragraph 48 of your report. And all right, so paragraph 48 reads, even more concerning, denying Georgians access to abortion care will exacerbate the existing maternal and infant mortality and morbidity crisis, with the greatest harm falling on Black communities. Did I read that right?
Yes.
And that aligns with what you testified to earlier today, correct?
Correct.
Now, at the outset, you don't appear in your report to quantify this statement at all. You don't offer anything to say this is how much maternal mortality or morbidity are going to go up after the Life Act. Is that right?
Correct.
Okay. But you do, if we look at paragraph 50, you cite a study by, is it Dr. Vilda? Does that sound right?
Yes.
Okay. So you cite Dr. Vilda's study to support the statement that states with restrictive abortion policy climates had a 7% higher rate of total maternal mortality. Now, just to confirm, you're not saying that there will be a 7% increase in maternal mortality in Georgia, correct?
Correct.
Okay. And when we're thinking about the Vilda study, do you know whether it was a cross-sectional study?
In my recollection, it is possible that it was a cross-sectional study.
And just since I'll ask a few questions about it, and I'll ask this once at least, may I approach?
You may. And while he's approaching, help the non-statisticians here understand what's cross-sectional versus intersectional or non-sectional.
So we are referencing the a study design in which we would look at the existing, number of abortion restrictions and existing maternal mortality rates, as opposed to, maybe a longitudinal design is one, like the Turnaway study example that we discussed earlier is one in which you sort of start with data or, collect data at multiple time points into the future. And so there's a bit of a strength of.
You can see recurring patterns. Cross-sectional, maybe a lay term would be snapshot. A snapshot in time is what's going on in America. We've got states with tighter restrictions and looser restrictions. And what do we see in terms of maternal mortality?
Exactly. And sometimes it's over a shorter period of time, I should say, as opposed to some of the more longitudinal studies that look over a longer time point. So my recollection, and I'll take a look at this, that there may have been, this did not necessarily, I think I need to take a look at how they describe their methods before I continue.
On page 1702, there's a study limitation section that says we use an ecological cross-sectional study.
Yes, so this study does refer to their study as a cross-sectional design, and I think that that is appropriate based on what I'm reading.
And it's true, is it not, that causal connections and causal inferences cannot be made from cross-sectional studies?
That is true. I should note, however, that in the report, this study was cited in addition to 2 other studies.
Sure. I just want to make sure that we address this one first. And that portion of 1702 that I drew you to indicated that the authors here didn't just say it's cross-sectional. They said because it's cross-sectional, we avoided any conclusions of causality, correct?
Correct.
Okay. And I'd like to draw your attention to one other part of the Vilda study. So this study compared maternal mortality figures in states with low, moderate, and high levels of abortion restrictions. Does that sound right?
Yes.
Do you know offhand where this study placed Georgia?
I don't know offhand, but can tell you quickly after looking at table 2. Georgia was in the high abortion, in the group with a high number of abortion restrictions.
And this is based on data from 2015, correct? The state of the law at that point?
Correct.
So would it be fair to say that this study, were it to be redone today, would still have Georgia in a high category?
Might be in super high.
Were there a super high category? But fair to say that they would still be in high, the state would be, correct?
It's hard to say without looking, in more detail, but it's very possible that Georgia would be in that category still.
There's nothing higher.
And so if Georgia was in the high category before and would be in the high category now, and this study looks at a potential higher mortality, maternal mortality rate as a state moves up in those thresholds from low, moderate to high, it seems that you can't say anything about this study because Georgia wouldn't be changing.
So once again, I refer to multiple studies that estimate potential impacts on maternal mortality. And in several of them, there is a effect that is either seen in the past within Georgia for abortion policy change relative to maternal mortality or projected in the future in another study's example. I think for this study specifically, they also indicate that total maternal mortality may be increased as a result of abortion policy restriction at the state level. And that certainly does not mean that it's not going to increase.
Okay. Well, you continue to mention the other authorities. So if we look still at paragraph 50 of your report, this was one study you cited. And then you cited a study that you talked about with plaintiff's counsel today. While I was bringing it up, this is a Stevenson study. Right, this was one you discussed?
Correct.
Right, so I only have a question or two on it, so let me know if you need to see the report, but just, I believe I have it correct here. This is a study that looked at a hypothetical nationwide complete ban on abortion, correct?
Correct.
Okay. And you would agree that here we're not talking about a hypothetical nationwide ban on abortion, correct?
We are talking about a near total ban in the state of Georgia, given that the majority of abortions that would be provided in the state of Georgia are no longer able to be provided in state.
But it's correct, is it not, that the Stevenson article looked at a complete ban nationwide? So that eliminates questions of travel, that eliminates questions of abortions up to 6 weeks, that eliminates questions of medical emergencies, medical futility, fetal anomaly, rape and incest, right?
That study did look specifically at a total abortion ban. I would again add, however, that relative to other states for which that is less the case, Georgia might be closest to that, again, relative to other states in the US.
And then you also cite, I think you talked about it with plaintiff's counsel, a study that looked at changes back in the 60s and 70s, I believe it was, is that right?
Correct.
And I just want to ask you very briefly, do you know what the state of the law was relative to abortion in the 60s?
I can't speak to the specifics of the law. I do know that there was a change whereby abortion access became legally available. And that is really, the study looked at changes in maternal mortality surrounding that.
Right. I mean, it looked at going from where in 49 states it was a felony. And there was they discussed what people were doing to obtain abortions when it was a felony in nearly every state, and then states loosening those restrictions and ultimately going into the through Roe v. Wade, right?
Correct.
But again, that's very different than what we're talking about here, correct?
So a lot has changed over that time in terms of people's or the way that care is provided. That said, the study was able to model a change in maternal mortality, resulting from access to care. And while given the time period, the change, say it is not quite exactly as drastic as observed in that study, even if it is an overestimate, I think a large number and large disparities in the number of maternal deaths are still a problem. And I think the evidence remains useful.
Okay. But each of those three studies we just talked about has little to no real comparison to what's happening in Georgia currently, it sounds like.
I would not characterize it that way. I think there might be some differences in the degree to which those studies may reflect an overestimate in two of the cases, perhaps. Yet and still, they still project increases in maternal death, or that maternal death declined following the provision of access to abortion care, and therefore I think are still indicative of the fact that we have a maternal mortality crisis that could worsen.
I think that's the point. Just, I think, made the point I'm trying to make is could worsen. Sounds to me like that's what all of these studies are saying, is it could, but the flip side of that is it also might not. Right.
So I maybe should correct my terminology. Is likely to worsen. I think the could, or what might be less clear, is the exact number or degree. But I would once again state that I think these studies likely are an underestimate of what could occur in one case, or a slight overestimate in two of the other cases.
Okay,
and the death is still likely to occur.
Okay, so with respect to maternal mortality, let's look at paragraph 22. So on the same topic of your report. We bring up the report, paragraph 22.
You're saying report, is that the same as the affidavit?
I should have, yeah, thank you. Dr. Rice's report. Affidavit.
AKA affidavit, okay.
Yes. So in paragraph 22 of your affidavit, you say, in the US, the experience of severe maternal morbidity, which includes significant short and long-term complications of childbirth, such as sepsis and eclampsia, is also disproportionately higher among Black people as compared with other racial groups, correct?
Correct.
And here you cite a study by a Dr. DeClercq, is that right?
Correct.
Okay. Let's just bring a copy of that for you.
Thank you.
Thank you, sir.
Before I get too far into this, Your Honor, for a bit of housekeeping, I realized that I did not move those three in before.
So the Vilda, Dr. Vilda is 608. I didn't get a copy. I don't need a copy, but if you want
I can clarify. Charlotte Kelly is already in the record. That's plaintiff's exhibit 43, so I need not introduce that.
okay, that's what I thought. It was up on the screen.
I would just note that I think Vilda and Stevenson are also in plaintiff's exhibits.
Okay.
76 and 77.
There we go.
Great. Well, I've got my hard copies here, but they're also in the record.
Perfect. So, Dr. Rice, with respect to this DeClercq piece, now this is the same piece. If we look on page 4, there's a heading that says serious maternal illnesses and complications are rare, correct?
Correct.
Okay. And it shows on the next page that complications like sepsis that you noted occur 7.8 out of 10,000 live births, correct?
Correct.
I believe, at the risk of misdoing the math, is 0.078%.
So I would need to calculate that. If I need to
It's a
do
small
math.
number. Is that, would you agree with me at least on that?
I would agree with their characterization that these are rare, but I am hesitant to use small. I think they matter.
Okay. But in your report, you have not attempted to quantify in any way how, if at all, complications like sepsis would increase under the Life Act as compared to the state of the law before the Life Act was enacted, correct?
I have not, it is correct that I did not provide an exact projection of that number.
You provided directional guidance. It will go up, but would it go to 7.9 or 10.2 or 50?
So
Can't really know yet.
yes, I think that's hard to be able to do at this point in time, though I'm sure that data will become available.
And that directional analysis, though, is again based on these reports that say we can't rule out that there may be some adverse impacts and adverse effects of travel and some of the other studies that we're talking about that are non-causal studies, correct?
Correct. I would add, though, that studies that indicate patterns in maternal mortality are often reflective of patterns in maternal morbidity. So I would not say that we don't have any information or, too limited information to be able to make this assessment.
If we can just move the clerk article in.
Clerk, is it in your?
Okay. You could move its submission.
I think it's already, isn't it one of the 70s? Oh, they retracted that.
No, not the clerk. This one will need to move, which I believe is 608.
Yeah, 608 is whatever you want to do next would be 608.
Yep.
Okay.
The clerk article.
Any objection?
No objection.
All right. It's in this defense 608.
Now, in another paper you wrote, I'd like to talk about some things you've said about maternal mortality, and this is in an article titled "Racial and Ethnic Educational Inequities in Restrictive Abortion Policy Variation and Adverse Birth Outcomes in the United States." Familiar with that?
Yes.
Okay, and this is Plaintiff's Exhibit 79, if we could bring that up. While he's bringing that up, can you tell me just very briefly what this study looked at?
So this study looked at an index of abortion restrictiveness. So looked at an index that's reflective of, once again, how restrictive a state's environment is around abortion policy, and the association of that index with specific birth outcomes from 2005 to 2015. And yes, looked at.
And if we go down on the right side, what I want to ask you about is, in this paper, you notably avoided saying that abortion restrictions will exacerbate maternal and infant mortality. So in fact, in 5 different places, you have the opportunity to say that statement, which is a statement you said today, and you didn't. So on the right, there's a sentence that begins with "given the landscape" toward the bottom, and it reads, "Given the landscape of racial and ethnic and socioeconomic inequities in birth outcomes in the US, policies restricting access to abortion have the potential to exacerbate adverse birth outcomes." And then if we look over on page 9, as it's coming up, I will read to you on page 9. On the right side, it reads, "Additionally, infants born preterm or with low birth weight may be more likely to experience negative health and socioeconomic outcomes as they age." Sorry, social outcomes as they age. And at the end of that paragraph, that's highlighted there. "Furthermore, our findings suggest that restrictive abortion policies may exacerbate substantial and enduring racial and socioeconomic inequities in infant morbidity in the US. And then lastly, in your conclusion on on page 11, in the conclusion paragraph, you say twice that first, the third line, restrictive abortion policies disproportionately affect more vulnerable groups, potentially causing or worsening health inequities. And further down, you indicate that it may increase preterm births and low birth weight. What I would like to understand is why you say today that it will exacerbate these things. In your article, you simply said that it may or has the potential to.
So there are, once again, different study designs have varying strengths in terms of their ability to make causal statements. This study design, certainly if there is a a spectrum of ability to say that, is certainly moving further on the right, given its, examination of longitudinal data, comparison of states that, have more restrictive policies to states that don't, and still it would not be methodologically appropriate to use that causal language. We have seen, however, a number of studies that have looked at this association. This is one, but there are others that have been conducted. And so, I would say across a number of studies that have looked at this association, we're seeing similar findings in terms of greater restrictiveness and relationship with these infant health outcomes. So across studies, I feel confident in the professional, ability to say that the literature supports that statement in the affidavit.
So was this peer reviewed?
Yes.
Do you think there would have been any issues in the peer review process if each of the 5 instances we just talked about, you had said that the data show that it will exacerbate these circumstances?
It's possible, yes.
Okay, but you were comfortable saying it today in your affidavit and in your testimony?
Comfortable saying it today in my affidavit based on professional opinion, in addition to the study cited here. And my professional opinion includes having reviewed a number of studies on this topic, of which this is an example.
This, I don't remember what exhibit this is, meaning the number, but
It's about to be 609.
okay, so it's not in yet.
Is it?
It's 79.
Perfect. See, 79.
So plaintiff 79, what's the, let's need it back. So this is from last year. So this isn't super old, this report.
Yeah.
Okay.
Now, I'd like to look at page 10 of this article as well. So on page 10, in the bottom left, you have a policy implications paragraph. You see that?
Yes.
Okay. And in there, you state that abortion restrictions are rooted in white supremacist values, correct?
That is reflected in this article, yes.
Okay. And you were one of the authors of the article.
Mhm.
Okay. And you're a member of SisterSong as well, aren't you?
Yes.
Okay. And are you aware that when discussing the Life Act, they indicated and stated that it was rooted in white supremacy?
That sounds consistent with what I've read.
Okay. And I just want to understand, is it your opinion that any restriction on abortion is based in white supremacist values?
Generally, considering the fact that abortion restrictions, time and time again, evidence indicates that they disproportionately disadvantage and affect Black people in the US, including in Georgia. I think they are part of a long list of policies that have that effect and that we've documented. I would feel comfortable with that, considering
And
that.
do you think that the people who voted for it were acting out of some white supremacist values, to use your words?
Objection.
Overruled.
So I can't speak to what all voting people are thinking in their voting decisions.
Okay. Do you happen to know the race of the members of the General Assembly who voted for this?
I know that most of the policies, that we've seen, including abortion decisions for our state, may have people representing multiple, races as part of our, legislative body for the state. But I can't say what the exact proportion is.
So the answer is no, you don't know.
I cannot speak to that
Okay.
definitively.
And you're aware that the founder of Planned Parenthood, a plaintiff in this case, Margaret Sanger, expressed some racist views as well, right?
I am aware of that history.
Okay. And worked with the Ku Klux Klan to advance birth control, right?
I am aware of her advancement of birth control based on values that are, reflective in the statement that you highlighted in the report.
Okay, but yet it's abortion restrictions that are rooted in white supremacist values.
But there have also been some decision-making around other health decisions that reflect that.
Okay, let's talk about abortion access a bit, because here again, you said earlier today that the Life Act, I believe your quote was, will drastically decrease the ability to get care. Does that sound right?
I would love to be able to see that if we're referencing specific language.
No, I'm sorry, it's from your testimony an hour ago.
Okay.
But we are going to look at your affidavit. We can pull it up, Josh. Specifically page 20. So I'd like you to just read the heading of section 4, if you could.
Sure. The ban will force Georgians who need abortion to either travel out of state for abortion care, to attempt to terminate their own pregnancies, or to carry their pregnancies to term and give birth.
And you would agree with me that the law doesn't actually support that statement, right? I mean, that the text of the Life Act doesn't support that.
The text of, I think this statement refers to the anticipated impacts that the Life Act will have.
Okay. Well, you say that it will force Georgians who need an abortion to do one of several things, but the Life Act permits a woman to obtain an abortion if she was a victim of rape or incest, correct?
So I just want to qualify something I just said. So these effects are already being had and are anticipated to continue. Could you repeat the question?
Sure. You state that the Life Act will force Georgians to do one of these things. And I just was asking you if you're familiar with the provisions in the Life Act, like the provision about rape and incest, the fact that it's a 6-week provision. There's a provision about maternal mortality, fetal anomalies, that this doesn't seem to be accurate based on the text of the law.
I would love to reference specifically the text that you are referring to. If
It's
possible, is that?
Of the law?
Yes, if.
Sure, we can pull up the Life Act. Well, it's coming up. You understand that the Life Act, I believe we were talking about earlier, it begins to restrict abortion after the presence of a heartbeat, correct? Around 6 weeks?
Fetal cardiac activity around 6 weeks.
Okay. So that would mean that before then, it doesn't restrict abortion, correct?
Correct.
Okay.
Well, I shouldn't say that it doesn't restrict abortion. I think, well, it's, or access to abortion is restricted for people with certain circumstances. But yes, this specifically, this law has a cut point around what you've suggested.
So I think what you're saying there is up until 6 weeks, the law does not prohibit abortion. Is that correct? Just want to make sure we're on the same page.
My understanding.
Okay.
And Dr. Rice, we are not holding you to, all Mr. Field can ask you for is your understanding. You're not on as the legal expert. Don't feel like you're being forced into that role.
Yes, so that's my understanding.
Okay.
I just want to clarify that not everyone is able, who wants to access abortion can access it before 6 weeks.
Okay.
But they're not prohibited by law. They may be prohibited by socioeconomic circumstances or a parent or something, but.
They are not prohibited by this law. Yes.
Right.
But the point I read on page 20 of your affidavit says that it's the Life Act that's going to force Georgians to do this.
The having made the sort of impose this around 6 week limit does have that anticipated effect, current effect and anticipated effect.
So I believe you wanted to look here, we can go. I just wanted to make sure that, I mean, you're comfortable with the statement that the Life Act does in fact include a provision about medical emergencies. Is that correct, or do you need to see?
Yes, that does include a provision about medical.
And likewise, a provision about medical futility,
I,
medically
Yes, I
futile
see
in
it.
paragraph 4 there.
mhm.
Okay. Now, you just mentioned the 6-week point, so I just want to ask a quick question there. You indicate in your report, and you may have even said it today, but you indicated in your report that many people don't know that they're pregnant by 6 weeks because of irregular menstrual cycles. Is that right?
So many people do not know, and people with irregular menstrual cycles may be less likely to, or are less likely to know it as early.
But do you have any data on how common that is in Georgia?
The data that we cite is not specific to Georgia.
Okay. And you'd agree that a woman could take a pregnancy test even before a missed period, correct?
The women do, yeah, can.
Okay. Now, on this abortion access point, in your rebuttal report, in paragraph 6 of the rebuttal report, you state that, well, it's coming up, it's important from a public health perspective for Georgians to have autonomy over their reproductive decision-making. Does that sound familiar to you?
That sounds familiar.
Okay. Now, this would include, when you're talking about autonomy, you're talking about, among other things, the decision to obtain an abortion, correct?
Correct.
Okay. Now, does that autonomy extend to 10 weeks gestation?
I am not imposing a gestational limit on right to autonomy.
Okay. So that right to autonomy that you say is important from a public health perspective is from 0 to 40 weeks.
All people at any stage in pregnancy or not should have reproductive autonomy.
Okay. Which includes the ability to get an abortion.
Yes.
Okay. So in the paper we were looking at earlier, this is Plaintiff's Exhibit 79. This is the one titled Racial, Ethnic, Educational Inequities. You suggest, so we were just talking about the woman's autonomy, but you also suggest this in the context of race. And I just want to make sure that I understand where you are in that. This was Plaintiff's Exhibit 79. You state that abortion restrictions compound racial and ethnic socioeconomic inequities in infant health. Do you recall that statement? We can pull it up if you need. On page 11.
Sounds consistent.
Does that sound right? And if we go back to page 3, you list 18 restrictions that you analyzed in this report. Does that sound right?
I would need to verify.
It carries on the bottom of the column over to the top of the next column.
Yes.
Okay. There's things like abortion facility licensing requirements, gestational age limits, and partial birth abortion bans. I just want to understand, are you saying that all of these lead to racial inequities?
So the study is a assessment of whether having a more restrictive abortion policy environment is associated with these inequities. So I can't necessarily speak to the specific policies on an individual basis, given that the study looked at an index.
Okay. Are there any here that you think are okay? Any of these restrictions?
I would not, I think to the degree that they prevent access to reproductive health care, I do not.
Okay. And one thing you discuss here that you contend limits abortion access is counseling requirements. Do you recall?
Yes.
Okay. And you discuss it actually in your affidavit. Now, what I'd like to understand, you call them biased. Does that sound right?
That sounds.
Called what biased?
Counseling requirements. And I guess what I'd like to understand is, what is your basis for saying that counseling about abortion is biased?
So the reference is not to just generally counseling about abortion. The reference is to the requirement that counseling about abortion include information that is not scientifically sound, or include the requirement that people have to present in some cases multiple times in order to be counseled and then return and receive care.
And you're not a physician, correct?
I am not.
Okay. And haven't attended medical school?
I have not attended medical school.
Have you treated any patients who were pregnant, considering an abortion, anything like that?
I have not provided abortion care.
Okay, so you can't opine on what's necessary as part of the abortion process or abortion care process, correct?
There is a large body of literature that speaks to what is, necessary versus unnecessary in terms of counseling around abortion care. So the comments that have been made in, some of the referenced documents are reflecting having reviewed that literature, including much of which includes the opinion of physicians.
Well, that's what I understand. What do you understand the counseling requirements here in the state to require?
So we spoke to that specifically in the report. If you would like to reference the specific state counseling requirements.
In the interest of time, I just want to make sure that we're talking about the same thing. This is a counseling requirement about, for instance, the medical risks of abortion, but also the medical risks of continued pregnancy, right?
And so yes, some of the counseling requirements include requirements for the inclusion of specific information around that. And in some, I think the study that you were referencing was a review of or analyzed data from states across the US. And for some states, there are requirements to include specific information that once again is not medically sound.
I guess my question is, do you think it's appropriate for an individual who is considering an abortion to be told about the medical risks of abortion?
So absolutely, medical risks that are, medically, scientifically indicated risks, but there are some that states have included, once again, that are not, the large body of evidence does not indicate our medical risks.
Okay, but now you're on the board of the Feminist Women's Health Center, correct?
Correct.
Okay. And they also say that, it's important to provide counseling to educate patients before they have an abortion, correct?
I think counsel, as someone is receiving healthcare generally, is a common practice.
And I'm sure that the Feminist Women's Health Center would counsel about abortion, but also about other options like childbirth and adoption and other things, right?
Around a variety of healthcare that they provide.
Do you know if they counsel on those topics, like about adoption?
So I can't speak to what they specifically counsel around. I am aware of their practice of providing counseling around the healthcare that they provide.
Right. And they say that counseling is particularly important because everybody has to make an informed decision before they have an abortion, correct? Does that sound right?
Informed healthcare decision
The
making.
witness has already testified that she doesn't know exactly what feminist counseling entails. So she has already indicated that she doesn't know the answer to this question.
Your Honor, I would say that she said she doesn't know specifically, but then said, around about all topics. So I was just asking if she knew about these three specific ones that I identified. If she doesn't, I'll move on.
Okay.
But I just,
All
I want
right,
to.
you either know or you don't. Well, let's see if we can short circuit this. Do you have any idea, other than generically, they'll provide healthcare counseling in the counseling as to what's covered?
I can't speak to what specifically covered, not having actually, been providing care, but I think that I was speaking to general healthcare decision-making and counseling I know is provided there.
And on the topic of counseling, the Feminist Women's Health Center also talks about post-abortion counseling, correct? Do you know that they offer that service?
I can't speak to what services are provided versus not provided, but
I mean, you're on their board, right?
welcome, absolutely.
Thank you, sir.
Very briefly, this is an aftercare guide from the Feminist Center in Atlanta. And if you look on the bottom of the second page, Dr. Rice, you'll see that one emergency topic they highlight is that you may, after an abortion, feel overwhelmed by your emotions. And if you think that you may hurt yourself, they give a number to call. And then over on the fourth page, you'll see at the top, it says, after an abortion, women report feeling many things like relief, sadness, anger, or confusion. And they offer counseling services for that. Correct?
That's what I see here.
Okay. Now, all I want to really touch on with this is, do you have any reason to doubt what it says here, that women who have abortions feel these emotions like anger or confusion or sadness?
I would say that pregnant people, after receiving any, procedure or after giving birth, experience so many of these things. So I don't think that this is specific to abortion care.
It's called Aftercare Guide about abortion, right?
Yeah. However, I've received aftercare after giving birth, guides that tell me to look out for many of the same things.
Not to belabor the point, but it does say after an abortion, women report feeling many things like relief, sadness, anger, or confusion.
I do see that.
Okay. And you don't have any reason to disagree with that, correct?
No, in fact, I feel that after many reproductive experiences, including childbirth, women may report feeling relief, sadness, anger, confusion.
If we could just move this. I think it's 609.
609. Any objection to Defense Exhibit 609? Admitted.
Okay. I'd like to just hit on a few things briefly before we finish. And that's another thing you talked about today was travel. And you indicated, I think you spoke about how individuals in Georgia now will need to travel further, correct?
Yes.
And that was a burden.
Yes.
And I believe you referenced Florida. Are you aware of what North Carolina's abortion laws are?
I believe that, I know that there is greater access in the state of North Carolina relative to Georgia.
In the state of, pardon me?
North Carolina
North Carolina.
is another. I was asked to provide an example earlier, so I started with.
Okay. Right, because I understand it, in North Carolina, there's a 20-week rule, and in Florida, it's 15 weeks. But I guess what I want to hit on here very briefly is, isn't there also data, and in fact, some cited in your study, like the Adante study, which suggests that women actually are more likely to travel outside of their communities to obtain abortions in order to avoid being recognized?
So there are circumstances in which people may prefer to travel some further distance to obtain care for those reasons. However, it's not clear that they would prefer to travel across state lines, across multiple state lines, and the distances that are currently required to access abortion care in Georgia.
Without getting into the study, we can explore it in briefing, but I mean, it just talks about distance traveled. There's not a special threshold at the state line, right? You don't remember anything that looks at state lines specifically in the Adante study?
So, no, I don't remember anything that looks at that specifically. I just give that context, given that, I know that we're able to assess some components of larger phenomenon in these studies.
Do you also recall the Adante study talking about the stress that women feel when they're obtaining an abortion?
It would be great to.
Okay, sure. It's Plaintiff's Exhibit 65. On page 5, I believe it is. Page 5 down in the discussion, there's a beginning in the middle of the second sentence, it says, regardless of distance traveled, the majority of participants scored moderate stress or high stress on the PSS, reflecting that women undergoing abortion are in general experiencing significant levels of stress. Does that refresh your recollection about this?
Yes, I see
Okay.
that.
So you would agree with that statement that women undergoing abortions are experiencing stress, correct?
That is reflected here.
I'd like to discuss one last thing with you. Because there's a topic that I didn't see addressed in either of your affidavits. Now, do you recall writing an article called "The Social Norms and Stigma Regarding Unintended Pregnancy and Pregnancy Decisions"?
Yes.
And just correct me if I'm wrong, but this is a study that was a qualitative study of 46 young low-income women in Birmingham, Alabama, correct?
Correct.
And in your reports, the two affidavits you submitted here, you never discussed the benefits of motherhood, correct?
The benefits of
Motherhood, correct?
Those studies did not, or the reports did not focus on that specifically.
So that's a yes, you didn't discuss that, correct?
Did not discuss that.
Okay. But in this study, I'll note, let's start looking at page 8. And again, this was a study looking at low-income women in Birmingham, Alabama, that were faced with decisions after they had an unintended pregnancy, correct?
Correct.
Okay, and you had respondents who responded with, for instance, in the middle of page 8, your summary statement here is the participants commonly shared feelings that women who adopt or abort are at a disadvantage in that they miss these or other motherhood experiences, such as milestones in their child's life, correct?
So I think this is a reflection of what a group of young women perceived, that they've, perceived how they perceive their experiences relative to others, but I'm not sure that they can speak to, what others may be missing out on.
Okay. And if we go down 2 more paragraphs, most participants felt that the choice to parent was an act of selflessness, strength, and responsibility, regardless of socioeconomic circumstances, correct? Did I read that correctly?
So that is what they, how they saw the experience of parenting. I think it does not necessarily indicate that others do not have,
Sure.
other
And
experiences.
in the interest of time, I just want to make sure I read that correctly for the record. And then on page 10, there's another statement that says, according to participants, women should cherish the ability to get pregnant, carry a pregnancy to term, and have a healthy child, given that some women can't have kids and some pregnancies end in fetal or maternal death. Did I read that correctly?
Yes, once again, according to this group of participants, they felt that, people who, make that decision. And so I think what is maybe not reflected in these quotes is that there are people who were in a number of different groups reflected here. They may not have been in circumstances in which they were forced to carry a pregnancy to term. And I think those are some important distinctions.
It's fair to say that throughout this report that you authored, there are numerous respondents. I just only picked up a few, where the respondents from the 46 young low-income women felt that they wanted to have a baby. That's it. Yes?
That is a yes. It does not negate the fact that some people do not want to have a baby.
And you ended with a conclusion, if I read this correctly, your conclusion was that something needs to be done to change that, right? Because you talk about these views and these responses as being the product of stigmas, not the product of actually their desire to have a child.
The conclusion references needing to change the fact that a number of people who want to have an abortion, who choose to, carry a pregnancy to term and adopt, people in both of those groups, which was not highlighted here, experience a degree of stigma that is harmful to their well-being and to their decision-making. And that if I'm recalling correctly, is what we were referring to as needing to change.
Okay, and you also, just last point, you also reference some of these women feeling made to have an abortion, coerced to have an abortion. Do you recall that?
I recall there being people who we spoke to who had, at least maybe one person or two who had the experience of feeling that they were, had people in their lives, whether a parent, some of these people were, young adults and had these experiences as minors, that they weren't able to make decisions for themselves.
But in your rebuttal affidavit, you say that there is also no basis for Dr. Coleman's conclusion that low-income people are likely to seek abortion due to coercion.
So
doesn't your study suggest that there are in fact people who face that coercion?
So in the rebuttal, we referred to the opinion that people's socioeconomic circumstances specifically were, if I'm remembering correctly, akin to that form of coercion. And I think we highlighted, or I highlighted specifically that, and other studies highlight that people should be able to make decisions regardless of their socioeconomic circumstances.
But you agree there are some low-income women faced with unintended pregnancies who felt forced to have abortions. That's what we just looked at.
Felt that their, parents, or that they were in contexts in which they were not able to make decisions aside from, the opinions of others in their lives. And there were a number of people also in the study for whom that was not necessarily the case, but there did exist people for whom their decision-making reflected the desires of some other party. And as we speak to in the, or as I spoke to in the affidavit specifically, and other research speaks to, collective, we, scientific community, speaks to the fact that people should be able to make their reproductive decisions.
No other questions?
Do you have any redirect?
No, Your Honor.
All right. Can Dr. Rice step down?
Yes.
Thank you, Dr. Rice, for your time and your testimony.
Thank you.
Appreciate it. We're going to take an afternoon break now. The next witness from plaintiffs is, all right, we're doing a lawyer rotation here. All right, and that doctor is here? Yep, there she is. Okay. Let's reconvene at about 3:45-ish on the wall clock, and we'll have that witness ready to go. In terms of everyone's timing, plaintiffs, you're at 3:56:33. And defendant, you recently passed plaintiffs. You're at 3:48:04. See you soon.
He was. So this is our bird, right? Yeah, Christopher. Yes. I'm not.
Well, knock on the water, man, see.
Much better this time. These breaks are way too short. All right, before we get started with Dr. Meltzer Brody, it is 10 minutes to 4. How long do you envision the direct examination going?
Probably just about 30 minutes.
3-0?
Yes.
Okay. And Mr. Field, are you on the hook again?
I am not, Your Honor, but I had one housekeeping matter first.
We'll do that in a minute. Who's going to handle? Mr. Scher, you haven't heard direct yet, but you've read affidavits. How long do you think cross will be?
Probably about the same.
Okay. Well, let's make it our stretch goal to complete this witness's testimony. And it's fine by me if we go a little past 5, as long as we don't hear a thud from stenographer April. As long as she's sticking with us, then we'll be good.
I think you'll be good, Your Honor, because I'm on mute most of the time.
Oh, well, that'll be too bad. Then you need to get one of those little buttons you press when you fall down and can't get up. That's where you're going to be stuck.
I'm good, Your Honor. Thank you.
Okay. Yes, ma'am.
I did want to just raise one thing. We had our fact witness who is here and she's been waiting outside all day. We expect her testimony to be pretty short, but I recognize that it's getting close to 4 o'clock. She also has some scheduling conflicts tomorrow that she wouldn't be able to come back until the afternoon. So I guess we're just looking for a little direction for if we should let her go home, if she should hopefully stay, if we are, stick to our estimates and get Dr. Meltzer Brody done in the next hour.
Right. So I have to get out of here around 5:40, or I'll have a kid standing on a curb and then defects, and then there'll be no judge tomorrow. So that's my deadline. If we end earlier than that, I won't be sad. But you need to manage your witness's schedule. If we want to flip things around and take your fact witness next, we could do that. But I'm seeing
Brody's flying out this evening.
heads are shaking vigorously that that's not going to happen. I don't want to delay any more testimony, and we can see how far we get with fact witness today. If when we're done with Dr. Meltzer Brody, it's not too late. But it sounds like if it doesn't happen today, then it will be later tomorrow. And I think we had talked about there may be witnesses called out of order, and everyone's being mature about that, because we'll be able to tell who's saying what about what.
Okay.
Okay, sure. I didn't mean to leave you hanging there, Mr. Field. Do you want to admit something?
I do. I would like to admit the last article that we were talking about, social norms. We've had it up on the screen.
Okay, that wasn't already a plaintiff's exhibit.
That's correct.
Okay, so defense 610. Is that defense 610? I think it would be. The 609 was the excerpt from the website at Feminist Center.
I believe that's correct, Your Honor.
Okay, any objection to 610?
No, Your Honor.
Ms. Oh, you're going to speak for Ms. Okay, all right. She got out of here. She's done. Okay, great. Then that's the plan. 610 is admitted, and I need you to introduce yourself again.
Good afternoon, Your Honor. Joanna Zacharias with the ACLU on behalf of plaintiffs.
Ms. Zacharias?
Zacharias, yes.
All right. Good afternoon. Dr. Meltzer Brody, if you'd work this way, please. Hey.
Yes, I do. Samantha Meltzer Brody, SAMANTHA, Meltzer, MELTZER hyphen Brody, BRODY.
All right.
Good afternoon, Dr. Meltzer Brody. What is your current profession?
I am a psychiatrist, and specifically a reproductive psychiatrist.
As you know, the court already has your 2 affidavits in your CV and evidence, so I'm just going to ask you a few questions about your credentials. First, can you briefly describe your education, starting with your undergraduate degree?
Yes, my undergraduate was at Simmons College, which is now Simmons University in Boston, Massachusetts. I attended medical school at Northwestern University in Chicago. I came south to attend residency at Duke University in Durham, North Carolina, and then traveled 8 miles up the road for a fellowship at Carolina, which has greater impact in those parts of the woods than it does here. And got an MPH and did a research fellowship with the Robert Wood Johnson Clinical Scholars Program before becoming a faculty member.
And where are you currently employed?
I'm employed at the University of North Carolina at Chapel Hill.
And do you work within a particular school at the University of North Carolina?
I'm a faculty member in the School of Medicine. Specifically, I'm the department chair. I'm the Assad Maimande Distinguished Professor and Chair of the UNC Department of Psychiatry.
Do you hold any other positions at UNC?
I'm also the director of the UNC Center for Women's Mood Disorders.
And what do those positions entail?
The department chair is a very large academic department of psychiatry with about 360 faculty, 100 plus trainees, a very large clinical footprint, a top 20 NIH funding portfolio, and all the staff that help us run the department to serve the people of North Carolina. In the UNC Center for Women's Mood Disorders, it is a clinical research, internationally renowned program that provides clinical care and research and training for mood disorders across the reproductive life cycle.
Thank you. And how long have you been on faculty at the UNC Department of Psychiatry?
Over 20 years.
And how long have you been working with the Center for Women's Mood Disorders?
So I was the founder of the perinatal psychiatry program in 2004, became the UNC Center for Women's Mood Disorders in 2006. So I've been working, my focus has largely been on mental health of women for over 20 years.
And have you ever been published in a peer-reviewed journal on a topic relating to women's mental health?
Yes, I have. I have published between chapters, book chapters, journal articles, abstracts, and other things, a couple hundred articles, papers, and books.
And what is the focus of your scholarship?
Most of my scholarship has been on reproductive psychiatry and perinatal mood and anxiety disorders, both pregnancy and postpartum depression.
And do you have experience serving as a peer reviewer for any journals?
Yes, I am regularly a peer reviewer for many journals in women's mental health that spans from Lancet Psychiatry, JAMA Psychiatry, Biologic Psychiatry, as well as the interface with women's mental health and OBGYN journals published in and review for the Green Journal, American Journal of OBGYN.
And you mentioned the acronym JAMA. What does that stand for?
The Journal of the American Medical Association.
Have you ever received any professional awards?
I have been very honored to receive a number of professional awards, including locally at UNC. Departmentally, I received the OMAX Gardner Award in 2020, which is given to the faculty member who's made the greatest contribution, I think, to humanity or the human race out of the 17 state universities in North Carolina. So I was extremely honored by that award. I received in 2019 from the American Psychiatric Association the Alexandra Simmons Award for Women's Mental Health. Last year, I was named the #1 expert on postpartum depression in the world by ExpertGate, which is a scientific ranking type of thing. And most recently, I've been ranked in Forbes 50 over 50 women advocating for mental health. So now you know I'm over 50. And then most recently, I was listed as the top 16 healthcare innovators in the United States.
Thank you. And what type of patients do you see in your clinical practice?
I care for mostly women with reproductive mood disorders.
Approximately how many pregnant patients have you directly treated in your career as a psychiatrist?
Thousands of women.
At this time, plaintiffs offer Dr. Samantha Meltzer Brody as an expert in reproductive psychiatry.
That's just those two words. That's easy for me to follow. Excellent. All right. Mr. Chair, any objection? Okay. Doctor, you are probably not for the first time qualified as an expert in the field of reproductive psychiatry.
Dr. Meltzer-Brody, you provided 2 expert affidavits in this case regarding pregnancy, abortion, and mental health. What is your basis for the opinions expressed in those affidavits?
The opinions expressed are based on my more than 20 years of direct clinical practice, also as a physician scientist, investigating and understand the literature in this area, and then the many, many years training the next generation as an educator.
And what is your opinion on the impact of pregnancy on a person's mental health?
Well, unequivocally, the literature shows, and certainly this is the basis of my entire career, that pregnancy is a time of very high risk for mental health conditions. We know that both anxiety and depression are some of the most common complications that occur during pregnancy and postpartum.
Do only people who have a history of mental health disorders experience such disorders during the perinatal period during pregnancy?
No, while certainly a history can increase your risk, we see many women for whom the first onset of a psychiatric condition is during pregnancy.
What kinds of
I
mental
have to ask one because you've used this term a bunch, both of you have. Perinatal in English means?
Yes, that's a good question. Perinatal is the broad term to be anytime during pregnancy and into the postpartum period. So the most generous definition postpartum is up to 1 year postpartum. Sometimes you'll see it more restrictive, which is pregnancy in the first 3 months postpartum, the so-called 4th trimester.
But perinatal includes both the entire pregnancy and some postpartum.
Yes.
Okay.
What kinds of mental health disorders are most common during the perinatal period?
There it is again.
Okay. The most common psychiatric disorders during the perinatal period are anxiety and depression. That includes what we would see as subthreshold disorders that would not meet criteria in the DSM for a full-blown disorder, or full-blown disorders, a major depressive episode of some kind. Anxiety disorders is a broad category from generalized anxiety, panic attacks, panic disorder, PTSD, OCD, and then on the mood disorder spectrum, including in the perinatal period, bipolar disorder, and then the subsequent risk postpartum of postpartum psychosis.
For patients with a prior diagnosis, how can pregnancy impact their mental health?
Well, a previous history of a psychiatric disorder is one of the greatest risk factors for a recurrent episode during a subsequent pregnancy. So for some women, pregnancy is particularly devastating to their mental health. We see women that only will have onset of symptoms during pregnancy or postpartum. For those that have a history, it can also exacerbate previous conditions.
Have you had patients who suffered a recurrence of a previously stable mental illness once they became pregnant?
Yes.
Have you had patients who have experienced a mental health disorder for the first time during pregnancy?
Yes, I have.
When a patient with a psychiatric diagnosis becomes pregnant, what options do they generally have with respect to managing and maintaining their mental health?
So the published first-line treatments are considered psychotherapy, and then depending on severity, medication. So as a psychiatrist, I'm generally prescribing medications. Those are the first generally treatments that are available.
You mentioned medication as a treatment option. Does the use of medication always guard against relapse or worsening of symptoms during pregnancy?
No, unfortunately, it doesn't.
Are there any risks associated with taking medication during pregnancy?
Indeed, there are, and that's the great complexity of caring for perinatal women. So if, for example, I have a patient with known bipolar disorder that enters pregnancy, the choices are complicated. A number of the medications for treating bipolar disorder are known teratogens. We know that stopping them will be associated with a much greater increased risk of relapse of symptoms during pregnancy. So it's really challenging, depending on the type of disorder, to make those decisions to keep the mother well, particularly women that have a severe psychiatric history, including of suicidal ideation or psychosis, and making the best treatment decisions.
And are there any potential impacts of medication on a fetus when a patient is pregnant?
Yes, there are. So Many psychiatric medications are known teratogens. For example, valproic acid, Depakote, is well documented for causing neural tube defects, including spina bifida.
You've used the term teratogens a few times.
Causing birth defects.
Okay.
Yeah. And lithium is well known for causing fetal heart anomaly, Epstein's anomaly, exposure in the first trimester.
In your experience, what impact can a relapse or worsening of symptoms have on a pregnant person?
Well, it can be devastating, and at worst, it can end someone's life. So when you have very severe depression, the outcome of very severe depression can be suicide.
I'd now like to turn to the law at issue today. Have you had an opportunity to review HB 481?
Yes, I have.
What do you understand this law to require?
My understanding of the law is that it restricts abortion at the time of any kind of cardiac activity detected approximately 6 weeks. And in particular to my interest, there's no exclusion for psychiatric disorders. So I believe there's an exemption for medical conditions. And there's an exemption for rape or incest, but only if it's been reported to the police. I would add that in my experience as a psychiatrist, most cases of rape or incest are never reported to the police.
When you say that, meaning you have treated patients who have shared with you, I had this situation and I never reported it.
Yes, that would be, I would say, most of the time.
In your opinion, is there any reason to exclude psychiatric illnesses as a basis for a medical exception under this statute?
No, I have dedicated my entire career to advocating for parity for psychiatric illness. The brain is an organ. We don't understand it as well as some other things like the heart or the kidney. It's actually much easier. The brain is enormously complicated. And because of that, there's been what I see as just a very unfortunate bifurcation of what we call medical conditions or psychiatric conditions. They're all medical conditions. And as a psychiatrist, my job is to provide the best care I can for the mental health of my patients, which is often life-threatening. Suicide is the greatest cause of maternal mortality in the world, one of the greatest causes of maternal mortality in the world. And the idea that we're going to exclude psychiatric illness, which is a medical illness, to me is just an enormous injustice and will result in women dying. This is something that I feel and always have felt passionately about in my work, including how we reimburse insurance coverage for any medical or psychiatric illness, parity legislation. So I believe there should not be any separation or exclusion of psychiatric or illness from any kind of consideration of what we're seeing as medical illness.
And in your expert opinion, is abortion ever medically appropriate to mitigate a psychiatric emergency?
Yes, it is.
What is your basis for that opinion?
Well, over the course of my career, I have cared for women for whom the patient came to me with the decision that they wanted to terminate the pregnancy because they felt that the risks of continuing it were devastating to their mental health, and they felt it was what was needed to preserve their mental health and in many cases save their lives.
Can you tell us a little bit more about those patients and what sorts of diagnosis they were dealing with?
So most of the time, these have been patients that have had complicated psychiatric histories. If you have experienced, I'm thinking of a couple of patients, postpartum psychosis, for which you literally go mad in the postpartum period. It's associated with suicide and infanticide. These are the horrible cases we read. You may never want to be pregnant again. And I can't guarantee those patients, I wish I could, that I will treat them in a way to prevent them from that ever happening. And I can try my best, and I can't always do it. And so for these women and the patients I've taken care of, there are patients who find the idea of a subsequent pregnancy to be so horrifying that they don't see a path forward. And they have felt in this case that ending their life would have been the only option other than terminating the pregnancy.
Can you provide any particular examples?
So I have had patients who have had, like I said, bipolar disorder with history of postpartum psychosis. I've had patients with severe major depressive episode who've become suicidal to the point that suicide was the only option they saw. I've taken care of a patient I'm thinking of with severe obsessive compulsive disorder. This person, every time they took a shower, would be convinced that they'd be contaminated if they saw the water bounce off the wall and then hit them, and then have to start over. And that would be hours and hours of taking a shower. And it just became so excruciating that ending their life seemed preferable. Certainly women that have exacerbation of PTSD trauma or subsequent panic disorder. So for women that have early life trauma, they have an increased risk of perinatal psychiatric disorders. That's felt to be because of epigenetic modification of trauma, because of dysregulated HPA stress axis, all kinds of things, and of the psychological trauma as well. And for those women, the idea sometimes of having a pregnancy continue that is so overwhelming, depending on the nature of the trauma. Was it, the nature of what happened, that they will see suicide as preferable to continuing the pregnancy.
Do you know if there are state laws that limit abortion, but have an exception for not just physical medical emergency, but truly any medical emergency? To your point, the brain is an organ, but it's health. There's physical health and there's mental health. And Georgia is taking strides towards parity. There was recent legislation passed that suggests we're moving in that direction. But I'm curious if you're aware of medical emergency exceptions to an abortion restriction that says, doesn't matter if it's your heart or your mind, if you will. If a doctor says this is a medical emergency and this patient will kill herself, kill the child, affect a major bodily function, whatever terms we're using, but it's psychological or mental health related rather than physical, that's sufficient for the patient to have access to that reproductive choice.
My understanding is that, and I cannot give you state by state examples at all. My understanding is there's states for which there's no distinction between the two. And then there's states or exceptions where it's been specifically carved out, as is this is.
I'd like to now turn to the opinions expressed by the state's witness, Dr. Priscilla Coleman, in the affidavit she submitted to the court on October 11th, 2022. Have you had an opportunity to review that affidavit?
Yes, I did.
What do you understand Dr. Coleman's opinions to be regarding the relationship between abortion and mental health?
Well, it's interesting because on one hand, Dr. Coleman specifically states that she realizes that anxiety and depression are common. There's common problems during pregnancy, that pregnancy in itself is a time of high risk mental health issues. And then on the other hand, she shows her work that's been published, which I should start off by saying has been widely debunked by the entire scientific community and all professional organizations, medical organizations.
Is it self-published or how is it out there?
It was published in journals, and it's an interesting question.
Okay.
But she asserts that abortion in a few of her writings causes further worsening of mental health concerns.
And in your expert opinion, is there any merit to Dr. Coleman's view that there's an association between abortion and negative mental health outcomes?
No, and I think that there's a much larger literature demonstrating that it does not. So studies by Trine Munch-Olsen using the Danish research registers, epidemiologic registers with studies by Julia Steinberg and others have shown that abortion does not increase the risk of mental health concerns. I think what's most compelling to me is just it's been debunked. Julia Coleman's work has been broadly criticized and debunked, including by the American Psychiatric Association, which is my professional body, the American Psychological Association, the National Academy of Art Sciences and Medicine, the American College of OBGYN, and the Royal College of Psychiatrists.
And what have those medical organizations said?
They have essentially all of them have made statements that there is no evidence that abortion causes mental health concerns. And I think earlier there was a discussion about association versus causality. So if you look at all the studies, you can clearly see that there is no, anyone could call it an association, a causality between abortion and a mental health concern. That is what has led all of these professional organizations to debunk Priscilla Coleman's work.
So help me understand, in some ways, what you're sharing seems a little counterintuitive. If we use the classical, uninformed male narrative, you brought a kid to term. It's beautiful. It's birth. It's a wonderful thing. Celebrate positive outcomes, good mental health. Oh, you killed your child. You because you didn't care enough about the kid, or you put your job ahead of it and you took your kid's life. I could see where, again, uninformed, focused perspective, that would cause the woman to be racked with grief and shame and lead to depression and anxiety, et cetera. So there is a naive perspective that would say, gosh, it seems like Dr. Coleman's theory is the way that data would go. You're saying it's not. I'm not doubting that at all, but I'm wanting to be educated a little bit on that.
Yeah, no, and I think it's very important, because one of my colleagues in my field, Kathy Wisner, who's at Northwestern and is probably a decade older than I am, and a distinguished scholar and psychiatrist and an inspiration for me.
She gets the award for people in their 60s.
Yeah, exactly,
Okay.
exactly. She will tell you that the reason she became a reproductive psychiatrist was she was a medical student, and a pregnant woman was in the emergency room with suicidal ideation and was examined by a male psychiatrist. And they came away saying, she's not depressed, because pregnant women are not depressed, because you can't be depressed if you're pregnant, because it's just such a joyous time. And at that moment, apparently a reproductive psychiatrist was born, as she was a medical student at the time. And I think what we see is that those kinds of, I call them old wives' tales, that motherhood in all cases should be joyous and happy and apple pie, and that if anything happened that you lost the baby or terminated the baby, you'd be racked with grief. I think those are unfortunately just sort of misnomers. Now, it is certainly true that women who want to have a baby and something happens to the baby are racked with grief. I mean, that's devastating. But I think that it all gets in my world with what is the woman's mental health history, what are the symptoms they're having now, what are the decisions being made and why. So it's always complicated and very nuanced. So there's never, always never, and wide generalizations.
Okay, thank you.
And of your patients who have decided to terminate their pregnancy, did any of them experience an improvement of their psychiatric symptoms upon termination?
Yes, they did. So the women for whom they found the idea of continuing a pregnancy untenable, the termination of the pregnancy resulted in relief of the worst of those symptoms. And that was really important. And that was what they decided. The patient decided in discussion with their family and shared decision-making that was in the best interest of preserving their mental health. Now, to be clear, if you have bipolar disorder, you had bipolar disorder, before you had an abortion, and you're going to have bipolar disorder after you have abortion. So abortion is not curing your bipolar disorder by any stretch of the imagination, nor is it making it worse. It's that the decision by that in particular woman that ending that pregnancy was in the best interest of her mental health. And in these cases, we're talking about severe situations. The patients I have taken care of, that was met with enormous relief.
Dr. Meltzer-Brody, in your opinion, what would happen if a pregnant person experiencing a psychiatric emergency was unable to obtain an abortion they wanted in order to alleviate their psychiatric symptoms?
Well, I think we end up with having potentially very dire consequences. In some cases, it would result in the mother ending her life.
Are there any other potential consequences?
yes, the patient could continue the pregnancy, and then we would do everything we could to treat the patient as well as we could. And the outcome would vary as it does from, the patient could potentially do fine, and the patient could do poorly in one way or another.
No further questions.
Mr. Scher?
Good afternoon, Dr. Meltzer-Brody.
Good afternoon.
Can I begin by congratulating you on what appears to be a very impressive career as a scholar and as a practitioner? And I can't say that I envy you the divided loyalty that you must feel every weekend as a graduate of both Duke and UNC. Now, in your practice, have you treated women who experienced the death of a child who had already been born, or who experienced a miscarriage?
All of those.
Okay. And what kind of mental health issues can arise when a parent loses a child who's already been born?
Oh, I think that without a shadow of a doubt, the literature is very clear that the death of a baby who's been born, so either from SIDS or I recently have taken care of a woman who had a stillbirth at term. Absolutely devastating.
Okay. And you mentioned several specific conditions that a woman might have during pregnancy, like PTSD, OCD, bipolar disorder, depression. Can those all occur in the wake of a death of a child who's been born?
Certainly, yes. I think it's really important that we absolutely keep in mind all these things can occur before you're ever pregnant.
Right.
They can occur during pregnancy, or they may happen after pregnancy. So again, everything with mental health, some things are precipitated by life events, some things are not. And with PTSD in particular, you may have PTSD because of childhood sexual trauma that you've been battling. You may be a military veteran. You may have been in a motor vehicle accident or witnessed some other horrific event that predates any kind of pregnancy.
Okay. And what kind of mental issues can arise when a parent loses a pregnancy from a miscarriage?
Well, we know that the literature in my practice, and I've always felt really grateful for this. I have the privilege of taking care of women at some of the most vulnerable times of their life. It may be infertility and the anguish that happens with infertility for women that want to have a baby. It may be due to miscarriage. It may be due to an unwanted pregnancy and the devastation that comes from making decisions around that. It may be due to pregnancy-related anxiety or depression. It may be related to postpartum depression or psychosis. It may be related to losing a child at a stillbirth for a wanted pregnancy. So all of those things can cause psychiatric issues.
And those issues can also arise even when the pregnancy was not planned, correct?
Sure.
Okay. So isn't it at least possible that a person who loses an unborn child from an abortion would likewise experience the kinds of mental health issues that we've discussed?
Well, I think that the idea is not that what I have observed in my work is that anytime there's reproductive flux, you're at risk for any kind of mental health condition. And that for someone who has decided that they want to end a pregnancy because they feel that that is in the best interest of their mental health unequivocally, that's a very specific type of decision, which is utterly different than someone who has a miscarriage of a wanted pregnancy or someone that loses a baby, at any other time in the pregnancy that they want that baby, or loses a baby to something like SIDS. They're qualitatively quite different.
So are you saying that a woman who loses a baby to abortion that she wanted can never experience as a result of that the kinds of conditions that we've discussed?
No, I'm not saying that.
So it can happen.
Yes, it absolutely can happen.
Okay. And have you ever treated a woman who had an abortion and then experienced mental health issues?
I have taken care of women who have had an abortion, who had psychiatric illness, and who felt that it was in the best interest of their mental health that they had that abortion. Yes.
And have you ever treated a woman who regretted having abortion after the fact?
I have not.
That's never occurred in your practice.
It has never occurred in my practice that I've had someone who came in with the chief complaint. And then again, I take care of women during the perinatal period, but I've never had someone come in specifically with the chief complaint of, I had an abortion and I regret it, and now I have a mental health issue. I'm not saying hypothetically it can't happen. I have not personally taken care of someone.
Whether or not it was the chief complaint, if it was even a non-chief complaint, you've never encountered a woman who regretted having an abortion?
No, actually, most of the overwhelming majority of everyone I've ever cared for, I work to help them carry their pregnancy to term and have a baby.
Okay. So how long after an abortion do you typically treat your patient?
I see patients sometimes for a one-time consultation to talk about what is the best medication for me to be taking during my pregnancy. I can see people shorter term or longer term, so there's no one answer on what that is.
Okay. So what's the longest after an abortion?
I would say, I'm trying to think, most of the patients I care for, I take care of during the perinatal period, and then generally after a year or two, transition them out. I have some patients that I've taken care of for years.
But for women who received an abortion, when does, in your view, when does the perinatal period close after a woman has had an abortion?
The overwhelming majority of people I take care of, I usually take care of them through 1 year postpartum, and then just to make room for everyone else coming in, people graduate out.
And is that true also for women who choose abortion?
Yes, that would fall under women who have had abortion, which again, sir, is the minority of my practice.
Sure. Now, you said in your report at paragraph 38 that for some patients, there's no other treatment that would be as effective as abortion at helping them stabilize. Do you recall making that statement in your initial affidavit? Okay. Now, you didn't sign any data for that claim, as I recall. Is that correct? You just relied on your clinical experience.
Don't answer yet. Yes, ma'am.
Could you please provide Ms. Masabodi with a copy of her affidavit so she can review that?
Sure, and we can pull it up on the screen.
Get it up on the screen.
Does she not have a copy of her affidavit?
Not in front of her.
Okay.
I don't have it in front of me.
Well, let's pull it up on the screen. I assume that'll be adequate.
Yes.
Okay, thank you. So you can see the final sentence says, for some patients, there is simply no other treatment approach, either pharmaceutical or therapeutic, that would be nearly as effective as abortion at helping them stabilize. Did I read that correctly?
Yes, that is correct.
Okay, and there are no sources cited. There are no footnotes or anything with any data. Is that correct?
No, I did not reference a study there.
Okay. And as I think you've said, the vast majority, and perhaps even all of the women who come to your practice for treatment are either pregnant or postpartum. Is that correct?
Most, yes.
Okay. And most of them are already struggling with some kind of mental issue before they come to see you. Is that fair?
Well, I am a psychiatrist.
Right.
Yes.
So they're
generally speaking, that's why
they come to you with mental health issues.
Yes.
Right. Okay. Good. And what do you define as a mental health disorder?
Well, as a psychiatrist, and based on my training, we are trained to conduct a clinical assessment following very specific scientific guidelines that we spend 4 years of residency training, learning how to conduct based on the literature and the DSM. and what's considered gold standard by the scientific community for a clinical assessment. So it's grounded in the evidence, it's grounded in the DSM, for better or for worse. Unfortunately, in psychiatry, we don't yet have blood tests that I can do a blood test and say, you have schizophrenia and you have bipolar disorder. And I hope I live long enough one day to see that. That would be awfully nice. But for now, it's based on what we see as consensus opinion, gold standard, what's considered state-of-art clinical examination.
So is it fair to say that you would include in the definition of a mental health disorder everything from postpartum depression to severe psychotic disorders and everything in between?
Well, anything that's in the DSM would be considered a mental health psychiatric disorder.
Yeah, and just so the record's clear, the DSM is the
Diagnostic and Statistical Manual.
okay.
What number are we on now? 5?
Yeah, getting ready for 6.
Okay. But in your report, you didn't break down the percentage of pregnant women who suffer from the various types of mental health disorders that can be occasioned by pregnancy, right?
We can do that if you'd like.
Okay, but you didn't in your report.
I did not in my report.
And so I'm going to take you up on your invitation.
Absolutely.
We'll do a little bit of that. And we'll do it from the studies that you cite in your report. And by the way, I assume that you consider the studies that you cited in your report reliable. Is that fair?
Yes.
Okay. So let's look at the O'Hara study, which is already in the record at Plaintiff's Exhibit 95. And if we can look at the bottom of page 4 and the top of page 5. And according to O'Hara, the incidence of postpartum psychosis is 1 or 2 per 1,000 births. Is that right?
Actually, it is now felt to be higher, but
Okay.
yes, that at the time of 2014 was what was seen, and commonly, thank God, I would say, it is one of the most devastating disorders. It happens quickly. So the prevalence of postpartum depression, in contrast, is 10 to 15%. The prevalence of postpartum psychosis is now felt to be higher than 1 to 2 per 1,000 births, not markedly high, but it's one of the most lethal psychiatric illnesses.
So not markedly higher. And 1 or 2 per 1,000 births, if my math is right, translates to a percentage of 0.1 to 0.2%.
Correct.
Is that right? Okay. And don't the data cited by O'Hara, and we can look at page 3, also show that major depression is at the high end, about 12% during pregnancy and about 7% afterwards, at least during the first 3 months. Is that a fair summary of what O'Hara says?
That is a fair summary.
Okay.
Yes. And they're talking here, just to be clear. So I know Mike O'Hara very well. He's talking about major depression at 7.2. I just saw Mike O'Hara last month, actually. He was talking about major depression at 7.2%.
Okay.
So that's major depressive disorder. If you look at the prevalence more broadly, you see broadly defined was 19.2%.
Okay, and that includes major depression plus
And minor depression.
and minor
Right.
depression.
But
Okay.
certainly, if the question is depression more common than postpartum psychosis or bipolar disorder? Oh, absolutely, yes.
Sure. But your report and your testimony today don't compare those figures to the rates of major depression or psychosis for women generally. Is that correct?
I think in my report that I talk about the prevalence of postpartum depression, perinatal depression, and anxiety at 10 to 15%. I believe that's one of the first sentences in my affidavit, but I'd have to look.
Well, but for women generally, not just women who are within the perinatal period.
Yes, there's been the ongoing debate for years on point prevalence
Right.
of women during pregnancy with depressive disorders versus point prevalence of women outside the perinatal period. Both are high. So women have twice the rate of major depression as do men,
Right.
partly because of the perinatal period, partly because of all the other complicating factors. The point prevalence at any one time during pregnancy is not necessarily greater than at any other point in a woman's life. What is uncategorically different is the postpartum period. So the first month in particular postpartum, the rates of depression are markedly higher at any other time point in a woman's life. That's also when you have the greatest risk of postpartum psychosis or postpartum mania or severe postpartum depression. So,
and that occurs in the population, or major depression occurs in the population generally at about the same rate or even higher than women who are pregnant, right?
well, no, it's about the same between any point prevalence in pregnancy versus the general population.
Okay.
But one of the greatest risks of postpartum depression or severe postpartum psychiatric disorder at birth, like postpartum psychosis or severe postpartum depression, is onset of symptoms either predating or during pregnancy. So I think that it's a little bit of apples and oranges, really, in terms of the vulnerability and the complexity of the perinatal period.
And let's go on. Let's go back to page 5 of the O'Hara report. In his study, he recognizes, without necessarily endorsing them, but he acknowledges that some studies have found what he calls a protective effect of mood stabilization and improvement for women with bipolar disorder during pregnancy. Isn't that right?
I think that there are some that believe, yes, that it can actually perhaps. Some researchers described a benign course, yes, but
Okay.
that is, other has described pregnancy as having no effect. All of that is completely different in the postpartum period. And so I think that is really what, in many ways, drives the concern with bipolar disorder, is that it may be quieter. And this is, this gets into an interesting discussion because many autoimmune disorders get quieter during pregnancy. And that's felt because women are actually in this hypercortisol state, which is what prevents women from rejecting the fetus, which is like taking prednisone. It's like taking a steroid, and that plummets postpartum. So sometimes there's been literature that suggested that, but then that all stops precipitously at the time of postpartum, which is where you have this burst of severe depression or postpartum psychosis after delivery.
But just so we're clear, it seems like you're acknowledging that the pregnancy itself, during the period of the pregnancy, does in the literature seem to have what Dr. O'Hara calls a protective effect on the woman.
He's speculating. He's saying it could be all of the above, but in no way would anyone, nor certainly Mike O'Hara, would not describe pregnancy as protective. He's spent his entire career taking care of pregnant and postpartum women during the perinatal period. So I think if you're trying to talk about bipolar specifically and say that that is mixed, yes, but trying to extrapolate that out beyond a categorical no.
Okay. And you also said in your report that pregnancy poses a significant risk of relapse of mental illnesses. Is that?
It can, yes.
Okay. And yet, let's go to paragraph 21 of your report. The only study you cite for that statement was a study by a man named Guglielmi of women who had OCD. Is that correct?
No, we talk about that a couple different times, actually. In my report, we also talk about the risk of relapse with bipolar disorder. So I think that particular situation I'm talking about OCD as well.
Okay. And what, if any, studies did you cite in support of your opinion about a relapse of bipolar disorder?
Well, we were talking about, it was about the risk of with major depression, and I believe if we want to pull up, I think it'd be good to pull up the affidavit to find that specifically.
If it's there, you can, your attorney can ask you about that. Now, I'd like to show you a chart, which I will mark as plaintiff's exhibit something, whatever the next number is.
So defense exhibit?
Defense exhibit, yes.
I think you'd be on.
You don't want to, the plaintiffs don't want to adopt my exhibits as their own?
We're either 610 or 611. Mr. Field wouldn't. 611, all right.
Dr. Meltzer-Brody, you reviewed Dr. Coleman's initial report in this case, I believe, correct?
Yes, sir.
Okay. I'll represent to you that this table I have provided to you called Table 1 is simply an excerpt from her report in which she listed recently published large-scale research studies on the association between abortion and mental health. Okay. And do you recognize the studies that are listed on that chart?
Yes, I
Okay.
recognize some of them, yes.
Okay. But as I read your affidavit and your rebuttal affidavit, you don't address any of those specific studies. Am I correct about that?
Well, I do indirectly. I haven't specifically, we didn't specifically focus on each individual study.
Okay.
The reason,
So let's,
the
go ahead.
reason, well, the reason that these studies and the systematic review have been debunked, and again, this is not just my opinion. This is the opinion shared by the American Psychiatric Association, the American Psychological Association, the Royal College of Psychiatrists, the American College of OBGYN, and the National Academy of Science and Medicine, is that the methodology is flawed. So there's very clear rules and guidelines on the conduct of a meta-analysis and systematic review. One of the first things is the quality of the studies included, the populations from which they're drawn.
I'm sorry, Dr. Meltzer, we've got limited time here, and I didn't want to invite you to go into a detailed recitation of your criticisms. I just wanted to be sure that we're on common ground, that your affidavits don't specifically address any of these studies, correct?
Well, but that's no, because the concerns that the criticism of her meta-analysis in particular, of which I believe a number of these are in there, but I'd have to look, I can't say that 100%.
Okay.
Is that, and the meta-analysis was earlier, so I think some of these, the ones from 1920 probably weren't in that one. So that would be the
Right.
case.
So not all of them were
Not
even
all of them.
available for her meta-analysis.
Yes. Mhm.
All right. So let's talk for a minute about suicide. Twice in your report, I think at page 6 and page 15, you say that suicide, and you said earlier today, suicide is a leading cause of maternal death. Do you recall
Yes, it
saying
is.
that? And you cite the study by Dr. O'Hara and another study by a researcher named Epstein for that statement. You recall that?
Yes.
Okay. Now, neither of those studies was looking specifically at suicide. Am I correct about that?
No, there are multiple studies that have been looked at specifically suicide. A UK study, and there's just, I heard last month at the Royal College of Psychiatrists meeting, the UK has a very large study, and they actually have death reporting of maternal deaths from suicide, which is different than this country, that unequivocally show the risk of suicide as one of the leading causes of maternal mortality.
And one of those studies was a paper by Dr. Oates, correct? Do you recall that? And that's one of the studies that O'Hara cites. Now, and let's turn to that. This will be a new exhibit for the defendants, which is number
612.
612. Thank you, Your Honor. So let's look at page 280 in the first paragraph. And Dr. Oates here concludes that in that study, the maternal suicide rate was 2 per 100,000 mothers. Is that correct?
Well, that's what that says in the paragraph there, yes.
Okay. And that's not just 0.2% or 0.02%, but 0.002%, right?
Well, I think that it's important to note that, thank God.
I'm sorry, if you could answer my question and then.
Yeah, no, I yes, that's what that says, but but thank God, the relative number of pregnant and postpartum women that end their life by suicide, that kill themselves, is thankfully relatively small.
It's almost infinitesimal.
No, I don't
right?
see it that way
Okay.
at all, sir.
But very small.
It's actually profoundly devastating. to everyone involved.
Sure.
And any suicide leads to generational trauma that increases suicide in multiple generations. So,
But it's a rare event, correct?
I wouldn't call it, it is unfortunately not as rare as we'd want to say. This is for one thing.
Well, it's much more rare than bipolar disorder, for example.
Oh, this is an old study for one thing. The data is widely in this study and generally underreported because when people die of suicide, there's often great lengths that go to hiding that it was suicide. It's gotten better, but in this study that came out, it was still relatively underreported. But I would never say that it's rare or that this is infinitesimal by any shape or form.
So let's look at page 250 of that same study, the first paragraph. Dr. Oates concludes from that study that the suicide rate was 3.4 per 100,000 people in the population of women in general. Is that correct?
That's what she concludes, but I would say that in the report I just heard when I was in Edinburgh, Scotland at the Royal College of Psychiatrists meeting, their report on maternal suicide, and they have an entire group that's focused, task group focused on this. It's much higher than previously thought. And it's absolutely devastating. So suicide in our country generally is not detected appropriately because families go to enormous lengths because of stigma to hide what happened. So this is 20 plus years ago or more. I still see that as for any mother that dies in that way by taking their own life is unbelievably devastating.
It's certainly a great tragedy.
And
we
it
would
is
all agree on that.
And it is actually thought to be higher than that in the newer literature.
But in this study, the suicide rate for women in general was still low, but significantly higher than the suicide rate for pregnant women, right?
I 100% agree that whatever is listed in this paper is what was reported as the data.
And you don't have any reason to think that today, at least you don't have any data to show that today the suicide rate for women in the general population is lower than it is for pregnant women, do you?
Well, it is true. And in the papers I've published with Trine Munkelschen looking at suicide in the Danish research registries, that in general, thank goodness, maternal suicide is, I would call it rare. I wouldn't call it very rare. I would call it rarer, but that it is a horrendous tragedy. And the rates are higher than what's reported here.
And this article also provides what it calls recommendations to prevent maternal suicide. And if we can go to the end of this article that lists the recommendations. For example, better identifying postpartum recurrences and better management of acute postpartum illnesses. I think that's at the end of the Oates paper, isn't it? Just before conclusions.
Well, the conclusion, she says, suicide following childbirth is rare, but the rates are higher than previously thought. That's what I'm reading on the screen.
That's not what he wanted you to read, though.
Right, but that's the part I'm reading.
No, there's a set of.
And then the next sentence is, and some women died despite exemplary care. And I would say one of the greatest tragedies in my professional career are the mothers I haven't been able to save from suicide, despite what I thought was trying to provide the best possible care possible and failed to have that kind of devastating outcome.
I think we're just about to the recommendations section, which is just before the conclusion. There we go. There's some specific recommendations near the end of the article. And the article doesn't make any recommendation on abortion as a way of dealing with maternal suicide, does it?
The recommendations on this page do not specifically mention abortion. That is correct.
Now turning to Dr. Epstein's article, Dr. Epstein cites another article that is specifically about suicide in footnote 47. If we could just flip quickly to footnote 47 in the Epstein article. And you're familiar with this study, right? The Epstein piece, it's one of the studies on which you relied.
Yes, sir.
So Dr. Epstein cites, it's at the very end where the references are. One more footnote. Well, footnote 47, yeah. You'll see there at footnote 47, there's a citation to an article written by Lindahl and Culp, right? Are you familiar with that article? Okay. And let's pull that article up. And let's look at the summary of it right at the beginning. The fourth sentence of the summary. Let's see.
The Lindahl article is very commonly cited.
Right.
Where it's commonly cited for 20% of postpartum deaths are due to maternal suicide.
Okay, and you can see that in the fourth sentence of that summary, Lindahl says that suicide deaths and attempts are lower during pregnancy and the postpartum than in the general population of women. Can you see that?
Yes, and I think that is, no one's refuting that, sir.
Oh, so you're not disagreeing with that?
I'm not disagreeing with whether suicide attempts and deaths are lower during pregnancy or outside of pregnancy.
Okay.
At any point prevalence time, more women are not pregnant than are pregnant, for one thing. For the other thing.
But the study here talks about rates of suicide, right?
No, I
okay.
understand. And I think the issue is when I'm treating patients during pregnancy and postpartum, I'm treating women with significant psychiatric illness, of which my job is to try and keep them well.
Right.
And prevent suicide.
Right.
Which happens, sir. And it is, according to 2020 Mom and the latest data, if it accounts for 20% of postpartum deaths, of maternal deaths, that's a scary number.
And what is the percentage of women who pass away from postpartum deaths after?
Well, after suicide, it's all of them because they're deceased after a suicide.
After a pregnancy.
Well, maternal mortality is actually increasing in this country, so it's a number going up.
So, but you're still not giving me the percentage, are you? Do you know the percentage of women
of all cause of maternal mortality?
Who commits, of all causes of maternal mortality?
I would defer to one of my OBGYN colleagues for what the latest data is right now.
Okay. And then if we continue in the Lindahl article, if we turn to page 81 there, Lindahl cites another article, which we won't get into, but another article by Appleby, and cites that article for the conclusion that consistent with lower rates of suicide in pregnancy, Appleby also found a low suicide rate among postpartum women in the first year post-delivery. You recall that?
That is indeed what the Appleby article says right there.
Okay, and you don't have any reason to believe that that pattern would be any different in the US than in England and Wales? Correct?
I think at the time the article was published, this is a study that is what Appleby found at that time. What I would add, sir, is what I've mentioned a few times. I think it's important for us to note. This is studies from the 1990s and 2000s, and in the UK in particular, which includes Wales, Scotland, Ireland, and Britain, they have—
Not Ireland, Northern Ireland.
Northern Ireland.
Boy, you're going to upset some
That is
people.
like, that was that.
Yikes, North
But it's not-
Carolina and Duke. You cross those lines.
It's an excellent point. My apologies. Northern Ireland.
But Dr. Meltzer, you haven't given us any other studies that come to different conclusions than
But
those, correct?
There is actually, this is what I'm saying is there is brand new data that I just heard reported that I will need to get the final report coming in. That it is a British report on maternal deaths, inquiries into suicide that is higher than this.
And are you telling us that the difference between the women in the general population and women who have just completed a pregnancy is different from the direction in this study?
Oh, I don't know if that's the case. I know that the rates of suicide are higher.
Okay. Now, again, on page 84 of the Lindahl paper under the discussion heading, Lindahl says, why don't we pull that up? That relative to suicide rates in the general female population, pregnant women have lower suicide rates. Is that what he says? Or she says?
Yes, he does.
Okay. And you don't have any evidence that that's different today than it was then, correct?
No, but I'm not sure I understand why it matters one way or another.
Okay. Now this page in the second paragraph under the discussion also says that suicide attempt rates, as assessed by hospitalizations for intentional injuries, are lower during pregnancy than otherwise, right?
Sir, as a
I'm sorry,
As a
you could just answer the question.
I'm answering
Okay.
the question. As a reproductive psychiatrist, my practice and my career has been focused on taking care of women with psychiatric concerns during pregnancy and
Right.
postpartum. I understand that your intent here is to make a point that the overall rate of suicide during pregnancy is less than outside of pregnancy.
And don't you think the legislature is entitled to take that fact into account in writing its laws?
I'm not an attorney, nor do I work for the legislature. But I'm finding it really hard to connect those dots, sir.
Okay.
So a woman's psychiatric illness, and we know that unequivocally that pregnancy is a time of much higher rates for psychiatric illness, or which may lead to suicide or other adverse outcomes.
But apparently from the studies, it doesn't actually lead to higher rates of suicide, correct?
Well, it leads to suicide, though. It's not that it doesn't happen.
But not higher rates compared to the general population.
I don't think that's the question at hand. I think you're trying.
But that's what he's asking. Instead, you guys are doing a good job of arguing. We're not having a debate. You've acknowledged all you need to do is what this literature says is that
Yes.
suicide attempt rates and actual suicides are lower on a percentage basis during pregnancy than outside of pregnancy. And you've explained why that's not particularly remarkable to you
And I
because,
said yes.
yeah.
Yes.
great. So we don't need to ask her that question again.
Correct. And let me just move on to the next point, which is the postpartum period. Okay. The study by Lindahl, if we go to the later on down that page in the right-hand column, Lindahl concludes that consistent with lower suicide rates in pregnancy, suicide rates in the postpartum are lower than expected in the general population. Right?
That is what that article says, yes.
Okay. And you have no reason to believe that it's that's wrong, do you?
No, I don't believe there's any reason that that's wrong.
Okay. And in fact, in a paper that you co-authored called Self-Harm in Women with Postpartum Mental Disorders, and that'll be another new exhibit for the defense. And I'm sure you're familiar with that paper, right?
Yes, this is the one I referenced. Thank you.
You're in it. I hope you know it. You're in it.
I'm in it.
Yeah.
I'm in it. I better know it.
This is the one with the Danes.
This is the one with the Danes. This is the Danish Research Registry. Yes.
And if we look on page 1567 in the first full paragraph, you conclude that motherhood in general appears to be a protective factor in terms of reducing self-harm, suicidal ideation, and mortality, right?
Yes, that the rates of suicide in pregnancy and postpartum, as we've already agreed upon, are less than the rates outside the perinatal period.
Okay. And you cite 3 additional studies to support that statement, right?
Well, I think that you have highlighted here, motherhood in general appears to be a protective factor in terms of reducing self-harm, suicidal ideation, and mortality. However, mental disorders constitute a well-established major risk factor for self-harm. and may add to the complexity of risk evaluation for suicidal and self-harming behavior in new mothers.
Right.
So I think it's important that we take the whole thing in context.
Sure. And you have pointed out earlier, have you not, that mental health issues can arise at any given period in a person's life. It's not unique to pregnancy or post-pregnancy or anything like that, right?
Absolutely.
Okay. So let's talk about another effect of mental illness that you mentioned earlier, and that is the concern that you express at paragraph 40 that untreated postpartum psychosis can lead to infanticide. Do you recall making that statement?
Yes.
And in fact, why don't we pull that up? It's paragraph 40. And if we look at that paragraph, you don't cite any data about the percentage of cases in which that very tragic event happens, do you?
Not right there. I did not cite a source there, correct, sir.
Okay, and can you think of any sources off the top of your head that reach a different conclusion?
A different conclusion.
I'm sorry, can you think of any sources off the top of your head that look at the percentage of cases in which an infanticide occurs as a result of depression after, either during or after pregnancy?
Yes, there are multiple published data looking at the risk of infanticide, which thankfully is also rare.
Okay, and in fact, O'Hara in his article describes that kind of occurrence as rare. So he agrees with you, right?
We are on agreement that
Okay.
infanticide is thankfully rare, yes.
So isn't it a fact that a child is more likely to survive if her mother suffers from postpartum psychosis than if her mother chooses abortion?
I don't have any data to link those two statements.
You think
sir.
a child can survive an abortion?
No, a child does not survive an abortion.
Okay. But many children whose mothers have postpartum depression survive that unfortunate occurrence, right?
Yes, and some do not.
Okay. And you said in your report that it's common for people who experience a mental health episode to lose their employment. You recall saying that?
Yes.
And yet, isn't it true that a child is more likely to survive if her mother becomes unemployed than if her mother chooses abortion?
I don't think I can link those two statements, sir.
Why can't you link them?
Well, I think most women do not end their life by suicide. And I think your point, I believe, is, and your question is, does anyone survive an abortion? Does the fetus survive an abortion? Is that the question?
No, my question was, what are the odds of surviving an abortion versus surviving some other unfortunate circumstance in a mother's life? And the child never survives the abortion, right?
Mm-hmm.
Now, let's talk a little bit about your criticisms of Dr. Coleman. In your rebuttal affidavit, at paragraph 2, you say, as you have a couple of times today, that the American Psychiatric Association has concluded that abortion does not adversely affect mental health. Correct?
Mm-hmm.
And you need to say yes or no, just so the court reporter can get that down?
Yes.
Thanks.
And you agree with that assessment?
Correct.
And but the only citation you provide from the American Psychiatric Association is a policy statement and not a scientific review or study. Isn't that correct?
The statement is the policy statement by the American Psychiatric Association.
So why don't we call that up, and that will be a new defendant's exhibit. Defendant exhibit 614.
Thank you.
Thank you, sir.
I'd like to direct your attention to the second paragraph of this document that is called the APA position. Could you read that paragraph for us, please?
Yes. The American Psychiatric Association opposes all constitutional amendments, legislation, and regulations curtailing family planning and abortion services to any segment of the population.
And as you understand it, is that the position of the American Psychiatric Association?
I believe that, yes, sir, that is.
And do you agree with that as well, as a member of that organization?
I am in agreement with the position by the American Psychiatric Association, yes.
Okay. And the APA, the American Psychological Association, has a similar view on abortion, right?
They have a similar position statement, I believe, sir, yes.
Okay. And you cited their task force report in your rebuttal at paragraph 2. And do you recall whether the APA task force report performed a meta-analysis or otherwise quantified the studies in that 2008 report?
I think I need to look at it, sir.
Okay, let's call it up. It's plaintiff's 110. Does this refresh your recollection of what they did?
This is their 2008 task force
Correct.
report
And the question is, do you recall their having performed?
to be able to determine.
Okay, but you relied on it in your report, right?
I did.
And sitting here today, you don't recall they're conducting a meta-analysis, I gather.
I would need to look at it again.
Okay. And to your knowledge, did the task force that created this report, did it select its studies based on sample size and representativeness and type of design and employment of control techniques and those kinds of methods that go into a statistically sound social science study?
I would certainly hope so.
Okay, but you don't recall their having done that?
I would need to actually, if you would be kind enough to bring up the full report that I could look at, I'd
We're
be happy
not-
to take a look at it.
I don't think we're going to have time to let you go through the whole report, but your counsel can get into that if they want. Now, the task force, if we look at page 68, the task force explicitly rested its final conclusion on the lack of an association between abortion and adverse mental health outcomes on a single study by a researcher by the name of Dr. Gilchrist. It's page 68, the first paragraph. Actually, let's look at page 90 in the first paragraph on the right-hand column. So they cite the Gilchrist study there early in the report, and then later on, when they're stating their conclusion on page 90, on the right-hand column, the right-hand top paragraph, they say, in the view of the task force, the best scientific evidence indicates that the relative risk of mental health problems among adult women who have an unplanned pregnancy is no greater than if they have an elective first trimester abortion than if they deliver that pregnancy. You see that in the report?
I do, sir.
And the only study cited.
Before you go any further, yes, ma'am.
May I just offer Dr. Samantha Wesselberdy the copy of this study so she can look at it in hard copy?
Do you have any objection to having our witness have the study?
I'm not going to ask her any more questions about it, but I have no objection if she has it.
Ms. Zacharias, you can deliver it to her. Sounds like we're about done with it, but
Thank you.
you had another question about the highlighted text.
Yes, and my only question is, isn't it true that the only source they cite there for that central claim is the Gilchrist study?
So as you can see, it's an extremely long report, which is why I wanted to have a chance to look at it. they go through all the different studies. And I believe did an exhaustive search. And they said that there's numerous methodologic flaws in most of the published literature. That's the one that they pull out as they think having the strongest scientific methodology.
Meaning Gilchrist.
Yes, sir.
Right. And that's the only one on which they rely in this paragraph. Isn't that correct?
They call it the best scientific evidence. Yes.
Okay. And let's see. Now you cited at paragraph 3 of your report some other criticisms of some specific criticisms of Dr. Coleman's meta-analysis, right? You recall that? Maybe we can call up the report.
Yes, sir.
But isn't it true that the only peer-reviewed source that you cited here was an article by Dr. Steinberg? The article that was published in a periodical called Contraception?
That was the article that we chose to cite. Yes, sir.
Right, because that was the only peer-reviewed article, right? Now, let's look at a statement from Contraception's website. And this will also be a new exhibit number.
Thank you.
Thank you.
And can you read just the first sentence of the second paragraph there?
Yes. The journal Contraception wishes to advance reproductive health through the rapid publication of the best and most interesting new scholarship regarding contraception and related fields such as abortion.
Okay, so it's a journal focused on reproductive health issues, right?
Yes.
And another defense exhibit will be another statement from the Contraception website.
Cute.
Thank you.
And could you read for us the first paragraph of that? And this will be defense exhibit what? 616, it sounds like.
You want me to read
just the first paragraph on that website?
Contraception, an international reproductive health journal published by Elsevier, is the official journal of the society.
Okay, so that is the official journal of the Society of Family Planning, right?
I think so.
Okay. And we'll have another defense exhibit, I guess number 117, from the Society of Family Planning. This is from their website. Can you read the one paragraph at the top of the page there?
So the Society of Family Planning, on their website, we believe in just and equitable abortion and contraception informed by science.
Okay, so is it fair to say from those statements that the society and their magazine, Contraception, generally take a pro-choice viewpoint towards abortion?
I believe that they believe in, as they say here, equitable abortion and contraception informed by science.
Okay.
I think that's their viewpoint.
And is it fair to say that they are identifying themselves as advocates for those positions?
I think that their statement here says they believe in just and equitable abortion and contraception informed by science.
Okay. And Dr. Steinberg didn't publish her own meta-analysis, right? Are you aware of Dr. Steinberg's having ever published her own meta-analysis of the literature on the link or the potential linkage between abortion and mental health?
I don't think she did.
Okay. And are you aware of any other critics of Dr. Coleman's analysis, meta-analysis, having published their own meta-analysis?
No, sir.
And are you aware of anybody else who published a meta-analysis in the wake of Dr. Coleman's meta-analysis?
I don't believe another meta-analysis and that has been done.
Well, let's look at another defense exhibit. This is an article by Dr. Ferguson from, actually, let's start with the one from 2011. And this will be, I guess, defense exhibit 118. 618. Sorry, 618. Are you familiar with this piece by Dr. Ferguson?
Yes, I am, sir.
Okay. And he writes in support of Dr. Coleman's meta-analysis, right?
Yes, he does.
Okay. And then, and this will be defense exhibit 619. Do you recall, does this refresh your recollection of another study that, or another paper that Dr. Ferguson wrote on the same subject
Yes, sir.
in 2013?
Yes.
And in that paper, he also does what you might call an additional meta-analysis. Isn't that fair?
Yes, I think that if you go back to the page before, can we go back to the previous thing where we have here? David Ferguson's work, yes, sir, this is what he has published. But this first page here, it also goes on to say a letter by Louise Howard and colleagues, which has Louise Howard's work and others have dismissed. He's criticizing that, but they have been very critical. This is the reproductive psychiatry community on the articles and the quality of the articles that are included in these reviews.
And is it fair to say that he's criticizing the critics of Dr. Coleman?
Louise Howard is criticizing David Ferguson's work.
Well, you can look at this later, but he's clearly.
He concludes here, there's no available evidence to suggest that abortion has a therapeutic effect in reducing the mental health risks of unwanted or unintended pregnancy.
I'm sorry, where are you leading from?
Right from the screen here, the conclusions.
Yeah, okay, so that's the next article, the 2013 article, right? And so he concludes there, as you read, that there's no available evidence to suggest that abortion has therapeutic effects in reducing the mental health risks of unwanted or unintended pregnancy, right?
Yes, and I think that the challenge really all of this literature can be summed up by what's in the American Psychological Large Report here, which was done. And I think they did an exhaustive review as the governing body of all psychologists in the United States. And they said, does abortion cause harm to a woman's mental health? Because that's really the question at hand. And their point of view is that this question is not scientifically testable as stated. And the reason is that you can't conduct double-blind experiments one way or another. So fundamentally, you're trying to look at meta-analysis and previous literature. And I think that people can write these papers often with a very particular point of view. I think we started the day with the statement that this is a very complex area and there's a lot of emotions that run high on both sides with that. But I think ultimately, I don't think that there's going to be one paper that's going to get to the bottom of it in the way that anyone would hope on whether abortion scientifically and through double-blind placebo-controlled trials refutes it one way or another, because you're just not able to ever conduct that type of study.
Okay, so it sounds like you believe the evidence on the question of the association between abortion and mental health is inconclusive at this point. Is that fair?
Yes, I believe that the inconclusive or the overwhelming literature, and the fact that I actually do believe in the statements of the scientific bodies. So I actually have great faith as a board certified psychiatrist in my governing body, in the American Psychological Association, in the Royal College of Psychiatrists, in the National Academy of Medicine and Science and Technology, and in ACOG, that there is no evidence that points to abortion worsening mental health. So that is where I land, sir. And then as a reproductive psychiatrist, as we talked about, my job is just to do my very best to take care of the mental health of the women that come to me for care during pregnancy or postpartum.
Of course, and you don't think that any of those organizations that you just cited, you don't think any of those organizations are subject to political pressure?
I think we're all subject to political pressure, sir. It's sort of impossible not to be subject to political pressure of any kind if you're alive.
And you don't think that any of those organizations at least take into account the economic interests of their members?
I couldn't comment for that. I don't work for any of those organizations, sir.
But that's not inconceivable to you.
I couldn't comment for any of those organizations. I don't work for any of those organizations.
Thank you. No further questions.
Ms. Zacharias, any redirect?
No, Your Honor.
Okay. Dr. Meltzer-Brody, thank you. You're not going to miss your flight, are you? Okay.
Thank you. And I did have a fantastic time twice when I was in Ireland, which is definitely not in the UK.
It is not.
And in fact,
my goodness.
No, I went to, it's definitely not in the UK.
Scotland might question you saying it's in the UK as well, but they haven't figured that one out yet. Thank you. So Ms. Stone, Ms. Kay, how do you want to proceed? It's 5:20. I'm betting we can't get through your fact witness before we have to.
Well, Your Honor, I only have 20 minutes of direct testimony, so
Well, if they want to ask 10 seconds of cross, we're not going to have enough time for it. So if they weren't planning on cross-examining the fact witness, right, who would be handling, this is, Ms. Nesmith? Nesmith, okay. That'd be you.
Yes, Your Honor. We do plan to do cross-examination.
Okay, then we need to plan to stop. Because I don't want to, plan B, option B would be to have just the direct before we stop for the day. But if then Ms. Nesmith couldn't be back till tomorrow afternoon, choppy, and it's peculiar to do it that way. So I think what we ought to do is stop. Let me tell you where everyone is. Plaintiffs, you have 3 hours, 29 minutes and some change remaining. Defense, you have 2 hours and 47 minutes and some change remaining. Now, everyone can have more time if those clocks run out and there's more time left, but that was giving both sides 6 hours. So.
But I just raised one housekeeping.
You can in a minute. I just wanted to make sure we had a plan. So we won't get Ms. Nesmith on the stand now. You would have a witness to go first thing tomorrow morning, or should we be turning to defense witnesses first thing in the morning?
Dr. Bedell will be here to testify first thing in the morning.
Okay, great. Even says in my little notes here, testifying on Tuesday, question mark? All right, so Dr. Bedell. And then that would be, you have 2 witnesses left, Dr. Bedell and Ms. Nesmith. Okay. Anything else from plaintiffs before we go off the record for the day? Mr. Chair.
I just need to move the admission of the exhibits that I offered.
Any objection? There she is, Ms. Zacharias, all right. I stopped keeping track because it got a little confusing to me as to which was already in and which wasn't. And sometimes you hung a number on it, sometimes you didn't. So you may, after we break for the day, want to confer with plaintiffs to make sure everything you meant to get in, got in. I heard no objections to any of it, so it's all in. But you'll just need to make sure the right numbers are affixed. So the record is clear. And I guess you, Mr. Scher, need to have your witnesses ready to go mid-morning tomorrow, because we'll only get through Dr. Bedell, I think, and then the plaintiffs will pause, and you'll move forward with your witnesses. And then I don't know what you've agreed to, if the defendant will get through all its witnesses before we get Ms. Nesmith on the stand, or if she's just going to insert partway through.
Well, that was going to be one of our questions for you, was how late you might be, what your plan for tomorrow is, because I think she's working until late afternoon. I think early to mid-afternoon. So getting here mid to late afternoon.
So we can go till about the same time tomorrow. And then we'll need to stop as forecast when we met before. So these timeframes shouldn't be surprising anyway. They may be disappointing people, but they shouldn't be surprising people. So assume we can go till about 5:30-ish tomorrow. So I don't know what the work schedule is. I don't know how you're going to work it out with the defense if they're still putting on their case and they're running out of time, how you're going to do that. I guess technically we wouldn't have gotten to their case if you hadn't rested, as far as we put that. And I want to reiterate something that I explained, not today, but in one of our pretrial conferences. If we get to 5:30 tomorrow and the two sides aren't done with their presentation of evidence, we'll need to meet again. These were the 2 consecutive days I could find in my schedule that were soon, but not too soon. And so if both sides agree that we're just not done and there needs to be more evidence in the record, we'll need to find another partial day soon to get the rest of the evidence in the record. But our stretch goal was to try to get it in by close of business tomorrow. The only other thing I can tell you about tomorrow is that our lunch break will need to be around 1, because I have a Zoom thing at 1 that I'll keep only as I will get off it when our lunch break is over, but I'm going to want to break for lunch around 1 so that I can do this other thing. I think that's it. Anything else from plaintiffs? No? Mr. Chair, anything else? Great. Well, thank you all for a long day. Will we have stenographer April back tomorrow, or were you here only today?
I'm not sure yet, Your Honor, but I would like to remind all counsel present, I have not received anything.
You didn't get names and serial numbers and everything yet?
No,
Okay.
no, nothing.
Well, shame on the two sides. You should charge them an extra $50.
I think they've been
I'll
a
get-
little busy, so I'll let it pass. I just wanted to give a friendly reminder.
I will, I've got your email up right now. I won't say it out over the record, but I'll make sure it gets to both sides if they don't already have it. And before someone goes to bed tonight from each side, they'll get you all those lawyers' names, because there's a lot of them.
I appreciate that, Your Honor. Thank you for having me.
All right, thanks for your help. We'll go off the record now.
One other thing, Your Honor, doesn't need to be on.
We're off the record.
Yes, sir.
Can we leave